All right. Looks like we're Soupy. Thank you so much. Looks like we are live, and welcome everyone to the committee hearing for the Joint Standing Committee on the Judiciary. This morning, we're going to have hearings on two bills. The first is LD 1696, and that is a recodification of Maine's Protection from Abuse Act. And then the second bill is a resolve by Representative Reckett, which is LD 344, constitutional resolution regarding the Equal Rights Amendment. And we will work on the protection from abuse recodification from now until whenever we're done, and then start the Equal Rights Amendment at noon. Before we get started, I just wanted to make one brief announcement, which is that last Thursday when we met, we voted to ask our committee analyst to work on legislation that we could report out on the probate commission study. And that those votes, I mistakenly thought they had to be in by noon yesterday. That rule doesn't apply to the type of vote we took on Thursday. And so I just wanted to alert anybody who had not yet voted on that they can vote until noon today. And then at that point, we'll just have to close the vote and move forward. But I just wanted to alert committee members to that. And with that, are there any other announcements before we get started? Not seeing any. Okay, so we'll start with committee introductions. And I am just going to call on people according to our voting sheet, starting with you, Senator Keim.
Good morning, everyone. Nice to see you all. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County and two communities in Androscoggin.
Representative Babbage.
Thank you, Senator Carney. Good morning, everyone. My name is Christopher Babbage. I'm the House Representative for District 8, which is part of the town of Kennebunk.
And Representative Reckett.
Morning. My name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty. I represent House District 45, which is my hometown of Cumberland and the southern part of Gray.
Thank you. And Representative Sheehan.
Thanks, Madam Chair, and good morning, everyone. I'm Erin Sheehan, and I represent House District 12, which is part of Biddeford.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Evangelos.
Thank you, Madam Chair. Representative Jeffrey Evangelos, House District 91, and I live in Friendship.
And Representative Newell.
Thank you, Madam Chair. Good morning, everyone. My name is Rena Newell, and I represent the Passamaquoddy tribe.
Thank you, everyone. And we're joined this morning by our committee clerk, Susan Panett, and our OPLA analyst, Peggy Reinsch. And I am Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And so without further ado, we'll open the public hearing on LD 1696. And that is being presented by Senator Donna Bailey. And I don't know if I'm empowered to bring her onto the panel, but I'm going to try. I am not. Soupy or Peggy, could you please bring Senator Bailey onto the panel?
Yes, I just tried.
Oh, wonderful. Thank you.
There she is.
And magically, she has appeared. Good morning, Senator Bailey, and welcome to your old committee, the Joint Standing Committee on Judiciary. We know you don't have the ability to bring treats to us in this virtual format, but your presence is enough of a treat. Welcome, and you can go ahead with presenting 1696.
Thank you, Madam Chair. And believe me, someday I will bring treats. Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. My name is Senator Donna Bailey, and I represent Senate District 31, which is the city of Saco and the towns of Old Orchard Beach, Hollis, Leamington, and part of Buxton. I come before you today to introduce and offer testimony in favor of LD 1696, an act to clarify and recodify Maine's protection from abuse statutes. The genesis of the need for this recodification began for me as a legal practitioner trying to navigate the ever-evolving PFA statutes, and was further solidified during my tenure serving on the Judiciary Committee, both as a member and later as a House Chair. The current PFA statutes have been modified numerous times over the years in a somewhat piecemeal manner, resulting in the current problem to be addressed. The result is a statutory framework that is confusing and unclear at best and incomprehensible at worst. I have even heard judges muse about how difficult the statutes are to navigate. If attorneys and judges sometimes struggle with the statutes, imagine being an unrepresented litigant trying to make sense of it all. As House Chair of the Judiciary Committee, I saw that something needed to be done and reached out to advocates who practice in this area to see if any would be willing to take on the massive project of rewriting the PFA statutes to make them more user-friendly and understandable. Luckily for us, Lucia Como Hunt at Pine Tree Legal and Andrea Mancuso of Maine Coalition to End Domestic Violence heeded my call and took the lead on convening a working group to recodify and restructure our protection from abuse statutes to make them clearer and more accessible to those who need to use them, whether as a litigant, an attorney, a judge, or other advocate. In asking for this project, I made it clear, and the working group stuck by their mission, that there were to be no substantive changes to the law, only a restructuring. The only additions are where there is clear case law interpreting the PFA statute section, then that case law would be incorporated. Those of you who know me know that I'm a longtime advocate of incorporating case law into statute whenever possible, so that everyone has access to the law, not just those in the know, like myself as an attorney. One is more likely to find a statute online when doing a Google search than a line of cases. This, for me, is an access to justice issue. The end product of this effort is the current bill in front of you. The definitions in the PFA statutes are clarified. The reorganization makes the statute functional and is now a logical statutory scheme as opposed to the piecemeal patchwork we presently have. Everyone from the knowledgeable judge to the first-time pro se litigant will be able to understand who is entitled to a PFA and how the statute works. I am thrilled and excited to bring this before you for your approval and consideration, and I can't thank enough the many who worked for over a year on this massive project. Thank you for your time and attention, and I'm more than happy to try and answer any questions you may have.
Thank you very much, Senator Bailey. Committee members, are there any questions for Senator Bailey? Go ahead, Representative Reckitt.
First of all, am I okay?
Yes, we can hear you fine.
Okay.
Thank you.
First of all, Don, I want to thank you, Senator Bailey. I want to thank you so much for initiating this effort. Having worked in this field for a long time, I can testify that the statute has been confusing, particularly to pro se litigants. But I have one overall question, but it's actually the same question in 3 spots on the effort that was made. It's not changes or anything. It's just that I think for me to understand it, it would be helpful if I knew what in general the case, there's 3 cases referenced in your notes, one of which is Smith v. Hawthorne, Shaw v. Packard, and Dyer v. Dyer. What I want is to know is whether or not those case law notations, what in general do they refer to?
And I don't know that off the top of my head. Perhaps others coming after me do have those committed to memory. And if not, I am also thinking that Peggy, during the work session, that I can get that information to her if you don't get that answered before the work session.
That'd be perfectly fine. Thank you.
Thank you.
Thank you both. Representative Moriarty, go ahead.
Thank you, Madam Chair. Senator Bailey, I was just curious to know how many people were on the or part of the working group, and did it include members of the judiciary?
I know that FLAC was involved and consulted. I don't know that a member of the judiciary was involved other than indirectly through FLAC, but I do know that I understand the judiciary will be testifying in favor. So they have reviewed this, and my understanding is that they do support this bill.
That's helpful. Thank you.
Any other questions for the bill sponsor committee members? I'm not seeing any. I did want to point out to everyone that our OPLA analyst Peggy had prepared a chart that compares the bill to the current law and includes notes, including the notes about the case law. Looks like this. I think it was delivered to each of us in person when we were at the State House last week. And I found it a really helpful way to consider the bill. And I just wanted to remind everyone that that's available as a resource, and also to thank Peggy for all the hard work that went into the handout. And so if there are no further questions for Senator Bailey, Senator Bailey, you're welcome to stay on the panel during the testimony if you'd like. Otherwise, I can move you into the attendee space if you prefer.
I would prefer to stay if you don't mind, Madam Chair.
Okay, and we will start with Lucia Hunt, who I will bring over to the panel. And while she's coming over, I did want to let committee members know that we have an option today to move into a work session, not that we would vote on this bill, but if we had questions that we wanted to review with our analyst after presentation of the testimony, we can do that. Okay, welcome very much, Lucia Hunt, to the committee. And we understand you put a lot of work into the recodification of the Protection from Abuse Act. You can proceed with your testimony.
Thank you, Senator Carney, and good morning, chilly morning, members of the Judiciary Committee. My name is Lucia Hunt. I'm Directing Attorney of Family Law and Victim Rights at Pine Tree Legal Assistance, and I'm speaking to you today in support of LD 1696, an act to clarify and recodify Maine's protection from abuse statutes. I would especially like to thank Senator Bailey for her enthusiastic support of this important reorganization of the PFA statutes, in addition to her co-sponsors. Pine Tree supports this reorganization because of our experience litigating PFA cases across the state. We see the challenges every day that the current statute creates, and we support this bill because it will make the statute more accessible and the current law more easily understood by all of the parties in this process. The current PFA statute is really best described like an old Maine farmhouse. There's the original structure, and it's been added onto over the years. So it's difficult to navigate, and it's a little bit confusing in its structure. And then you have this body of case law, which is like an entirely separate outbuilding that has to be read together with the statute in order to understand the current state of the law. So when I bring someone new on board at Pine Tree Legal, I give them not only the PFA statute, I give them a list of cases, and I say, you have to know both of these in order to really litigate these cases effectively in the district court. This bill is going to address some of the most common legal issues that we see in practice with the Protection from Abuse statute, including eligibility, final hearings, and extensions. Eligibility is a particular roadblock for victims of sexual assault, stalking, and elder abuse. Despite those categories of folks being able to file, under the statute for a long period of time, it's the way that the statute is structured means that you have to read 3 different sections together in order to really understand the total group of folks who are eligible under the current statute. The reorganization of those sections into one piece means that all of the provisions that relate to eligibility are now located in one place in the current bill. Another frequently litigated issue is continuing final hearings, which seems like it would be a fairly straightforward issue, but the current statute says really clearly that final hearings have to be scheduled within 21 days. And then we have case law from back in 2005 that makes it really clear the court has discretion to grant a continuance of a final hearing if there's substantial reasons presented by either party that support the granting of that continuance. And it's often defendants who've been served just a few days before a hearing who are requesting those continuances. In the bill, the language from the case allowing continuances is taken right from the case law and placed directly into the statute. And that is the Shaw versus Packard case from 2005, just to answer Representative Galgay-Reckitt's earlier question. Extension of final orders similarly has been interpreted and explained by the law court. And so the proposed bill incorporates those concepts directly into the statute. LD 1696 will make the statute easier to read and will help all parties understand the law that governs protection orders. And for those reasons, I urge you to support this important reorganization and clarification of the PFA statute. And I'm certainly happy to answer any questions.
Thank you very much. Committee members, are there any questions for Lucia Hunt? All right, I am not seeing any. Thank you very much for your testimony today, and I'll move you back to the attendee space in just a moment. And our next testifier will be Andrea Mancuso. Welcome, Andrea Mancuso, to the Judiciary Committee. Want to express us again our thanks for your work on this matter, and you can proceed with your testimony.
Thanks so much. Good morning, Senator Carney, members of the Judiciary Committee. My name is Andrea Mancuso. I'm here today on behalf of the Maine Coalition to End Domestic Violence in support of LD 1696. There are many reasons why this recodification is necessary. Some you've heard of, some others are highlighted in my written testimony. But my role this morning is to talk to you about the process that resulted in the bill that you have before you. As Senator Bailey mentioned, during the 129th legislature, members of the Judiciary Committee in a work session on a PFA bill noted pretty much around the horseshoe that the committee would like to see a recodification to make it more accessible to the average person. And Senator Bailey followed up and made that specific request. So over the last 18 months, several stakeholders whose work is steeped in this chapter of law have worked on that recodification, and that's the bill before you. One of the first actions we took as a small drafting team was to acknowledge a need for technical assistance around the process of recodification, how best to track the reorganization work as a practical matter as we were going along, and a refresher on the rules for statutory construction. We had the benefit of consultation early on in the process from staff at the University of Maine School of Law with recodification experience, as well as from the committee's incomparable analyst. After putting together a comprehensive first draft, we did several line-by-line reviews of the draft with practitioners from Pine Tree Legal Assistance, the Cumberland Legal Aid Clinic, Legal Services for the Elderly, staff attorneys from the Domestic Violence Resource Centers, the Office of the Maine Attorney General, all stakeholders who are really steeped in this law. These conversations helped ensure that the various pieces of case law that needed to be incorporated were that language in the PFA statute that needed to be updated to align with where those terms are used in other titles was accomplished, and also to double and triple check us that the recodification, in fact, did not work any substantive changes to the law. So through this process, we had the benefit of more than 20 attorneys with high levels of expertise in this chapter providing input and feedback. We were also fortunate at several points along the way to have been able to consult with leadership from the Family Division of the Administrative Office of the Courts. Once that initial round of feedback was incorporated and we had an even better draft, we shared the draft with the Family Law Advisory Commission, and feedback from FLAC's detailed review was incorporated. And then a subsequent draft was sent to the Maine Commission on Domestic and Sexual Abuse for their review and feedback before the final version was forwarded to the revisor's office for polishing. And of course, all of those collaborators have since had an opportunity to review the final LD and prepare remarks for you this morning. Just a note, the recodification effort would not have been possible without the assistance of Peggy Reich from OPLA. Peggy made herself available for consultation at each step of the process to ensure that we were able to give you a good product, and we are so grateful for her generosity with her time and expertise. We're confident that what you have before you is worthy of support. It really does provide a structural reset, continuing to provide the critical safety and stability to survivors who need emergency court orders, while also better attending to due process and basic fairness to all litigants and practitioners who are going through this process. Thank you for the opportunity to share some of this information with you this morning, and happy to answer any questions.
Thank you very much. Committee members, are there any questions for Andrea Mancuso? Go ahead, Representative Newell.
Thank you, Madam Chair. Good morning, Andrea. Thanks for being here.
Good morning.
Thank you for the explanation in regards to the process. And just reviewing the comparison with the current law that we so generously received from Peggy. I know that there's references to the Passamaquoddy tribe and the Penobscot Nation Tribal Court. So as you explained the process as to who was represented in compiling this over the last 18 months, I came to raised the question of whether or not there was any representation from the courts of the Passamaquoddy tribe or the Penobscot Nation and or its attorneys.
So we shared the draft. Thank you for that. There is some updated language about the tribes in LD 1696. We initially had some feedback from Laura Ustak on where to pull some of that language from to make sure that how we're referring to courts and tribal courts is consistent across multiple titles. And in taking the review to the Abuse Commission, where several tribal representatives sit, we had specifically asked to make sure that they were able to provide any feedback on any of those portions. And I know Lucia has done some additional work and conversations with the tribal courts, specifically around their PFA process as well, and discussing that this parallel process was happening at the same time.
Thank you.
Committee members, any additional questions? I am not seeing any. Thank you once again for your testimony today.
Thank you very much.
And we'll next be joined by Elizabeth Ward Saxel, and it's just going to take me a moment to move her here.
Good morning.
Good morning, Elizabeth Ward Saxel. Welcome to the Judiciary Committee.
Lovely to be here. Thank you, Senator Carney, members of the committee. My name is Elizabeth Ward Saxel. I'm here on behalf of the Maine Coalition Against Sexual Assault, which represents and serves Maine sexual assault support centers. I'm here today in strong favor of LD 1696, and with many thanks to Senator Bailey for her many hours of work to bring this to committee. Each year, 14,000 Mainers will experience sexual violence. Yet of those 14,000 Mainers, fewer than 5% will make a report to law enforcement. And so one of the only paths to justice and safety for the thousands of remaining survivors is accessing civil protections. The good news is that over the last 15 years, this committee, your committee, has carefully crafted several critical statutes which have increased victim safety and their ability to thrive, starting with allowing victims of sexual violence to seek protection orders, regardless of whether or not the sexual assault occurred within the context of domestic violence. However, as you've heard, the old farmhouse, which is our protection from abuse statute, is very difficult to navigate. Even with the support of Pine Tree Legal Assistance attorneys who represent sexual assault survivors across our state every day, the path is far from straight, with many system players still confused about what remedies are available to sexual assault victims. And those are the survivors who are fortunate enough to have PTLA's expertise behind them. But the vast majority of those seeking PFAs do not have the benefit of legal counsel. They are left to try and work their way through the statute and are unlikely, as you've heard, to have access to the case law, which plays such a central role in these cases. As a result is that many victims of sexual violence do not receive the protections to which they're entitled, not because the protections don't exist or because they're not eligible, but because the statute is too hard to understand. The complexity of the statute actually sometimes benefits those survivors who are being represented by PTLA, as opposing counsel often does not have as strong of a grasp on the law and case law. Yet another reason to make this statute more accessible. We're deeply grateful for the many, many hours of work put in by Lucia Shomo-Hunt and Melissa Martin from PTLA and Andrea Mancuso from the Maine Coalition to End Domestic Violence to reorganize this statute. Pretty much everyone in the field is tired of me hearing me talk about this bill. I am overly enthusiastic about it. I tried to tamp down my excitement this morning, but I just can't resist telling everyone what a thing of beauty it is. The drafters, as you've heard, consulted with many other experts in the field, they being some of the greatest experts in the field on the statute already, and were vigilant about not making any substantive changes, even under pressure from allies advocating for important statutory improvements. The remarkable product of their work will result in increased access to justice for all involved with these cases, from those seeking PFAs to those opposing them, those who have representation and those who are representing themselves. As a result, I would strongly urge you to support this bill and would be pleased to try and answer any questions you might have.
Thank you. Committee members, are there any questions? I'm not seeing any, but I actually did have a question for you. You described the disadvantage to both parties seeking protection and defendants that arise from the current old farmhouse state of the act. Could you give us a real life example of that, please?
Sure, although I think I would prefer to defer to those who are actually representing folks in court. But I am privy to information from the conversations among the folks who worked on recodifying the bill, where they acknowledged right now they're at an advantage. That in court, oftentimes they've got a really solid handle on that case law, and opposing counsel doesn't. So I'm sure Lucia Shomo-Hunt in particular can provide some real life examples, but it's something that I know we're aware that we'd be maybe losing a little ground in some situations in terms of seeking PFAs for victim survivors, but clearly it's in the interest of access to justice to have a level playing field, which it is not right now.
Thank you very much. Committee members, any other questions? Not seeing any, we'll send you back to the attendee space. And next we'll be joined by Leo Delicata.
Good morning. Thank you,
Senator
Senator.
Welcome.
Thank you very much. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly, and I'm happy to speak today in support of this wonderful piece of legislation. Again, I don't want to read my entire testimony. Some of it will repeat what you've already heard, but the purpose, let me just tell you that these cases involving this statute are some of the most satisfying things that we do. We represent people who've had a tremendous amount of trauma, and we're able to get them some immediate relief with a protection from abuse order. I wanted to say three things about it. And what I'm going to say is give you three examples of how the reorganized language will improve our use of the law for our clients. The first is that the proposed eligibility section, beginning on page 3 of the LD, repeats, but it repositions existing language that it makes it clear that an elder can get a protection from abuse order against an extended family member, even if that extended family member has never lived with them or the person was or is an unpaid caregiver to the elder. Presently, this language is often overlooked because it's located at the end of a very dense paragraph of one of the sections of the current law. This recodification will now highlight it, so nobody will miss the opportunity. Second, and in similar fashion, the relief section, which begins on page 10 of the LD, is reorganized and simplified. Among other improvements, these changes highlight the court's ability to make a finding of economic abuse. This finding allows the court to order the perpetrator to repay the victim for any financial harm caused by the perpetrator's bad behavior. For example, the court may order an abuser to repay a debt created on a victim's credit card. Again, this is not a substantive change, but it's a welcome rewrite because oftentimes the fact that you can get an order for economic abuse is not known. It's not picked up sometimes even by judges. The third and the last example is not primarily a repositioning or a clarification of language. It's a change that includes updated language that reflects Maine Supreme Court decisions whose holdings are currently not found in the Protection from Abuse statute. Section 4111, which is entitled Modifying and Extending Orders, found on page 13 of the LD, includes factors that must be considered by the court when determining whether to extend a protection from abuse order beyond its original date. These standards were enunciated by the Maine Supreme Court in 4 cases, but were not subsequently reflected in amendments to the PFA statute. As a result, the complete law applicable to the extension of court orders is now found in 2 different places: the Maine Supreme Court decisions and a section of the PFA statutes. This is inconvenient at best and confusing at worst. This change will ensure that everyone is aware of what the law provides. Now, what I've done on the last page of my testimony, actually beginning on page 2 at the bottom and continuing, is to give you a before and after demonstration of how the proposed language will change the current expression pertaining to the extension of an protection from abuse order. First, I set out in 2 subsections of the current statute the particular section that gets rewritten, and then I attach the rewritten piece. And I've also included footnotes and highlighted them in yellow. And in the footnotes, I put the names of the cases that correspond to the particular changes in that section, the new section, that really connect the language, the new language, with the case law. So I hope that's helpful. I appreciate the effort that everyone has made in doing this incredibly large piece of work. And I think it will, as people have already said, benefit everyone who needs this remedy, and will make it easier not only for practitioners and judges to understand, but also give the public a real chance to know what their options are. Thank you.
Thank you very much. And a special thanks for giving us a real life example. We appreciate that a lot. Committee members, are there any questions for Leo Delicata? I'm not seeing any. Thanks for all your contributions to this legislation.
Thank you.
And next we'll hear from Rebecca Austin. Welcome, Rebecca Austin, to the Judiciary Committee. You can proceed when you're ready.
Thank you. Thank you, Senator Carney and members of the Committee on the Judiciary. My name is Rebecca Austin, and I'm the Director of Advocacy, Intervention, and Prevention Services at Safe Voices, which is the Domestic Violence Resource Center serving Androscoggin, Franklin, and Oxford counties. I am also a member of the Maine Commission on Domestic and Sexual Abuse. I'm here today speaking on behalf of the Commission in support of LD 1696. The Commission is comprised of sworn law enforcement, attorneys, advocates, survivors, representatives from within state and tribal government, and a judicial advisory member. The Commission is tasked by statute with advising and assisting the executive, legislative, and judicial branches of state government on issues related to domestic and sexual abuse. Since the Commission's creation more than 2 decades ago, the Protection from Abuse Order statute and process has been one of our core areas of focus, and it serves as a cornerstone of Maine's response to those experiencing domestic and sexual abuse and violence. Almost every Maine legislature over the last 20 years has played a role in moving forward important modifications and additions to the Protection from Abuse statute to ensure that it continues to align with our understanding of how best to ensure Maine's ability to provide effective protections for some of our most vulnerable communities. LD 1696 continues that tradition by putting forth an important non-substantive reorganization of the statute that better accounts for the reality of the vast majority of litigants who are engaging in this process. Both plaintiffs and defendants are doing so largely without the benefit of an attorney. This reorganization has been needed for a long time, and for all the reasons that you will hear from others today, the most important of which is that it improves transparency and the equity of access for all litigants, as well as for professionals who might be helping them. The Commission strongly supports this proposal, and we do hope that you will as well. And finally, the Commission would like to thank Senator Bailey for providing the opportunity for this project to move forward. Members of the Commission are happy to participate in any way that might be helpful for the Judiciary Committee as you work on this bill in the coming weeks. Thank you.
Thank you very much. Committee members, are there any questions for Rebecca Austin? I am not seeing any. Thank you for your work on this legislation. And next we'll hear from Julia Finn. Welcome.
Good morning. Senator Carney, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch, and it's great to see you all again. I testify in favor of passage of this bill. LD 1696 represents the efforts of many of those who have spoken already this morning, as well as Senator Donna Bailey, and with consultation and review by the Family Law Advisory Commission, also known as FLAC. As you know, FLAC does include judicial officers and other members of the judicial branch. The drafters have described the goals of the bill as follows: to include recent clarifications to the law contained in recent cases decided by the law court, to comport with accepted rules of statutory construction, and to simplify and reorganize the language and structure of the statutes. This is not a substantive change, but rather a clarification of the existing law. Amending the law in the manner described in LD 1696 would constitute concise statutory language is important so that the public can understand the rule of law and the application of it. This is particularly important.
Julie, you froze for a little bit. Can you please go back a couple of sentences? I'm not sure exactly where we lost you, but maybe like 3 or 4 sentences, please.
Sorry about that. It's been kind of spotty for me this morning here on Zoom. So I was just saying that the judicial branch feels that this is an improvement to the law, that it will improve access to justice, particularly for unrepresented litigants, which is a very important goal. And therefore, the judicial branch supports the passage of this bill. One final note, however, is that this bill will require a significant effort to revise all statutory citations in our many internal and forms, publications, clerk instructions, and website content. So we would ask that the bill be given an extended effective date, possibly until January 1st of 2023, if possible. Thank you very much, and I would be happy to answer any questions if you have any.
Thank you so much. Committee members, are there any questions for Julie Finn? I'm not seeing any. Thank you very much for testifying before the committee today.
Thank you.
And thank you for your suggestion regarding an amendment to the effective date. And the next person who signed up in advance to provide favorable testimony is Melissa Martin. Welcome, and you can proceed.
Thank you. Good morning, Senator Carney, Representative Harnett, and members of the Committee on the Judiciary. My name is Melissa Martin, and I am the Legal Services Representative on the Family Law Advisory Commission, aka FLAC. And I'm here speaking on behalf of the Commission in support of LD 1696, an act to clarify and recodify Maine's protection from abuse statute. LD 1696 represents a comprehensive restructuring and clarification of the protection from abuse statute. And FLAC is very supportive of these efforts. FLAC had the opportunity to meet early on and discuss the need for this to be redone and was very supportive of this work happening, and then had several opportunities throughout the drafting to see drafts and to give feedback throughout this process. FLAC believes that LD 1696 is important because it will make the protection from abuse statute easier for courts, for attorneys, and for unrepresented litigants. As you all know, FLAC is comprised of a number of attorneys and judges and other stakeholders. And so in looking at this, FLAC was really thinking comprehensively about how the court system works as a whole for all of these different participants in protection from abuse hearings. So from judges to attorneys to the people who are coming in unrepresented. There are three really important things that LD 1696 does that improves the protection order process for all three of these groups. So one is that currently, and you've sort of heard about this, the old farmhouse example, where right now there are certain sections that to understand, you have to read multiple sections of the statute together. And one of those is the eligibility section, which right now requires cross-referencing 3 different sections of the statute in order to understand all of the different people who are eligible for the protection from abuse statute. That is now clarified and put into one section, which makes it easier for everyone to read and to use. The second is that as this old farmhouse was created, there were a lot of paragraphs throughout the statute, and I think this is really clear in Peggy's side-by-side, where the resulting sections of the statute in the original statute we have now are these huge blocks of text that are almost impossible to read. And they list several things throughout the paragraph, and sometimes you need to read the first part of the paragraph with the last part of the paragraph to understand, and that can be really, really challenging. Where what we've done is really break those down into subsections throughout to make them easier to read. And the last piece that's really important is, and several people have talked to you about this morning, is incorporating that case law. By taking the case law and putting it directly in the statute, that means an attorney who's taking one of these cases pro bono, a new attorney, a new judge can open up that statute book and see that case law reflected directly in the statute without having to know that there's this case law out there, which frankly, unless you're an attorney practicing in this area, you often are not aware of that. That case law is now directly in the statute. For all of these reasons, FLAC supports LD 1696 as an important and necessary recodification because it will benefit courts, attorneys, and unrepresented litigants involved in protection from abuse proceedings. I'm happy to answer any questions at this time.
Thank you very much. Committee members, are there any questions for Melissa Martin? I am not seeing any questions. Thanks once again for your role in bringing this legislation forward. And that takes us through all of the people who signed up in advance to testify in favor of the bill. And at this point, I'm going to speak to those in the attendee space and ask if there's anybody else in the attendee space who would like to testify in favor of the bill. Please raise your electronic hand and leave it raised until I bring you onto the panel. And I'm not seeing anyone in favor. We'll ask for, actually, before we move to those opposed, I did want to give some committee members who joined us after introductions to introduce themselves. Representative Libby, would you like to introduce yourself?
Thank you. I'm Laura Libby. I represent District 64, which is Auburn and Minot. And thank you all for being here today.
Thank you. And Representative Thorne?
Thank you, Madam Chair. I'm working through some technical glitches, the gremlins of the January type. My name is Representative Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in Penobscot County.
Thank you. And now I'll turn back to those in the attendee space and ask if there's anybody who wishes to speak in opposition to LD 1696. If so, please raise your electronic hand and keep it up until I've called on you to testify. I'm not seeing anyone who wishes to speak against. If there's anybody in the attendee space who wishes to speak neither for nor against, please raise your electronic hand. And again, I am not seeing anyone wishing to speak neither for nor against. Before we conclude the hearing, I wanted to ask committee members if they would like the opportunity to move into a work session simply to ask Peggy questions about the work that's been done on this bill, and particularly, guided by the side-by-side handout that she provided to each of us. Can you just let me know, either raise your hand to give feedback, or if you're interested in doing the work session, again, not to vote, but just to discuss, please let me know. Senator Keim, go ahead.
Thank you, Madam Chair. I think it would be helpful. What I would like to do is go through the side by side and have Peggy walk us through the areas of change, most especially the areas where case law has been put into be codified. If now is the appropriate time to do that, then so be it. I would appreciate it.
Okay, thank you. I think it is a good time to do it. And I think it will help us all when we get to the work session where we'll be voting on the legislation. Representative Libby?
Thank you, Madam Chair. I would appreciate the side-by-side comparison as well, though I do need to put out there that I am having significant technical difficulties that I will need to be able to have time to resolve before the noon time public hearing.
Okay. Yeah, it's not quite 10, and I don't think the side-by-side will take a super long time. And also just be aware that watching it on YouTube is an option if your technical difficulties are insurmountable right now. I'm sorry that you're having them. Peggy, okay, so first thing I'll do is end the public hearing on LD 1696. And then open a work session on LD 1696. And Peggy has joined us on screen. And Peggy, we would really appreciate hearing from you regarding the side-by-side. And if you can highlight the questions that Senator Keim raised, we'd appreciate that as well.
Thank you. I'd appreciate that. What was a good thing in putting this side by side together is that there was a lot of give and take with the folks who were putting the bill together. So we kind of recognized what was missing, and or not what was missing, but how to line up the existing law with what was in the bill, or vice versa. And actually, some of those people that have worked on this really have a much better grasp of the case law. And if you don't mind, I would appreciate having them available to answer your questions too in the work session. So I don't know if I know Andrea Mancuso and Lucia Hunt and Melissa Martin do a lot of these cases and are much more fluent about how these apply. So if you could have them available to answer your questions too, that would make it easier for me. But I can get you through a lot of this if you want. So I don't know if you want to bring them over now. They are prepared to answer your questions and explain exactly how they went through, like the eligibility section, if that's useful to you.
Okay, let's bring those three over to the panel now. And then Peggy, if there are points where you think it would be helpful for us to hear from one of them, just please let us know.
All right.
Andrea, Melissa, and
Lucia Hunt.
Okay, thank you.
Not that the others weren't helpful, but I think they were the ones who were doing most of the experience-based work. Would you like me to share the screen of the side-by-side? Is that helpful? Or do you just want to go ahead with it? I'm not sure if everybody has the paper copy of it. I think I sent it to them electronically as well.
Okay, let's do this. If anybody would like Peggy to screen share, raise your hand. And if anybody wants it, we'll do it for everybody. So just raise your physical hand if you'd like screen share.
Okay.
I think giving people the handout worked, Peggy. Thank you.
Great. So I'm going to go pretty fast through this, but stop me when you have a question, because if you're looking at the side-by-side, if you're looking at that chart, you'll realize that, for example, the new section 4101 is almost exactly the same as the existing section 4001, which is the purposes. So subsection 1 is recognition. These are the purposes that the legislature recognized many, many years ago in putting this into statute. Those are being carried over into this new chapter. So all that's the same in 4101 with regard to purposes. And then there are some changes in section 4102, but the changes are in order to make it clear what these terms mean. And I think we've included a new term or moved a definition to someplace else, but they're all existing definitions that kind of you had to sort through the statute to figure out what they mean. So maybe the best one to talk to is about abuse. And if you look at the existing law, you'll see there's a big paragraph that says abuse means the occurrence of the following acts between family or household members or dating partners or by a family or household member. Or so the current law defines abuse in terms of relationships too. So those relationships are maintained, but they are included in the different section dealing with eligibility. So we have a very clear definition of abuse, not kind of cluttered by who's committing it against whom. Here's what the conduct is that is abuse. So if you other than that very first box for subsection 1, you'll see that paragraph A is the same across, and then paragraph B is the same. And I've kind of explained what those cross references are. 17A, chapter 11 is a sexual assaults chapter. There's a cross reference to section 106, which is the use of physical force by persons with special responsibilities. No change. I just put those notes there so you'd understand what that law is. Paragraph B is the same. Paragraph C is the same. It's just been divided into 2 categories, either when that abuse involves engaging in conduct or when it involves abstaining conduct in which the person has a right to engage. So the perpetrator of the abuse is either forcing somebody to do something or stopping somebody from doing something that they have a right to do. So current law, it just broken down so you can understand it. Paragraph D is the same as current law. Paragraph E is the same as current law. Paragraph F, paragraph G, and I just put that's the unauthorized dissemination of certain private images that was grafted onto the Protection from Abuse statute a few years ago. And then in paragraph H is the same. So those are all the different pieces that make up the broad definition of abuse. Any one of those pieces of conduct, those areas of conduct, qualify as abuse. The next definitions, adult, court, dating partners, economic abuse. I will point out that the revisor's office in recodifying the definition of economic abuse just clarified that the stealing from or defrauding was from an individual. And I kind of hope that shows up that I highlighted the word individual about 5 lines from the bottom. But that's not really a change in the definition of economic abuse. So family or household members is a definition that is cross-referenced throughout the statutes for various purposes. And this is one of those paragraphs that I think Elizabeth Ward Saxel mentioned that is a big block and it's kind of hard to decipher. And I think Leo Delicata also mentioned something about how it's hard to pull out these pieces. So the bill pulls out all these individual pieces of who is who makes up a family or a household member. And at the end of that subsection, it says holding oneself out to be a spouse is not necessary to constitute living together as spouses. That is current law. That whole block is current law. What you see highlighted in that middle column of the current law is something that was added a couple of years ago that was saying, okay, for very narrow purposes, we're going to say that individuals presently or formerly living together and individuals who are or were sexual partners qualify as family or household members for only these statutes. So Title 15, 1023, and you'll see those listed there. This is something that we need to actually address. Everybody knew that this needed to be addressed and we kind of fell off our radar. We're going to have to address it in a committee amendment here to probably go in and reference these sections, the Title 15, the Title 17A, to say, to cross-reference family or household members, except not paragraphs F and G. But I just want to flag this as something that is actually a change and that we will need to address, and nobody meant to skip this over, I don't think. In fact, some of the working papers say, oh, don't forget, we need to catch up with this. So this is something that we will have to address in a committee amendment. And we'll break down each of those sections of statute.
Just one moment, Peggy.
Yeah.
I think that Senator Keim has a question. Go ahead, Senator.
Thank you. So Peggy, you're saying that there is a change here, or you're just saying that we simply need to cross-reference it and it hasn't yet been done. I guess I heard you say that this is a change, but then I lost track of what the change was.
It's an inadvertent change because what the language that's highlighted in that middle column says is we're expanding the definition of family or household members to include individuals presently or formerly living together and individuals who are or were sexual partners, which are now paragraphs F and G in that left column, only for the purposes, not for every time we talk about family or household members, but only for the purposes. We're including them when we say family or household members in these sections. So Title 15, 1023, I think that's a bail, that might be a bail code. Those Title 17 sections, warrants, and those are different domestic violence crimes. And some, I think those are victims, 1802, 1804. I'm sorry, I'm going to have to look those up specifically. But right now, the law says when you say family or household member, and it's you're talking about it in any of these sections that are highlighted, we are including individuals presently or formerly living together and individuals who are or were sexual partners. There are actually a few sections in the statutes that cross-reference the definition of family or household member that are not in this group. And so what the law means right now is F and G are not included in the meaning of family or household member when those statutes are applied. So what we need to do is make sure we go through and catch any other reference to family or a household member that's not here, to make sure it doesn't include F or G, unless the legislature goes through the process of saying, oh yeah, actually we do want that to apply. But that's a completely different question. But this also raises the question of cross-references. If you look at the very end of the bill, there's a section, because this was drafted in the first regular session, that directs the revisor's office to go through and catch all the cross-references to the what's existing chapter 101 and make it to the new chapter. We'll probably have to do that in the committee amendment. We have a list, we're able to do that. It's just gonna take some paper and a little bit of time. It's not a huge research project for us, but we should probably do this in this bill as part of the committee amendment. So in that process, because those sections of the law that cross-reference family or household member will be in that list of cross-references, we can very easily pick them out and do a quick cross-reference to make sure we are not changing the effect of the law. So yes, it's different. This section is actually different than current law. It was inadvertent. We have the opportunity to go and fix it very quickly.
Thank you.
Yeah, thank you. And thanks for the clarifying question.
Yeah, that's just a really thorny piece that we were going to get back to and we didn't. If you remember what April was like last year. Law enforcement agency, this is one of the updated definitions to make it clear what a law enforcement agency covers. State, county, tribal, municipal, or University of Maine system law enforcement agency. That is actually the definition that's used in the Uniform Crime Reporting Law. And if you go through the statutes, there are various definitions of law enforcement agency. But this is the one that seems to work in all situations. This is also one that the Attorney General's office recommended that we use. So the next one you'll see.
Did you have another question? Go ahead.
I do. I think I need to understand. So it seems that the definition here is an expansion to now include the University of Maine system, whereas before this would not have applied to them. Is that correct?
It looks that way, but I think that they actually, they do apply this law now, even though it's not defined. They're not part of that definition, but they feel that it applies to them. So, you know, technically, yeah, that might be a change, but as the law works, my understanding is that they act as if it does apply to them explicitly. I don't know if anybody else here can respond to that in a different way.
Go ahead, Andrea.
The feedback that we got with through the review with the Office of the Maine Attorney General was that in multiple areas of code, that the University of Maine system law enforcement, when it says a municipal law enforcement agency, they will actually interpret that as applying to them. So for sake of clarity, it was recommended that really when we refer to law enforcement agency anywhere in statute, that it use the Title 25 definition of it so that it actually melds in practice with how these laws have been interpreted across the board.
Okay, thank you.
Yeah, thank you. And I think that's something we can reach out to the University of Maine system and get more information directly from them as well.
So, ready to go on? Okay, the next one is mutual order of protection or restraint. This is no longer being defined in the definition section, but the actual definition itself is in the section later on, dealing with what's prohibited. The mutual order of protection or restraint has been prohibited for years and years and years. And that shows up in section 4110, and I'm trying to get you a page number. Too many pages. That's a long section.
Lucia Hunt, go ahead.
Thank you. I just want to add that this is one of those places where, you know, two different things had to be looked at and you had to know where they were in order to actually understand what this means. So this is another great example of a place where in practice, we would consistently have long discussions, you know, about what this meant and how to understand it. And so by putting them together without changing even the wording, just pushing them into the same section, it's another example of how we located things that needed to be read together to be understood in one place.
Thank you. Melissa Martin?
Yeah, I think, and Peggy can correct me on this, but if I also remember, I think one of the things that Peggy taught us about drafting is that if something is only used in one place in the statute, it really shouldn't be in the definition section. So because definitions are meant for words that are used multiple times throughout the statute so they can have a clear meaning. And I think this was one example where we used that legislative drafting principle to make it easier to understand, as Lucia just described, and it was also unnecessary to have it in the definition section.
And it shows up on page 39. You'll see that it's the new section 4110. There's a paragraph C on the left-hand side, and current law 4007 subsection 7 says the court may not issue a mutual order of protection or restraint. And so this is where that definition is moved to. There's no change. It's just moved to the one place where it's used in the statute. Okay, we're rolling now. So Subsection 8, order. This is one of like the key parts of this bill that makes this law make sense now, I think, because it explains what an order is and the different categories of an order. If you, right now, it says it talks about a temporary, emergency, interim, or final protective order, order of a tribal court of the Passamaquoddy tribe or the Penobscot Nation, or similar order issued by a court of the United States or another state, territory, commonwealth, or tribe. So what subsection 8 does is talk about, paragraph A is just a temporary, emergency, or interim order issued under this chapter. B is a final protection order issued under this chapter after hearing or opportunity for hearing or with consent of the parties. So that's what a final order is. The bill's very careful to identify what type of order is being discussed in each of these sections, whether it's temporary, emergency order or a final order. But order also means an order of a tribal court of the Passamaquoddy tribe or the Penobscot Nation, or again, the same language that you see from the current law, an order issued by a court of the United States or of another state, territory, commonwealth, or federally recognized Indian tribe. Okay. Subsection 9 is social media. That definition hasn't changed. And then here's the other, this is like the work of art in LD 1696, which is the eligibility section. And it really took, I think, a lot of creative thinking to pull this out of all the different sections to identify who can file for a protection from abuse order. And so it's broken into an adult, a minor child, or somebody filing for on behalf of a minor child, or an older or dependent adult. And it makes it very clear what the circumstances are. So I don't know if Andrea or Melissa or Lucia wants to walk through this better than I can, but so just jump in when I go off track. Would it be all right if Lucia went ahead and walked you through this a little bit? Thank you, Lucia.
I'd be happy to just kind of frame it. So this is what I was talking about in my testimony, and I think others did as well, as being one of those major stumbling blocks. It was because you had the embedded family or household member in the definition of abuse itself. And then you have a whole other section, 4005, in the current statute that you have to get through like 3 really dense paragraphs before you find the other folks who are eligible to file and get relief under the protection order statute. So what we did was take those sections and put them together and then break them into adults, minors, and older dependent adults. And so that's really sort of the framing. It was one of those areas, again, where because you had to read it in several different sections in practice, it's been a real problem, even though since I think 2007, victims of stalking and victims of sexual assault who are not family or household members are eligible for protection orders. Because of the way that the section 4005 in particular was structured with these very dense paragraphs that you can see in the column of current law, it was really, really challenging to understand, and to understand that all of these folks are actually eligible under the law. And actually one of the law court cases that we looked at, which is Craig versus Karen, that was a 2014 case that had to do with stalking. And there's a paragraph 9 in that law court case that says really clearly, you know, victims of stalking, even if they aren't family or household members, and victims of sexual assault are eligible to file. So the law court had explained this also in case law, although it's just, this is not an addition of that case law. I'm just saying that it's referenced and explained in this law court case. But we took the language that already existed and just really reorganized it and restructured it in this section.
Committee members, are there any questions about that point? Go ahead, Senator Kime.
More just for curiosity, but is the stalking piece, which law court decision is specific to that?
So the statute also already, the statute was amended to say you don't have to be a family or a household member if you're a victim of stalking or sexual assault. And I think what Lucia's saying is the law court was reiterating that that's what the statute says. You don't have to prove that relationship.
Right. I just wondered if there was note made of that law court decision that she was referencing, if it was the Craig versus Karen, or if it wasn't in the notes at all.
I don't know if it was included in the notes because it's really not adding anything to the statute. I just mention it because the case law does explicitly state that stalking is an independent ground without being a family or household member. And that is an area that we just see a lot of argument about and a lot of misunderstanding in the practice. So I don't think it's referenced because there's not a carryover that we're not taking any of the language from there and inserting it into the statute where you see the other references to case law. But I'm just mentioning it because it reiterates that, that was one of the issues in the 2014 case was, the analysis, are they family or household members? They were not. In that case, the two parties were not family or household members. So the court just took about a paragraph to say, and in fact, that's not necessary under the statute. If you look at the side by side, you can see the language in 4005 sub 1, an adult who's been the victim of conduct defined as stalking, and then it references the criminal code, or described as sexual assault. And then it goes on to list some other crimes that also qualify an individual. And then as I'm doing this, you can see you have to go through the language really carefully and sort of read it together. Whether or not the conduct was perpetrated by a family or household member or dating partner may seek relief by filing a complaint alleging that conduct. So that's what the existing law is. And this is a great example of how you have to really parse it in order to understand what it's saying about this eligibility.
And Andrea Mancuso, did you want to add to that?
Just for Senator Kime, if you are looking for the specific citation for Craig v. Karen, it's in Peggy's side-by-side on page 9, where we've actually added the clarifying language from Craig v. Karen to make it really accessible for everybody who might not have the background understanding for what that means to really draw the line. So it's in the middle of Peggy's side-by-side, page 9. In that middle, you can see both the citation to the law court decision and the specific paragraph from that decision that we've pulled the reference language in from.
Yes, thank you. That was what I was wondering. Thank you.
And so can I just ask a quick clarification? And so the current language kind of includes within the middle of a pretty dense paragraph whether or not the conduct was perpetrated by a family or household member or dating partner. And what the bill does is incorporate that language as part of section 1B, but using the language that was in Craig v. Karen, which is similar to, but not verbatim to what was in the statute before. Is that right?
Yes, that's correct.
Thanks.
Okay, to move on to minor child, because those other things, those other 1, 2, 3, and 4 were part of that really dense paragraph. actually, the minor piece is also part of that really dense paragraph in the center of the top of page 9. You'll see when a minor has been a victim of such conduct. So subsection 2 in the new bill, a person responsible for a child or a representative of the department when a minor child has been, that's who can file for a protection from abuse, protection from abuse relief. So so paragraph A is a victim of abuse, as defined in 4102 subsection 1, family or by a family or household member or dating partner or an individual related by consanguinity or affinity. And then it goes back to repeat these different specific types of conduct that the minor was a victim of, these different conduct. And then subsection 3 is an older or dependent adult, an adult who meets the eligibility requirements in both A and B following. So A means the adult has to be either 60 years of age or older, or a dependent adult, as that's defined in the Adult Protective Services statute, or an incapacitated adult, as defined in that statute. And I've included those definitions in the far right column. So that's just paragraph A. So they have to meet A, that's kind of who the victim is, who the person is that needs the help. And then B is that person actually has to have been the victim of abuse as defined in this chapter or the Adult Protective Services chapter. And I think that's what Leo Delicata was talking about. And the abuse was perpetrated by an extended family member or unpaid care provider. So it doesn't have to be a family or a household member. And that is the current law. And the paragraphs below there, extended family member is currently defined in the current law on page 11. It's in that long paragraph. And unpaid care provider also is defined in that long paragraph. So it's not new, it's just broken down so it's easier to read. Okay, so now you've defined abuse, you've defined who can actually seek relief for that abuse, and now you get to 4104, commencement of a proceeding. Once again, this is something that they've reorganized to make it very clear. You have all your definitions, you have who can file, and now here's a step-by-step process on going through. Current law is not nearly as clear as this, so it's not substantive changes, it's just an organizational improvement. So here's where a plaintiff can file. So it's in the district court of the division, that's a judicial description, in which the plaintiff or defendant resides, or if the plaintiff has left the plaintiff's residence to avoid abuse, in the division of the plaintiff's previous residence or new residence. So it gives options. That's current law. And then the next paragraph is also current law. It's about what happens when there's not a judge, basically, where the plaintiff is filing a complaint and what happens. The complaint may be presented to another district court judge or any superior court justice. And when that happens, whoever's sitting in that case has the same authority to grant or deny the temporary, order. So this is a temporary seeking emergency. It's a temporary order. A temporary order can be issued ex parte. It doesn't have to have a hearing with the other party involved. So the process is filing a complaint alleging the abuse or conduct that makes a plaintiff eligible to seek the protection. And this is one of the places where the law court has said the complaint need only include a short and plain statement showing that the plaintiff is entitled to relief. The current law doesn't actually say that. And but that's how the law court is interpreting it and is making all the courts interpret that language. And that is the Smith versus Hawthorne case. And that was not, I have the wrong date there. I don't know why it says 220 Maine. I will update that correctly. I don't know how old that case is, but any questions on that? Okay, so that is how a plaintiff starts. They can file a complaint that can be short and plain, showing that the plaintiff is entitled to relief. Here's the abuse. Here's who has engaged in that conduct. There are other proceedings that can be connected to this, or this can be filed in the process of these other proceedings, I believe, is how this works. The Uniform Child Custody Jurisdiction and Enforcement Act. I'm sorry, these laws can also apply in a protection from abuse action. If there's a divorce action or legal separation action going on, a proceeding under this chapter is in addition to any other available civil or criminal remedies. So this is not the exclusive source of relief. And relief can be sought even if there's no criminal case, criminal charges filed. There doesn't have to be a crime being prosecuted in order for somebody to seek a protection from abuse order. And that is all current law. Keep going.
I think so. And this side by side is extraordinarily helpful, Peggy. Thanks for putting it together and walking us through it.
Great. So here's the procedures in 4106. That's tracks everything. You'll see that paragraph B on page 15 at the bottom. We already included that in where you can file for relief. The revisor's office just wanted to make it updated some of the language about the clerk of the court. And this is, if this was a bill a couple of years ago where the clerk can say, here are some, here's information about places where if you need assistance, you can find some assistance and support, and clarified that it can be any local or statewide organizations providing those services. Forms hasn't changed, fees hasn't changed, notice hasn't changed, notification, all the main rules of civil procedure do apply, as do the main rules of civil procedure with regard to appeals. And appeals may only be for error of law or abuse of discretion. The court may not mandate mediation or appointment of referees in actions brought under this chapter. And that's current law, and that is continued. Service of the order, this is not changed. What happened in current law, there is service of temporary orders and there's service of final orders, because the process is the same. These have been combined, this process is combined into one section. It's the exact same process of serving the order on the person who is the subject of the order, the person who committed the abuse. Page 19, electronically transmitted printed copies of the order, that's current law. Officer who served the order as a witness, that is current law. On to page 20. So this is a discussion of temporary orders and the relief that can be included in a temporary order. And this is not a change from current law. The structure is a little bit different, but other than that, it's all the same relief that can be granted. You will see in, let's see, paragraph B, subparagraph 3 on page 21, that current law says entering the family residence or the residence of the plaintiff. So current law says the court can issue an order that enjoins the defendant from doing that. Do not do this, defendant. Go to the family residence or the entering the residence or the family residence or the residence of the plaintiff. You'll see that subparagraph 3 includes the land immediately surrounding and associated with the residence. That's because that was litigated in a case, State versus Falcone, and in 2000. And the law court said when the law says family residence or residence of the plaintiff, it includes the land immediately surrounding and associated with the residence. So that's one of those situations where the law now incorporates what the law court says the law means. So now it's clear to everybody that it's not just going through the front door. It includes the yard, the curtilage.
Thank you. Just one moment, Representative Newell, go ahead with your question.
Thank you, Madam Chair. Peggy, can I just take you back to number 1, temporary orders under LD 1696 and temporary orders under current law. In that first sentence, we have subsection 2 in 1 and then subsection 5.
Right, so those are cross references. So if you go back to section 4006 in the current law, so 4006 subsection 5, and you can see it right below it in the box below, there's the interim relief that can be ordered. That is subsection 5 of the current law, lists all those different things that can be in an order, enjoining the defendant from doing various things. So that's why the middle column cross references subsection 5. Here's what the order can prohibit. In the new section 4108, we're starting with subsection 1, and all the relief, all the things that can be included in the order are in subsection 2 right below.
Okay.
And then you'll also see the last sentence of that paragraph. That's a good question. A temporary order remains in effect pending a hearing pursuant to section 4109. In the current law, it's kind of odd because the hearing came first. That's the 21-day hearing that you hear about, that a hearing has to take place within a certain number of days after a temporary order is issued. Current law has that hearing ahead of what can be in the order. And so now section 4109 is where the hearing is. So same process, it's just easier to find. Here's what can be in the order. And then when you get to the next section, you have to have a hearing on that order. So it doesn't stay in place permanently. You have to have an opportunity for a hearing for that temporary order. So that's why those cross references don't match up from the current law to the new law. So other than that one thing about the curtilage or the yard, all of those relief options are carried over from the current law to 1696. There was a new subsection about the care, custody, or control of animals. That is just added as a paragraph C. So you have A, B, and C for interim relief. And then there's a new there's a separate subsection which carries over the current law, which is for temporary orders when the court may direct the defendant not to possess a firearm or other dangerous weapon. And that is just carried over directly from the current law. The complaint has to demonstrate that the abuse involves one of those weapons or a heightened risk of immediate abuse to the plaintiff or a minor child. And so that is not different than the current law. The only updating is that when the abuse, you'll see killing or threatening to kill pets, but we've actually used the language to make it consistent. Killing or threatening to kill any animal owned, possessed, leased, kept, or held by either party or minor child residing in the household. And that's the same language that is in its current law, 4006 subsection 5A. You can see it on page 22. So that's just making the law consistent with regard to pets and animals. So going through page 24, again, this is a temporary order. So there are places in 1696 where instead of just saying order, it says temporary order. To make it clear, this subsection is just about temporary orders. So that's why the words don't always match up from line to line. And then subsection 4 is emergency relief. That matches up with subsection 3, which is emergency relief under section 4006. And it looks like those all match up. And again, the hearing is now in section 4109, no longer in subsection 1. So the next subsection, denial of relief, before a request for temporary, emergency, or interim relief is denied, the judge has to go through some steps, and some of these are fairly new additions to the statute, I think. Maybe not. Allow the plaintiff the opportunity to be heard in person to support the complaint and advise the plaintiff of the reasons for the denial. So that is actually current law. I'm sorry, it spilled over onto page 27 there. And then current law is just carried over for dissolution or modification, as is the extension. So if a hearing on the complaint is continued, the court may make or extend temporary orders as it considers necessary. And the cross-reference is to the new final protection order, section 4110, as opposed to the existing law, which is 4007. Okay, keep going. Thank you for your patience, everyone. Section 4109 is where all the hearings are. It combines the hearing practice and incorporates the language from Shaw versus Packard. That's one of the cases that was mentioned this morning. So you'll see that the current law says, and is carried over, within 21 days of the filing of a complaint, a hearing must be held at which the plaintiff must prove the allegation of abuse or conduct specified in section 4103 by a preponderance of the evidence. Current law. If a request for temporary, emergency, or interim relief is denied, the hearing must be held as soon as practicable within the 21-day period. And then the new sentence is, and this comes from Shaw versus Packard, nothing in this section limits the court's discretion to continue the final hearing upon the court's own motion or upon the motion of either party. So that's why Shaw versus Packard is there in the right-hand column. Is there any questions?
Yeah, Peggy, I had a question here, and I don't know whether it's for you or for one of the others who have joined the panel, but is this the instance where there was some lack of clarity as to whether a defendant who needed additional time to prepare for the full hearing had been requesting more time, and there was a lack of clarity as to whether, okay, can someone who's had practitioner experience speak to that a little bit, please? Go ahead, Andrea.
I think probably all three of us could speak to this because we've all been in courtrooms with the plaintiff's counsel and defendant's counsel where the request comes up to continue the hearing. And there's inevitably conversation amongst counsel, amongst litigants, and taking up court space, arguing around the statute says 21 days. And there's a case. This is a case as an attorney. I would never go to court without Shelby Packard because it says really clearly that despite the language in the statute, as an administrative function, the court retains the ability to continue the hearing date. And so this is I think was the first case that as we were looking at it that we said litigants and attorneys need clarity around this particular piece of it for transparency and fairness to understand that they have a right to ask for a continuance. And I think from my experience, at least, it's often defendants who are served 3 or 4 days before the final hearing. And of course, we show up with all of our witnesses ready to go. And a defendant asks for a continuance. And there's this conversation around, well, can you have a continuance? Can you not have a continuance? So for fairness, this felt like a particularly important piece to make sure that was clear. I don't know if Lucia or Melissa has anything to add.
Yeah, I'm happy to jump in too. I think one of the other things that is included here is that it could be on the court's own motion. And I think that that's a really important tool for our judges to have. Obviously, you know, and all three of us have practiced a lot, we see this, the protection order court dates are really busy and the judges and the clerks in the courthouse do everything they can to hear all the cases that are assigned on a particular day. But the reality is sometimes they don't have time to hear them all, right? I think we're seeing this, you know, more acutely during COVID. One of the courthouses I practice in has staggered court dates. So not all the cases are called in at 8:30 in the morning, which is sort of how the traditional dockets have worked. They're coming in on 30-minute intervals. So some cases are scheduled, you know, pretty close to the next docket. And if the case is more complicated and it needs a hearing, sometimes the court doesn't have the time to hear that case that day and they need to reschedule it to another day. And this just clarifies that they have the discretion to do that. That's in court rule and it's in this law court case. And that's just really important to have clarified in the statute so that everyone is aware that sometimes that is going to happen. And it's okay, and the court does have the discretion to do that.
Thank you. Senator Bailey, go ahead.
Thank you. So yeah, I just wanted to share some real world experience. First, as others have mentioned, more often than not, it is the defendant who's asking for the continuance because they've been recently served and or they want time to retain an attorney. But secondly, in terms of the court's own schedule, I just had a case. I was on the representing a client in the PFA docket at Portland District Court last Friday. The court was closed due to a snowstorm. And so obviously those cases all needed to be continued. Thank you.
Thanks. All right. Thank you, everybody, for providing that additional information.
Okay, so the next section we'll move on is section 4110 relief. This was substantially reorganized, mostly to make it clear what violations of protection orders are prosecuted as crimes and what are actually treated as contempt because they are not following an order. So bottom of 28, top of page 29. So after the court has hearing or opportunity for hearing, and upon finding that the defendant has committed the abuse or conduct, the court may grant a final protection order to bring about the cessation of the abuse or alleged conduct. The court may enter a finding that the defendant represents a credible threat to the physical safety of the plaintiff or a minor child residing in the household. The court may enter a finding of economic abuse. Those are all things the court can do now. And then this just breaks it up procedurally better. The court may approve a final protection order by consent if the parties agree to the terms, including whether an order under this section includes findings by the court. That is the current law. And then subsection 3 is relief granted under this section may include, I'm sorry, that didn't line up quite right. Directing the defendant not to, these are all things that are current law, they're carried over. All these forms of relief, directing the defendant to refrain from engaging in various activities. It also covers some or all temporary parental rights and responsibilities. It covers the unauthorized dissemination of certain private images, and everything's the same until you get to paragraph M, and this is not a substantive change. The law used to talk about batterers intervention programs, and it was the law was amended last year to call those to categorize those as certified domestic violence intervention programs. And paragraph M is amended just to clarify. These are things that the judge can order, and paragraph M is amended just to clarify that is one of the things that the judge has authority to order, is requiring the defendant to attend a certified domestic violence intervention program. You'll see there are specific mention of that type of order a little bit later in the bill. So let's see. All right, so paragraph O is actually the same as the current law. And then the child support guidelines have to be applied if the court is ordering any child support. Paragraph P is ordering payment of monetary relief when there's been economic abuse. Everything else is just carried over from current law into LD 1696. Subsection 4, these are no longer permanent orders, these are final orders about no possession of a firearm, muzzle loading firearm, bow or crossbow or dangerous weapon for the duration of the final protection order. And the only change in this subsection is making it clear that these are final protection orders, because this subsection is all about, this whole section is about final protection orders. We're no longer talking about temporary. So if the words don't line up from column 1 to column 2, it's because final protection order has been inserted. On page 37, the final protection order, it must be for a fixed period not to exceed 2 years. And so LD 1696 kind of breaks that up a little bit to make it easier to read. So I guess we have an extension someplace else. The order has to indicate in a clear and conspicuous manner the potential consequences of violation of the order. And the order has to include a warning in conformity with Title 17A, Section 506A. That's protection, that's the harassment, the crime of harassment, I believe. So the limitations still apply, current law. You can't affect title to any real property in a protection from abuse order. You can't require the execution of a bond by the plaintiff prior to issuance of an order. You can't issue the court can't issue a mutual order of protection or restraint. Here's that whole definition move there. So talking about the extension that was at the top of the bottom of page 37 and the top of page 38, there's a whole section about modifying and extending orders. So that language is moved into section 4111. So that is current law, except for the what the law court has ordered the law currently really means in Dyer versus Dyer. And I know one of those attorneys is going to be able to explain to you each of these cases. Dyer versus Dyer, there's Gerke versus Gerke, Doe versus Tierney, about these specific things in determining whether an extension of a final protection order is necessary, what a court can consider.
So let's dive into that a little bit, please. Who would like to speak to the Dyer v. Dyer issue? Lucia Hunt, go ahead. Thank you.
I'll take a crack at it. So Dyer versus Dyer is a 2010 case that makes it clear that the court can extend a protection from abuse order more than once and without a limit on the time of the extension. So the original order can be for up to 2 years, but an extension can be for no limitation on the amount of time. That case also held that it's proper to consider earlier abuse when extending an order. And this is really fleshed out more in the Gerke v. Gerke 2015 case and Doe v. Tierney, which is a 2018 case. So those are the cases that we really relied on because the law court did such a good job of spelling out the things that could be considered in extending an order and making clear that an order could be extended. And you know, the statute does have the standard within it, but no real explanation about how the court can come to that conclusion. So these 3 cases really make that very explicit. And, you know, I can only imagine that the law court took those opportunities to be so clear because they see, and we certainly see in the practice of litigating extensions, quite a bit of discussion by attorneys and some confusion by judicial officers about what they can consider when they're looking to extend an order.
Thank you. Melissa Martin or Andrea Mancuso, do you want to add anything to that? Let's take a pause here for a minute and see if committee members have any questions about the bases for extension and what can be taken into consideration. Are there questions on the part of committee members? Not seeing any. Thanks for that additional information.
Great, thank you. So that gets us to page 40, middle of the page, modification of order. That is current law, top of the page in the middle column, you'll see upon motion of either party for sufficient cause, the court may modify an order from time to time as circumstances require. So that's current law. Subsection 3 is also current law. And brings us to page 41, which is sealing of information. This is, so subsection 1 comes from section 4008, which is identifying information sealed. This was actually in response to a case where I believe the court had to give out information that was requested by the defendant in a case. And so now that information can be sealed. It was location information about the plaintiff. And the private images in any, this comes from section 4008. So this is kind of court activity. The court can seal the information. And the issue about the private images was, this was kind of the revenge porn where how does that evidence get into court and what happens with that evidence? And this says that with regard to those private images, because number one, they're private, and number two, they might be a huge invasion of privacy. And any information describing and directly pertaining to the images are governed by a court rule. It doesn't mean the court has to hand these out as a public record or share them with anybody that it's inappropriate to share them with, and the court adopts rules to govern that. That is current law. Okay, moving on to section 4113. This is actually the same. There are no differences in the consequences for violating a protection from abuse order under current law and under 1696. It's just organized. It just makes it clear when it's a crime and when it is must be treated as contempt. So subsection 1 says it's a crime. Violation is a crime. Class D crime when the defendant has prior actual notice, which may be noticed by means other than service in hand of the order. But the only provision of the order that is violated concerns subsection 3, paragraphs K through U. The violation must be treated as contempt. Yes.
I'm sorry to interrupt you, but before we proceed with the violation, I feel like we need a little bit of a 7th inning stretch.
Okay.
And I was wondering if everybody would be agreeable to reconvene at 11:05, just to give us all a moment to get a drink of water, whatever. Okay, great. So we will just remember to turn off your camera and your audio, and see everybody at 11:05.
Sorry.
It was nice to be able to take a little bit of break.
Yes.
Thanks, everybody.
Thank you. So if we're ready to keep talking about this, violations 4113, there aren't changes. As indicated, the section 4110 was reorganized to put the criminal pieces together and the violations that were criminal together. So it's easier to just say in subsection 2, K to U, as opposed to if you look at the existing subsection 2, all these different paragraphs. But that's the only change, was the organizational. I will mention that subsection 4, because this bill was printed in April or May, it didn't catch the amendment that was made by LD 803 to subsection 4 about reckless conduct assault when it is a violation of a protection order that is similar to a protective order pursuant to section 4007 issued by a court of the United States or another state, territory, commonwealth, or tribe. If you remember, Senator Deschambault had a bill last year. So we'll need to amend subsection 4 just to carry out that amendment that you made at the end of the session last year. And then my question at the top of page 43 is, in talking about repeat violations, this is just cross-referencing the new law under, excuse me, 1696 about violating a protection order. We might need to go back and also cross-reference the existing, what's existing right now, but will be former protection from abuse statute. So you catch those repeat violations.
Peggy, could we simply refer to the previous act, or would we have to list out the different sections?
I think you could say former chapter 101.
Okay, thanks.
Right, but I think somewhere along the line, if you do need to cross-reference those, which I wasn't thinking about when we were working on this bill ages ago. Law enforcement agencies, there really aren't substantive changes there. There's a little bit of revisor clarifying language, which I've tried to highlight.
Peggy, hang on. Peggy, just one moment. Senator Keim has a question. Go ahead.
Thank you, Madam Chair. Sorry, Peggy, to jump back, but I guess I don't understand what we just discussed about the repeat violations and the need to cross-reference. So what I think is that a person who commits a violation, so in current law, it says a person who commits a violation under subsection 1 and 2 or more prior convictions under subsection 1 or 2. So because it's saying if they have convictions referencing a piece of law that we're changing, so that's why we have to change it in the new law and we haven't? Is that what you're saying?
Right. So, and actually, I think I might have highlighted the wrong language. So it's really just below what I highlighted, has 2 or more prior convictions under subsection 1 or 2. So subsection 1 is they've committed is a violation. They violated the order when the defendant has prior actual notice, or 2 is it's one of the contempt punishable things, but that doesn't go back any farther than the effective date of this. So it would only apply if they have a prior conviction for violating under this new law. So it would only be 4113 convictions, as opposed to any convictions under what is currently the law. So say they had a protection from abuse order issued this year, they violated it, they were tried, they had a conviction. Next year, this new law goes into effect. There's a new protection from abuse order under section 4113. Right now, subsection 5 doesn't look back at anything that was committed under the existing law, under this year's law.
I am still confused. So
what would, if they had a conviction from New Hampshire,
right,
for violating an order, that then this would apply. Repeat violations would apply. If they had a conviction for violating section 4010, let's say, I'm not sure if that's the right number, 4010 under 19A in 2021, and now they've committed another, they have a new protection from abuse order in 2023, and you look, they can't, the statute isn't looking at anything that happened under the statute that's now been repealed in 2020. So if this goes into effect in January of 2023, there does not appear to be a reference to convictions for committing a violation of a protection order that was issued prior to 2023.
okay, right. So we need to make sure that the language reflects that if there's been violations of a PFA, that they are considered, right? Because so we're changing the referencing to make sure that it references the old law. So if they have violated the old law,
right?
Do I have that right?
Yes, you do.
Okay.
Exactly right. I'm sorry.
I don't know why. It was just hard for me to understand that for some reason. Thank you.
Right. And you know, this is just an issue that I thought about in the last, few days, and I haven't had a chance to talk about it with anybody else, whether it's district attorneys or, attorneys on either side. So we'll figure out what that language needs to be if it really does need to happen. Okay, thanks. Law enforcement agency responsibilities is no change. Subsection 5 is just broken out to make it clear the different categories of action that's happening. Subsection 6 is no change. Subsection 7, subsection 8, the bill corrects the reference to the statewide association of prosecutors because we can't name an entity that doesn't live in the main statutes. So subsection 9 is the same. Subsection 10, subsection 11, section, I'm sorry, so I'm saying, and then the new section, section 4115, Maine Commission on Domestic and Sexual Abuse. This is reorganized to identify who is the appointing authority. So under the bill, everyone that the governor appoints is in paragraph A. And then there are some kind of, I don't know if you'd call them ex officio members. Well, I guess it says it, ex officio voting members. So the attorney general, chief of state police, those aren't appointed by the governor. And so those are in paragraph B. And then paragraph C is the chief justice of the Supreme Judicial Court is requested to appoint a person to serve in an advisory capacity. Those are not changed from current law. Terms of office, the governor appoints the chair, none of that has changed. And then the subsection 4 is a domestic abuse homicide review panel. no changes. What we will need to probably do is build in some transition language. So everybody who's serving now can continue to serve out their terms. And we don't just wipe it out. We're transitioning it under whatever the section is, 40. We're transitioning the existing commission from what is created currently in 4013 into 4115 without changing the membership. And I think we have to fix a cross-reference to where the Maine Commission on Domestic and Sexual Abuse is established, which is technically in Title V in the list of boards and commissions. The certification of domestic violence intervention programs, that's the change I had mentioned earlier. They were called batterers intervention programs. There was a bill last year that changed them to domestic violence intervention programs. This bill was able to catch up on that. And then the last thing is Section 4 is an unallocated section directing somebody to do something. In this case, it was directing the reviser of statutes to catch all those cross references and put them into the errors bill. But since this didn't pass last year, I think that's something that we can do and add to the committee amendment. And that's something I can work on and then have everybody else review. The specific effective date, you heard that the judicial branch is requesting an effective date of January 1, 2023, so they can catch up all their internal and all the forms that they use that cross-reference all these sections. So I'm sure I said way too much and too fast, but I'm happy to answer any questions, and you have your other experts here who can answer questions much better than I can, I think.
Thank you so much, Peggy. I see that the bill sponsor's hand is up. Go ahead, Senator Bailey.
Thank you, Madam Chair. I too wanted to just extend my thanks to Peggy for this very, very helpful chart and cross-reference. I think she did an incredible job as always. And I want to just briefly mention that for what it's worth, I have no objection to the effective date being pushed out a little bit to allow the judicial branch to update its guides and its forms. I think that's a reasonable request. Thank you.
Thank you. Representative Rackett?
Yeah, I just have a quick question on that note of the effective date. I'm presuming that if this bill passes, even though it says the effective date is 2023, to the extent it's just simply a way to help people see this better, they could use the new law to do that effectively 98% of the time. Is that accurate? I mean, you wouldn't have to go back to all the old way of finding things if it's laid out here clearly. Couldn't the practitioners just look at this bill?
Once it's enacted, it's law, even if it hasn't taken effect. So if it's more useful for somebody to look at the bill and say, oh, here are the things that can be considered when we're asking for an extension of a protection from abuse order, rather than pulling out all the cases. Yes, but it's also, I mean, yeah, if it's helpful in understanding what the law means, since you haven't made changes, then I think so. I'm guessing that the attorneys that are going in court will come in with LD 1696 and all the cases just in case, because the person, it doesn't mean anybody else would know to look at that.
Okay, thank you.
Senator Keim, go ahead.
Thank you. I had a couple of questions. One, Peggy, you probably mentioned it and I missed it, but on page 58, you put additional questions, transition, existing commission. What was that about?
So the existing commission is appointed under section 4013 of Title 19A. When you repeal that, that means all those appointments are gone. And so we just need some language that says, and we do this anytime we, change the place in the statute, because you're not changing who's on it or what their jobs are or what their terms are. We'll just need to say, by the way, we are not wiping them out. All those terms and all those responsibilities are shifted to 4114 or whatever it is.
Thank you. And then my second question, something I would like to explore is, I think other times, some people I talked to told me other times when we have done this type of work, that there's been an amendment or there's been sort of a caveat, if you will, placed in that says that these changes aren't meant to change that this recodification isn't meant to change the intent of the law. I'm wondering if you could find examples of that for me, Peggy, and if we could consider that. I guess I recognize this is a work session, but also, we're not ready to vote it. So I guess we have to have at least another work session in order to discuss that idea. But if you could get it to us, where we find that in law currently, and so that we could discuss that idea as well, that would be helpful for me. Thank you.
Committee members, are there other pieces of information that would be helpful for us to have at our next work session on this bill? I did want to reach out to the University of Maine system and kind of clarify whether or not they consider themselves to currently be required to comply with the current act. And Peggy, is that something that
yeah, I'll do that.
You would be able to do? Thank you. Senator Kime?
I had just one other thought that I wanted to go back through and read again the sections that are codifying case law. And I didn't know if someone could just, so that I make sure I didn't miss any, if someone could just say, oh, that one is found on page 9, and then there's another one found on page whatever. Could someone, does anyone have the ability to just sort of run through the whole thing and just make sure that I tried to highlight them, and I just want to make sure that I haven't missed any.
Do you want that right now, or do you want a list?
A list would be great, actually. Yeah, takes less time that way. Thank you.
All right. Well, I'll be happy to do that, and I'll run it past Andrea, Melissa, and Lucia, and make sure that I've caught everything.
Okay, perfect. Thank you.
And then Peggy, would you circulate that to all of us? I'm
Absolutely.
sure that's your plan. Thank you. Anything else, committee members? Other pieces of information that we'd like to have available prior to the work session? Peggy, anything else that we should know?
I don't think so, but if you do think of something, let me know, and we'll try to track that down in time for the work session. And especially if it's information that you think you'll need in order to decide whether to vote on the bill or how to vote on the bill.
Okay. Thank you. Any final requests for information at this point, committee? Not seeing any. Peggy, Melissa, Andrea, and Lucia, thank you so much for all your hard work, and to the others who participated. This obviously was a major undertaking, and your presentations were extraordinarily clear and helpful. We really appreciate your efforts.
Yes, and I want to thank them for being the legal group who knows us backwards and forwards. So thank you for participating.
And thank you to the bill sponsor, of course, as well. So at this point, we'll take a break until noon when we start with our hearing on the resolve regarding the Equal Rights Amendment. And Representative Thorne, did you have a question?
Well, if I could, Madam Chair, I missed the vote last Thursday on the recommendation to draft, incorporate probate courts into the judicial system. If possible, I could vote on that.
Yes, and just to clarify, it's it's not a substantive vote on the proposal. It's just a request to our analyst to draft the legislation for the committee's consideration.
Sure, I'd like to
go ahead and
no on
I
that.
think. Why don't you tell us your vote now? But I think the process is to report it to your presiding officer. But why don't you do both, and then we'll make sure we have it both ways.
Okay, I'd like to vote no on that.
Thank you.
Senator Carney, I think that the committee clerk has updated procedures for that.
Oh, okay, great. That's Soupy, do you want to tell us
Yeah.
what I'm sorry, I wasn't aware, but go ahead.
That is perfectly okay. Thank you, Peggy. As long as we are on camera, then the member can register their vote and not have to go through the presiding officers. And because I was absent on Thursday, I was unable to send out the regular way we used to do it. You know, I'd send out the voting sheet and then the members could, so it's not really anyone's fault why we're doing this, but as long as we're on camera and Representative Thorne indicates on camera, then they say that that's okay. I have to see him and I have to hear him, and I think he's met both criteria.
Great. Thank you. It's a much clearer process. I'm glad that we have that update, and thanks for providing it. Anything else, anyone? All right. See you all at noon. Thank you, everybody.
Thank you.
Ann, can you stay for a minute?
Sure.
And it's not a secret. I mean, I'm getting a lot of calls because I sent you an email. We have 40 people that have signed up to speak so far on this bill coming up.
Okay.
A number of them are legislators, and people are just asking, are we having time limits? Are we, are you hearing from all legislators first? Are you hearing from legislators speaking in favor first? Or I guess I just want a little clarification so I can answer some questions.
Thank you. And I'm glad you're asking it on the YouTube and live stream. So there will be other than the bill sponsor, there will be a 3-minute time limit, and I'll be running a clock as is typical for the committee. And we will take legislators first, and we'll do legislators in support, legislators in opposition, and then legislators neither for nor against. And then we'll move into other attendees. I think that the governor may also be providing testimony. I'm not totally sure, but if that is the case, then I would take the governor after the bill sponsor.
Excellent. Thank you so very much. Appreciate the help.
Yeah, thank you for asking the question. See you in a little bit.
Bye.
Peggy. And Representative Reckett, I just realized that we didn't table the previous bill before we moved on to receiving votes on the probate commission matter. And so we'll have to do a quick tabling motion on 1696 before we resume. And Lois, I just wanted to alert you to that.
Sorry, I didn't even think about that.
I didn't either.
Is there something like tabling by implication?
I don't know.
Madam Chair, you're going to want a roll call?
Don't think we need a roll call on a tabling motion, but we will do it by a show of hands because the electronic raise hand function does not show on YouTube. So,
okay. Thank you.
Well, I did have to step away for 15 minutes, but evidently you took a vote during that time?
no, we did. We went when we were transitioning from our work session on 1696. We did not table that bill. We kind of moved on to the probate court matter. And so we just need to have a quick motion to table.
Did you vote on the probate court matter, a motion regarding that in any way?
No, we
Okay,
took some votes that were related to last Thursday's vote.
I see. I'll catch up with Soupy.
Yeah, I believe that you voted to report out the legislation.
Yes. Yes.
Okay. Right. Well, at this point, we're close to beginning our next work session. But before we do that, I would entertain a motion to table the work session on LD 1696. Do I have a motion? Moved by Representative Reckett. Is there a second? Seconded by Representative Babbage. Representative Poirier, I just wanted to fill you in. We moved on too quickly this morning and neglected to table 1696. And so this is the motion to table that. All those in favor, please raise your actual physical hand and keep it raised until we've counted the votes. Okay, it looks like everybody who is here in attendance is voting in favor of the tabling motion. Thank you, everyone. And so that concludes our work session on 1696, and we'll begin our work this afternoon with a public hearing on LD 344, a constitutional resolution prohibiting discrimination based on sex. And LD 344 is sponsored by our committee member, Representative Lois Reckett. Before we have the sponsor begin, Representative Moriarty, did you have a question?
No.
Okay. I just want to go over how we'll do the hearing. A number of people have signed up to provide testimony regarding LD 344. And so we'll begin with the bill sponsor, and then we will see if the governor is available and would like to testify. We would call on her next. And then we'll call on legislators, all legislators, but we'll begin with legislators in favor and then opposed and then neither for nor against. And then we would move on to others who have signed up to testify. And the process that I'll follow is that I'll just ask people in the attendee space when your time comes up, for example, legislators who want to testify in support, please raise your electronic hands and keep them raised. And I'll bring people over in batches from the attendee space to the panel. And so you could be floating through cyberspace, just be patient and you'll reappear on the panel or return to the attendee part of the meeting. And with that, and then again, for members of the public, I'll follow the same process. those in favor, those opposed, and then neither for nor against. And again, we do have a number of people signed up, and so I'll be running a timer. And what I will do so that I'm not moving around the screen, I'm going to keep my hand raised, so I'll always be in the upper right-hand corner, and then I'll just hold my phone up like that when you're close to the end of your 3 minutes. And I appreciate everybody's cooperation. Again, the bill sponsor is not subject to the 3-minute limit. And with that, committee members, any questions? Not seeing any. Representative Reckitt, welcome. And we look forward to hearing your presentation of your bill.
Thank you so much. I'm before you today in support of LD 344, a resolution proposing an amendment to the Constitution of Maine to explicitly prohibit sex discrimination based on the sex of an individual. I don't want to begin by giving you my history on this issue. Instead, I want to first raise up the voice of a 7-year-old girl from Old Town who submitted testimony online this morning. Her name is Zoe, and she is not presenting her words to you because she has to be in school. Therefore, this 77-year-old woman is going to do it for her. Quote, I think the Equal Rights Amendment is a good movement because it will help girls grow up to be treasured as much as boys. Girls and boys are, capital letters, equal, exclamation point. Zoe Humphrey, age 7, Old Town. It's no secret I have been advocating for a federal Equal Rights Amendment every day since 1972. In 1973, as a private citizen, I lobbied the Maine legislature to ratify that proposal, losing in the Senate by 1 vote. The next year, in 1974, I did the same, and we were successful. Today, even with the required number of states that have ratified the amendment, the Equal Rights Amendment is still not the law of the land. In Maine, a further defeat was also suffered in the mid-'80s when a state constitutional amendment was struck down. Many of you know me as a kind, determined, and some would say stubborn soul. When I was elected to represent part of South Portland in 2016, constitutional equality in Maine continued to be a top priority for me. A majority of the 128th and the 129th legislatures passed the resolve, but unfortunately each time we were unable to pass muster by 2/3, which is the barrier necessary to send this out to vote by the people. In 2017, we lost that by 6 votes. At one point in 2019, we lost by 2. To my mind, this momentum has now met its urgency, and it's time to embrace equality by letting the people of Maine choose for themselves. These pandemic times have challenged all of us, but it has proven to bear that collective voices, equality, and community can withstand any challenge. Why does Maine need an ERA? Our outstanding Maine Human Rights Commission takes care of sex discrimination, doesn't it? Yes, but only in employment, housing, public accommodations, and credit-related issues. It has no legal basis to handle domestic violence, violence against women, insurance, and pension discrimination, and incarcerated women. Through this effort, we can fix that coverage gap of protections. Many people testifying today will share a variety of issues in which they believe a state ERA could provide relief to them or that they care deeply about. But for me, the bottom line is that it's a matter of principle and permanence with the foundation of Maine's laws treating all Maine citizens equally, regardless of sex or gender. I am inspired to continue the fight for equality by one of my heroes, the recently deceased U.S. Representative and civil rights icon, John Lewis. I have recently been reading his latest book called Carry On, and I want to read you a brief quote from it because I think it's pertinent today. We helped to inspire and educate millions of people around the country, and we showed we take this issue seriously and that there are elected representatives who want to do something about it. We have to keep our eyes on the prize and return more determined than before. We will keep going and going, getting into good trouble until more join our cause and change is finally at hand. John Lewis would push aside the disappointment of inaction by others, knowing the fight would continue. Sadly, he died knowing, not knowing, or knowing that the reauthorization of the Voting Rights Act protecting freedom in his name remains stalled in the US Senate. Also, Susan B. Anthony, a pioneer crusader for the women's suffrage movement, died without knowing the 19th Amendment to the US Constitution, giving women the right to vote, would eventually pass. The similarity of these two change agents, as with the leaders behind the ERA for the last 50 years, remains the same. Like them, we will fight for equality to our last days, knowing others will keep our eyes on the prize until the change occurs. Thank you very much for your attention, and knowing how many people are testifying today, I thought I would be especially brief. Thank you.
Thank you so much, Representative Reckitt. I believe that Representative Evangelos has his hand up with a question. Go ahead, Representative.
Thank you, Madam Chair. Representative Galkay Reckitt, I just have one question today for you. Lois, we've worked together in this committee on human rights issues. Everything from sovereignty to poor people's rights to racial justice. But the opposition is always the same. Maine doesn't have these problems. We're different. Maine's not ready for this. I'm joining hands with you today. But what do you have to say to these critics who continue with this refrain? Would you please speak to that? That's all I got.
Thank you. It's very hard because people ask me why people are opposed to this initiative, and I have a very difficult time articulating that because it doesn't speak to my heart at all. I mean, the opposition. So I have difficulty doing that, and I hope that the people who do testify today in opposition might give us some clue that is more understandable than what I have felt in the past. I think that there's been a lot of peripheral issues that have been landed onto this amendment that really, in most cases, have absolutely no bearing on it. But there's a fear of change. There's a fear of, I don't know, for me, it feels like a fear of progress. And I don't know that that's the case. I don't know that's the motivation. I don't even know what the motivation is. I respect the opinions of my fellow legislators. I just plain don't agree with them. And I think that there isn't, I hope that some of the people who speak in favor of this today may reach the hearts of some of the people who have consistently voted against us. I don't know whether that will be the case. What I do know is that I'm going to continue either in this legislature or subsequent to the end of my service here. I'll be keeping at it until change comes. And I know, Representative Evangelos, that that's sort of your attitude on several things that mean an awful lot to you. And I admire your persistence in all of those things, 99% of which I think I agree with, but not every single thing. So, if people look at the Democrats on this committee and in the legislature as if we're a monolith, that's not true, really. But we argue out and we get to places that are a lot of the time the same, but it's not always the same. And I think we need to encourage dialogue across the whole panoply of the legislature. And I hope we will do that this year.
Thank you.
Thank you. Any other questions, committee members? Not seeing any. Thank you so much, Representative Reckitt. And now next we will hear from Governor Janet Mills.
I'm coming.
We see you. Hello, welcome, Governor
Hi.
Mills.
Thank you. I hope you can hear me as well as see me. Thank you for allowing me to testify today. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. I humbly request that you vote ought to pass on LD 344, a resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of the individual. A favorable vote on this measure in the committee in the House and Senate will allow the people of Maine to vote on a measure which approximately 26 other states have now seen fit to embody in their state constitutions. Our own state's history of constitutional amendments may be of interest to you. Without diminishing the importance of the measure before you today, it is noteworthy that the people of Maine, upon request of the legislature, have amended the Maine Constitution 174 times in the past 188 years. Among the matters that have merited this level of attention with varying degrees of gravity are residency requirements for candidates for the legislature, the preservation of the right to keep and bear arms, municipal home rule, current use valuation for taxation, line item veto power for budget legislation, protection of the revenues of the Department of Inland Fish and Wildlife, repeal of the infamous poll tax and payment in lieu of military duty, men only, exemptions from current use tax assessment for commercial waterfront and other properties, reducing the voting age of age of adulthood to 20, and then a year later, reducing the voting age and age of adulthood to 18. People matured very, very quickly. A change to the timing of direct initiatives for enactment of legislation and people's vetoes, changes to the year of reapportionment, measures reducing the volatility of the state pension fund, increases to the debt limit, authorization of the use of voting machines, et cetera, et cetera, et cetera, up until last November when the Maine people amended the Constitution to preserve a right to food. I ask you, is any of these 174 measures, these constitutional amendments, any more important than the granting of equal rights and protections to all of our citizens, regardless of sex? The measure before you should not be confused with the federal Equal Rights Amendment, which engendered great debate in this body some 40, 50 years ago, and which has not yet been adopted by the requisite number of states in order to become the 28th Amendment to the US Constitution and the law of the land. Maine, however, did ratify the Equal Rights Amendment to the US Constitution in January of 1974 in a strongly bipartisan vote after many other states debated and supported the same measure. In line with that strong statement of nearly 50 years ago, the current, more modest measure does not seek federal recognition, but asserts that as a matter of state constitutional law, the principle of equal protection is worthy of preserving in our most revered legal instrument, our Constitution. While our state and our nation have unquestionably made great progress in effectuating equal rights for men and women, those changes have been piecemeal, intermittent, and impermanent. And those laws, which cover discrimination only in specific areas like employment, housing, credit, public accommodation, education, they are ephemeral. They're subject to repeal or change at the whim of any particular legislature or initiative. It is both sad and fortuitous, I think, that our state comes so late to the game in adopting this important measure after 26 other states have done so. It is sad because so many other states have taken the lead and without incurring irreparable damage to their cultural and historical institutions, customs, and laws. It is fortuitous because there is now an abundance of history in those states and case law and actions on which we can judge the actual impact of such a measure, including the level of scrutiny and the preservation of various valued protections and customs. In terms of the impact of this measure on Maine law, there are at least two in-depth analyses. One in October 1984 by Attorney General James Tierney on two specific issues, and a 28-page impact study of February 1983 by members of the Attorney General's professional staff. And I would urge your staff and you to seek information, resources from those opinions about the effect of this amendment on various things, including abortion. Much case law in other states also since that time has demonstrated how such a constitutional amendment may be read to be consistent with other established values. The late Justice Ruth Bader Ginsburg once said that she would like to see her granddaughters, when they pick up the Constitution, to see that notion that women and men are persons of equal stature. She said, I'd like them to see that it is a basic principle of our society, end quote. Recently, we marked the 100th anniversary of women's right to vote. We should take this opportunity to see that the right of equal protection is enshrined in the Maine Constitution, so that 100 or more years from now, our descendants and future citizens will say, what was all the fuss about? While I won't have the privilege of signing this bill, it being a constitutional resolve, destined, I hope, for wider discussion amongst the population of Maine, I cannot wait to accompany the 5 adult women whom I proudly call my daughters and my 2 little granddaughters into a voting booth in the fall, some fall soon, this fall, I hope, to cast my vote so that they and their uncles, cousins, and friends will be fully protected in our most sacred document, and that they will all have the equal opportunity under the law that we have come to expect and demand, and which deserves to be preserved in this Constitution of the state of Maine. Should equality of rights, regardless of sex, be preserved in the Maine Constitution? I ask you today, let the people decide. Thank you.
Thank you, Governor Mills. Committee members, are there any questions for Governor Mills? Not seeing any. We appreciate you appearing before the committee and providing your testimony today.
Thank you, Madam Chair.
And now I'll ask that any member of the legislature who is present in the attendee portion of the meeting who would like to speak in support of this legislation to raise your electronic hand, and please keep it raised until after you've been brought over to the panel. And actually, please keep it raised until you've provided your testimony. And so I'm going to start bringing over members of the legislature, starting with Senator Vitelli. And Senator Vitelli, when you are able, you may activate your audio and video and begin. And as a reminder, I'll be running a 3-minute clock from here forward. Welcome.
Thank you, Senator Carney. Can you hear me?
Yes, we hear you just fine.
Good. Well, thank you, Senator Carney, Representative Hartnett, and esteemed members of the Judiciary Committee. My name is Eloise Vitelli, and I represent Senate District 23, which is all of Saginaw County and the town of Dresden in Lincoln County. And I thank you for the opportunity to testify in strong support of LD 344, the resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. This is not the first time that I and many of the others speaking today have come before this committee to advocate for this resolution. We are here again today to continue the work of generations of women and allies who've advocated for equal rights for women, and we stand on their shoulders, thankful for the progress that's been made, while knowing that our work is not yet complete. In July of 1848, at the Seneca Falls Convention, the Declaration of Sentiments was adopted that begins, quote, "We hold these truths to be self-evident, that all men and women are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted deriving their just powers from the consent of the governed. 72 years later, the 19th Amendment was finally adopted, giving women the right to vote and thus able to consent to the laws governing them. You heard the governor referenced that we just celebrated the 100th anniversary of that 19th Amendment. I'll skip over some of the history because I'm sure you've heard some of it already, and you'll probably hear more from those who follow me. Just to say that in 1974, the year that Maine ratified the federal Equal Rights Amendment, and I moved to Maine, the wage gap, the difference between what women earned on average for working full-time and what men earned on average for working full-time was 59 cents. In their 2020 Measures of Growth report, the Maine Economic Growth Council cites data showing that full-time working women were earning just 80% of what full-time working men were making in 2019. Disappointingly, that represents a drop of our percentage of 4 percentage points from 2018 to 2019. A reminder that we're still decades away from closing the wage gap. And while there are a number of factors that account for this wage differential, wage discrimination remains part of the equation. I spent my entire working career helping to improve opportunities for women and their families to achieve economic security, preparing them for the workplace through education and training, helping them identify career pathways that could lead to well-paying occupations, including starting their own small business. The Equal Rights Amendment itself will not resolve the economic disparities that women still face. After all, we've had comparable worth laws on the books in Maine since 1966. But the Constitution provides the foundation upon which our laws are based. And as we know, laws can and do change. And in recent years, we've seen a vocal backlash to many of the advances we've made in gender equality. Advances that detractors once said would occur if a federal ERA were passed, that have happened anyway. I agree with the ERA Coalition co-founder, Jessica Neuwirth, who said, on the contrary, quote, "It's almost more important in times like these to have very explicit constitutional language. If the law says no discrimination on the basis of sex, the better off people are going to be." And equal rights.
Senator Vitelli?
Yes.
I'm sorry. I am sorry to interrupt you.
My 3 minutes.
The 3 minutes was up quite some time ago. So could you
Oh.
please, I apologize, but could you please wrap up your remarks?
Thank you for your indulgence. I will just please urge this committee to vote ought to pass on this bill. And as the governor said, get this referendum out to the people. Thank you.
Thank you so much. Committee members, are there any questions for Senator Vitelli? I am, Representative Babbage, is your hand up because you wished to speak in favor of the bill? Okay, thank you. Seeing no questions, thank you so much, Senator Vitelli. And Representative Babbage, why don't you proceed next?
Thank you, Madam Chair. Let me thank you, Senator Carney and distinguished colleagues on what is to me the very special and important Committee on the Judiciary. My name is Christopher Babbage. I'm honored to represent the people of District 8, part of the town of Kennebunk. I take the podium symbolically here to testify in support of LD 344, a resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. Excuse me. Women's equality has been prioritized, or a prioritized cause for me for a half century. I came to adulthood during the civil rights years, and equality before the law became for me a crusading cause. Second, my concern for my young students made me committed to do better. And then finally, the birth of my first daughter made even more personal the importance of this issue. That precious little girl will turn 45 this year, and yet we still debate whether equality of the sexes deserves the highest protection. I have the good fortune to lead the study of American Story with high school students in Greenville for 8 years, Kennebunk for 31 years, and Bates College for 17 summers. For 4 decades, I taught high schoolers the exploration of history and government. One of the several issues I was excited to revisit during the study of each era was the role of women in American society. Throughout the year, covering 3 centuries of history, I introduced readings by or about insightful women with varying viewpoints about the role and challenges of their sex. For the girls in my classes, I sometimes worried about being the bearer of bad news regarding the status of their sex in history, even recent history. But the message to all my students, girls and boys, was this: people with courage bring issues forward and provide others with the opportunity to hear, to learn, and to act to improve society. Injustice within the law prevails when we don't seize those opportunities. The proposed amendment put before us by Representative Reckitt is an historic opportunity. Now, a majority of states, albeit a slim majority, as the governor mentioned, do have this constitutional protection. Maine has seen it necessary to amend the Constitution 174 times, yet never has protected this equality. Current interpretation of present law by the courts addresses some inequalities, but others remain. If we as legislators allow the people to vote on this proposal and Mainers vote to approve the amendment, then the courts will regard this equality as a higher standard with strict scrutiny to the facts, so that disregard of this fundamental right must be justified by a compelling state interest. The legal concept of equality of all Maine citizens should and must include at the highest level a ban on discrimination that disadvantages someone based on their sex. Okay, I will wrap it up.
Thank you so much.
De jure segregation can and must be eliminated by law. I just want to mention that, you know, whether it's Lillian Stevens, a suffragette from Dover, who had to give up her teaching position because she got married, or the issues that were mentioned by the governor that deserve our attention today. Equality before the law should be fundamental. And I want to mention one thing, if I may, Madam Chair. Before this committee 105 years ago, Florence Brooks Whitehouse stood before this Judiciary Committee, which was men only. Today, we as men and women have the possibility of together bringing about this important change. And this bill gives the women the same rights that I have, no more, but importantly, no less. I urge your support for this proposal. Thank you, Madam Chair. Appreciate it.
Thank you very much. Representative Moriarty, did you have a question or did you also wish to speak? We're not able to hear you, Representative.
Wish to speak, Madam Chair.
Okay, I'm going to ask you to wait a moment and call on you shortly.
Okay.
Lynn Williams, would you like to proceed with your testimony? And just a reminder to please stay within the 3 minutes. We're not able to hear you.
Sorry.
Perfect.
I'm here today to enthusiastically support Representative Reckitt's Bill 344. I am the representative of the towns of Bar Harbor, Lemoyne, and Mount Desert. It was almost 55 years ago when I arrived at college, having been accepted into the civil engineering program. I had grown up in the shadow of the Brooklyn Bridge, and that iconic structure made me think that I too could design something like that. Even though the man who engineered and oversaw the construction of that bridge was John Roebling, early on during construction, he contracted tetanus and became bedridden. It was his wife, Emily Warren Roebling, who was his eyes and ears on the construction site, and who later graduated from law school. However, the second day I was at college, I was called into the Dean of Women's office
and told that since I was the only woman in the engineering program, I would be better off switching my major. At 17 years old, I did not yet have the strength to resist that authority figure. Over those intervening 55 years, I've seen a lot of positive changes with respect to what roles women can play in our society. However, I have also seen a lot of pushback to those changes. I've personally experienced the glass ceiling, and I've experienced housing discrimination multiple times as a single mother. As someone involved in politics and government for many decades, I know that rights must be enshrined so they cannot be taken away arbitrarily. And as an attorney, I know that rights must be more than conceptual and more than dependent on the goodwill of those who have power in our society. They must be clear and enshrined in writing. They must be part of our body of laws. The resolution proposing an amendment to the Maine Constitution, which would prohibit discrimination based on sex, is long overdue. Thank you, Representative Reckitt, for proposing this measure. While we have not been able to get the ERA enshrined in the federal Constitution, we can take this action to get it into our Maine Constitution. As part of the Missouri Compromise, Maine entered the Union as a free state. Now it is time for Maine to once again guarantee protections to those who have long sought them. I look forward to voting on this historic piece of legislation when it comes to the House floor. Thank you for listening.
Thank you very much, Representative Williams. Committee members, any questions for Representative Williams? Not seeing any. Appreciate your testimony. And Representative Brooks, you're next.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Heidi Brooks, and I gratefully represent State House District 61, which is part of Lewiston. I'm here to speak in strong support of LD 344, the resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual, and I thank its sponsor, Representative Louis Galgay-Reckitt. When my youngest niece was 9, about a decade ago, she was under the impression that it was illegal in the United States of America for a woman to be president. Indeed, in our history, we haven't elected a woman president. I can tell you about how she was holding the modern woodman ruler, tin ruler, with presidents from George Washington through George H.W. Bush, and I could see why she might get that impression, unfortunately. And now she's turned, a decade later, 19. I brought her to vote for the first time last year, and that's really important to me. About 200 years ago, Maine became a state, as was mentioned by a previous speaker, and now we have a female governor, and it took a long time in that process. We've had and have female senators in the state house and state senate. The demographics are evolving and changing. I did go to medical school, and I met women. There were fewer women than there were men in my class, but I had met women not too much older, maybe a generation, maybe two, who were, one was a neurosurgeon in her class, and when she was applying for residency or her fellowship, I guess, somebody asked her on the panel of male interviewees or interviewers, I should say, about how her skill as a mother compared, how could she be a good mother when, or a good neurosurgeon, and they questioned her motherhood. And things like this are reprehensible to me. Right now I'm on the Health Insurance Financial Services Committee, and discrimination in health coverage is among the cruelest. So in our history, our history of inequality is lengthy, whether it's related to the right to vote, to own property, to be extended a loan or credit, employment opportunity, equal pay for equal work, and the list is extensive and not complete. But we have an opportunity here in Maine. We have an opportunity to say there's equal protection in the Maine, and put it to voters, extend the conversation. And with that, I will end my testimony. Again, I thank the sponsor, Representative Louis Galgay-Reckitt, and the members of the committee for their consideration.
Thank you, Representative Brooks. Committee members, any questions? Not seeing any. Next, we'll hear from Representative Gramlich.
Thank you. You'd think after 2 years of Zoom, we'd get this process down really smooth. Thanks for bearing with me. Good afternoon, Senator Carney and my esteemed colleagues of the Joint Standing Committee on Judiciary. My name is Lori Gramlich, and I represent House District 13, Old Orchard Beach. I am here in strong support of LD 344, resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. I'm not going to read my entire testimony in the interest of time. I do reference some historical perspectives, but let me be clear. LD 344 gives women the dignity of full inclusion in the Maine Constitution that men have always had. We've heard in the past, and we will undoubtedly hear again, that we do not need the ERA. However, history has revealed that we do indeed need to assure that women are guaranteed once and for all equal protection under the law. There are many examples, many, too numerous to mention here, but I will say it was in my grandmother's lifetime, and I was fortunate enough to know her, that women, I'll add white women, finally realized that they realized the right to vote in 1920. This was accomplished after years and years of women fighting for this fundamental right. The women's suffrage movement took activists and reformers nearly 100 years to win this right. And for many, this incredible fight for a sense of equality was finally over, but for some in the early 1920s, the fight continued. Specifically, Alice Paul, who was instrumental in ensuring women finally had the right to vote, was among them. She believed the true battle for legally protected gender equity had yet to be won, and I agree with her. She began working on the Equal Rights Amendment in 1923, nearly 100 years ago. Her proposed amendment, simply put, was as follows. Equality of rights under the law shall not be denied or abridged by the United States or by any state on the account of sex. Another example of relevance illustrating gender inequality includes simple matters that we today take for granted. For example, in my mother's lifetime, during the 1960s, a bank could refuse to issue a credit card to an unmarried woman. Even if she was married, her husband was required to co-sign. And as recently as the 1970s, credit cards in many cases were issued only with a husband's signature. It wasn't until the Equal Credit Opportunity Act of 1974 that it became illegal to refuse a credit card to a woman based on her gender. Additionally, married women could not divorce their husband unless he agreed to it. We have indeed addressed these inequities. However, we still have work to do. And there's one more example I want to share with you, which is another example of why it is imperative that we pass LD 344. This morning, I heard a piece on National Public Radio. It was suggested that gender bias in the acceptance rate for astronomers relative to both the Hubble and now Webb telescope existed. In a study published in 2014, it was determined that proposals that were led by women had a lower acceptance rate than those proposals led by men. This discrepancy remained constant for more than a dozen years for the entire time it was studied. Recommendations were to make the review process completely blinded and anonymous for scientists bidding to do this work. Not only would the evaluation committees not get to see any names, but all proposals would be required to be written in a way that made it totally impossible to know who the proposal was from. In 2018, astronomers did their first truly anonymous review for Hubble proposals. That year, for the first time ever, the acceptance rate for proposals led by women was higher than the acceptance rate for proposals led by men. The gender difference had finally flipped. Let me be clear, the ERA does not add new laws to the Constitution. It only eases the rights currently within it. This is an issue for both men and women. Issues of custody, employment, and fair wages are important to both sexes, and the ERA would guarantee equal legal rights without regard to sex. I mentioned my mother and my grandmother, and I will now look to the future and mention my daughter and all of our daughters and sons. It is my hope to give them true equity under the law. This is their future. I thank Representative Reckitt for putting this forward and for tireless work on this issue. I urge you to vote to pass LD 344, and I would be happy to answer any questions for you. Thank you very much.
Thank you, Representative Gramlich. Committee members, are there any questions? Not seeing any. Appreciate your testimony. And Representative Sachs, you're next.
Thank you so much, Madam Chair. Good afternoon, Senator Carney, and in absence, Representative Harnett, and esteemed members of the Judiciary Committee. My name is Melanie Sachs. I am honored to represent House District 48, which includes Freeport and part of Pownell, and I'm here in strong support of LD 344. As mentioned, Alice Paul, a social worker, introduced the Equal Rights Amendment in 1923 in Seneca Falls, New York, almost 100 years later. It has not passed. In 1974, and I quote her directly, she stated, "I have never doubted that equal rights was the right direction. Most reforms, most problems are complicated, but to me, there is nothing complicated about ordinary equality." We in Maine ratified that federal ERA statute that same year in 1974, but we have not yet made the change to our own constitution as many other states have done. It is not complicated why we should do so. We currently utilize a piecemeal approach to policymaking in areas such as pay equity, workplace conditions, healthcare, among others. A constitutional amendment would ensure that equity, parity, and equality in our policies, our legislation, and regulations would be grounded in our foundational document. Mainers recently enshrined the right to food in our Constitution by overwhelming numbers. Let us give Mainers the opportunity to ensure that the rights of every person to be free of discrimination is similarly protected. It is an honor to come before you today to urge you to support this historic and important legislation. Thank you for that opportunity, and I'm happy to answer any questions.
Thank you very much, Representative Sachs. Committee members, any questions for Representative Sachs? I am not seeing any. Thank you very much. And Representative Zager, you can go ahead.
Thank you very much, Madam Chair, and Senator Carney, other honorable members of the committee. I am Sam Zager. I am honored to represent District 41 in Portland. I very much appreciate the opportunity to testify briefly regarding the Maine Equal Rights Amendment. I thank Representative Reckitt for her work, as well as countless others who, as have been mentioned, were tirelessly working at Seneca Falls in the 100 years ago, 170 years ago, and many others. What would the purpose of the Equal Rights Amendment be? Well, it was, as has been stated, it would enshrine crucial and equal rights in Maine's Constitution and signal very important things to girls and young women. But I want to live in a state, indeed in a nation, that has an Equal Rights Amendment. I've asked myself, is this needed? After all, the 14th Amendment of the Constitution has an equal protection clause. However, it took more than a century for the Supreme Court to apply the 14th Amendment to sex discrimination in a case out of Idaho. And yet there are still exceptions and vulnerabilities to this protection, as Governor Mills mentioned. Currently, there's no explicit protection in either US or Maine's Constitution on the basis of either sex or gender. So the Maine Equal Rights Amendment would advance the concept of equal justice under law, and that is the kind of state I want to live in, and many others have expressed the same. Furthermore, there are examples in our state constitution of a right having both implicit and explicit guarantees. Freedom of religion in Article 1, Section 3, the right of an individual citizen to bear arms in Section 16 are two such noteworthy examples. The long history of discrimination and unfairness on the basis of sex and gender, two separate and overlapping concepts, calls for explicit protections in Maine's Constitution. So please support the Maine Equal Rights Amendment, and thank you very much for your time and consideration.
Thank you very much, Representative Zager. Any questions, committee members? I am not seeing any. Let's see, Representative Moriarty, why don't you go ahead with your testimony, please?
Thank you, Madam Chair, and good afternoon to my colleagues on the Committee on Judiciary and to all of those citizens who may be watching or participating in this hearing. I am Steve Moriarty, representative from House District 41, which is Cumberland and part of Gray. I speak in support of the resolution proposing a state constitutional amendment to guarantee equal rights to all citizens without regard to a person's sex. Our Constitution sets forth a method and procedure for amendments. Clearly, as shown by Governor Mills, it was anticipated at the time of statehood that the need would arise over time to revise our basic law, and we have done so on many occasions. A strong and hearty republic requires that all of its citizens be able to fully participate in its civic life. The prohibition of legal distinctions among citizens based on sex is proof of resilience, fortitude, and faith in our founding principles. We are a great state, but we can recognize when legal distinctions prevent us from achieving the fullest extent of our promise. At such times, we must rise to the occasion and eliminate barriers to the unrestricted exercise of rights under our Constitution. To my fellow members of this committee and of the current legislature, and indeed to all citizens across the state, I tell you that legal differences based upon sex of an individual, the sex of an individual, conflict with and are inconsistent with the overriding goals of our democracy. They must be eliminated. The time has come and the moment is ours. With clarity and conviction, let us all move forward by supporting the pending resolution. Thank you, Madam Chair.
Thank you so much, Representative Moriarty. And now we're going to take one person out of order, and that's Eleanor Smeal. And she will be joining us from the attendee space in just one moment. Eleanor Smeal, welcome very much to the Joint Standing Committee on the Judiciary of the Maine Legislature. You can proceed with your testimony whenever you're ready.
Thank you so much. And I say that was a very smooth transition from webinar to live participant. I'd like to thank you for this opportunity. And I would also like to thank and salute Lois Reckitt, who has been tireless leader, not only in Maine, but I must tell you nationwide. She has been a key figure in the work of many groups at the national level, as well as the state level, and certainly at the National Organization for Women, where she served as executive vice president when I was president. I wanted to speak on the Maine ERA because it is so important that all the states ratify a state ERA as well as a federal ERA, which we are working on. We believe that it has been ratified, by the way, by 38 states and 2/3 of Congress, and we believe that it should take effect now. But we're fighting. We don't have that yet on concrete. In the meantime, we do need them at the state level too. For example, in the state of Maine, domestic violence, violence against women, insurance pension discrimination, and other areas are not covered by your Human Rights Commission. We feel that this is imperative. And I thought I would just take one area, which people don't think about very much, but it's a form of discrimination that costs every American family. Right now in insurance, it is permissible to discriminate on the basis of sex, except health insurance, which we now have covered under the Affordable Care Act. But remember, that act is being constantly challenged and might be repealed. What is so important about a state ERA is that insurance is a state regulated industry, and that if you had it, all kinds of benefits would not be, our benefits typically are less for women, more for men, and also this goes the reverse in pricing. Pricing is more for women and less for men. Not a good combination. It involves billions of dollars just in health insurance. We always said there was discrimination. And finally, in the Affordable Care Act, we found out that the discrimination is that somewhere between 150 to 200% more women were paying for same policies, but there wasn't coverage for maternity in 80% of them. Now that's been eliminated, but only as a statute, which can be reversed. And the glory of the Equal Rights Amendment is that it would be a constitutional mandate that you cannot discriminate on the basis of sex. And I think it's very important that you get this guarantee in Maine. And I really salute your work, your consistency in that work, and hope that you will be successful. All Maine citizens will benefit, women and men, because if you cheat half the human race, you're in reality cheating us all. Thank you so much for your attention, and I do hope that this is a very successful effort. And I know it will be eventually.
Thank you very much, Eleanor Smeal. Committee members, are there any questions? Not seeing any. We appreciate your providing testimony today.
Thank you.
And next, we will hear from Representative Hymanson.
Hello, thank you. Senator Carney and esteemed members of the Judiciary Committee. I'm Patty Hymanson. I represent District 4 in the Maine House, parts of York, Sanford, Wells, and all of Ogunquit. I stand in support of LD 344. When I was on the York School Committee and reviewing updating policy, we sought to reflect current practice in our updates and let discussions go from there. In this arena about equal rights for women, we need to reflect current practice that expects women to be treated equally to men. However, this is not explicitly stated in law. Our most elevated set of laws, our Maine Constitution, needs to say that so that there is no doubt. Despite being in a large public school system in Yonkers, New York in the early 70s, young women like me had no sports teams like my male classmates. I went to Yale, then only recently coeducational. I could not have a credit card unless my father signed for it, not true for my male classmates. Ruth Bader Ginsburg changed that, as we've heard. My medical school class, had 30% women. Now women make up 50% of or more of medical school classes. In the early 80s, the wife of a prominent Boston cardiologist told me that women in medicine would lower the pay of physicians. Women's work was not as valued as the same work men did. Still true. When I took a year off from training to be an emergency medicine doctor at York Hospital here in Maine, then travel around the world by myself with a backpack in 1985, the program director of my residency in New York City refused to write me a recommendation, insinuating that as a woman, I would not return to medicine, that my life was somehow frivolous and home-based. My fellow residents wrote a stellar recommendation for me to convinced him to sign it. My residency class in Boston neurology was mostly men, and although I was on a career path in an academic hospital, I could see no career path that would have given me, as a woman, the flexibility to keep my life balanced. I could see what an uphill battle women physicians had. Here in Maine, with my husband, a cardiologist, I opened my own private practice on the seacoast, recruited other neurologists, raised 3 kids in York, and took care of my neighbors on the seacoast for 26 years. I've been living in Maine for 35. My point in telling you all this is that yes, women can carve out a path for themselves that seems to be easier over time. In my case, the story I just told takes place over 50 years, but the fight remains. And the fight remains in Maine as a reflection of cultural issues. Our most elevated set of laws, our Maine Constitution, needs to explicitly say, so there is no doubt that, quote, Equality of rights under the law may not be denied or abridged by the state or any political subdivision of the state based on the sex of an individual, end quote. I hope you will vote in favor of this bill and of letting Mainers decide the issue on the ballot box. Thank you for your time and your attention. Happy to answer questions.
Thank you, Representative Hymanson. Committee members, any questions? I'm not seeing any. Thank you for being here today and for your testimony. And Representative Arford, you are next. We're not able to hear you, Representative.
My apologies. Senator Carney and respected colleagues of the Judiciary Committee. I am Poppy Arford, representative of District 49 in Brunswick. Thank you so much for the opportunity to offer my strong support for LD 344 resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. I am going to keep my comments brief and do my best not to repeat anything that's already been said. As a longtime patient advocate, I can remember when insurance gender rating was common practice when it came to health insurance coverage. For those of you who are unfamiliar with the term, gender rating is the practice of charging women higher premiums than men, despite the fact that evidence shows women and men have similar lifetime health costs. In fact, in many states, individual market health plans charged women more despite excluding coverage for maternity care. I believe we can all agree that this was an unacceptable and unfair practice. Yes, gender rating and healthcare coverage is now illegal, thanks to provisions in a 2010 federal law that was implemented as part of the Accountable Care Act. Yet this law has been subject to numerous repeal attempts, which, if successful, would remove the legal protections against this discriminatory practice. This is just one example of how, even when we have made important progress in society and in statute, codifying equality in our state constitution remains meaningful and necessary. The principles our society is built upon, however, are not so fluid. We enshrine them in our constitutions as guideposts, and gender equality is one of those principles. It belongs here in our state, in the Maine Constitution, alongside our other cherished rights. Thank you for your consideration of my testimony.
Thank you, Representative Arford. Committee members, are there any questions? Not seeing any. We appreciate your testimony today. Next, we'll hear from Representative Hepler.
Good afternoon, Senator Carney, and wherever Representative Harnett is, and the rest of the Judiciary Committee. I'm Allison Hepler, and I want to speak in support of LD 344. I was going to offer testimony as a historian, a teacher, and a feminist, but I think I'm just going to, in the interest of time, talk about as a historian and a teacher. In my scholarly research on women and workplace health, I wrote extensively about protective labor legislation, which limited the hours and working conditions of wage-earning women. Supporters of protective labor legislation opposed the Equal Rights Amendment, fearing that this amendment, if passed, would eliminate these protections. By 1954, Alice Hamilton, a workplace reformer who had opposed the ERA in the 20s, changed her mind about it, noting that women had made sufficient gains in the workplace and that many of these protections were now extended to male workers. Hamilton, I will note, was 85 years old at the time, and she changed her mind. And so I say that surely Maine residents should be afforded the opportunity to change their minds after the failed vote in 1984. Second, in my U.S. history classes at the University of Maine at Farmington, we recently spoke about the ERA in the context of the 19th Amendment on female suffrage. They seemed puzzled that a national ERA had never been ratified, and I asked them to guess why it had failed in the 1980s and 70s. They couldn't imagine. Women in the military, I said, and unisex bathrooms. They were dumbfounded. They have grown up with these two realities and their world has not collapsed. They need a chance to weigh in on this issue as voters and as residents and as citizens. And so I ask you to give them a chance to vote on a state ERA. Finally, I'll just say we need the talents of everyone in this society. So please vote ought to pass on LD 344. Thank you.
Thank you very much, Representative Hepler. Committee members, are there any questions for Representative Hepler? Not seeing any. We appreciate your testimony today. Representative Copeland, you can go ahead and proceed.
Thank you, Madam Chair. Good afternoon, Senator Carney, Representative Harnett in absentia, and esteemed members of the Judiciary Committee. My name is Lynn Copeland, and I'm honored to represent the citizens of House District 14, located in coastal and downtown Saco. I am here in strong support of LD 344, the resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on sex of an individual, but brought forward by Representative Reckitt, and I thank her for that. Nearly a century ago, the Equal Rights Amendment to the U.S. Constitution had been introduced. Through genealogy research, I've learned that an ancestor of mine was a suffragette all those years ago. Yet here we are, still seeking the obvious: equal rights under the law. If it were given that women already had equal rights, there would be no reason not to put the ERA in our Constitution for our daughters, granddaughters, and for all of our descendants, showing them we are a moral people in a democratic society and believe they have a right to the dignity of being equal under the law. The Maine Economic Growth Council issued its 2021 report, as has been noted, and it points out that significant wage gaps still exist today. They reported that in 2019, Maine females' earnings were 80% of that of Maine males in 2019. In my written testimony, you can see on page 2 of that, there's a chart. The longevity of this fight and the statistics reported here are a reminder that gender equality is not secure, and equal rights and protections under the law are imperative. It is long past due for Maine to join the 26 other states who have adopted equal rights amendments. I urge this community to vote ought to pass and look forward to voting for this historic legislation on the floor of the 130th legislature, giving Maine voters the opportunity to have their say. Thank you.
Thank you very much, Representative Copeland. Committee members, any questions? Not seeing any. We appreciate your testimony. And next we'll have Representative Lookner. And before you start, Representative Lookner, I just wanted to make a final call for representatives and senators who are in the attendee space who want to testify in support of LD 344. If so, please raise your electronic hands and keep them up, and I'll bring you over to the panel shortly. You may proceed, Representative Lookner.
Great, thank you, Senator Carney, Representative Harnett, honorable members of the Judiciary Committee. My name is Grayson Lookner. I represent District 37, which is part of Portland. I'm here today to testify in favor of LD 344 resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination on the based on sex of an individual. In Maine today, women face innumerable challenges to succeed as individuals and to support themselves in our state that are not faced by men. Discrimination on the basis of sex and gender results in pay disparities, housing instability, challenges in accessing appropriate health care, unequal treatment under the law when it comes to seeking justice, and barriers to attaining employment commensurate with experience. These injustices are pervasive and require legislative action. LD 344 would ratify in law that we, the people of Maine, view women as equal under the law and deserve the same rights and opportunities as men. Sex and gender discrimination does not only harm women, however, it harms everyone, including men. Men who wish to spend more time with their families may not be given the same parental leave as women in professional jobs. There's less support for men who wish to work in caring professions like elder care, social work, and nursing, critical areas for our economy that are all desperate for need of workers, regardless of their sex or gender. The expectation that men will be breadwinners of the family creates unrealistic expectations and creates unrealistic expectations and harmful views towards work and the family. These expectations manifest themselves in higher suicide rates, shorter life expectancies, and poorer health over a lifetime for men. Women who find themselves economically dependent on an abusive partner for their material welfare are oftentimes stuck in untenable situations. Since women are usually expected to care for children with few laws mandating that men do their fair share of child rearing, women who wish to escape these situations find themselves at the mercy of their partners for housing, food, and healthcare, with few routes to get out. Since employers are free to discriminate against women when it comes to hiring practices and pay with little or no transparency, the options for women seeking to liberate themselves and to find economic independence may be few. Most troubling, the trauma perpetuated on children stuck in these homes can manifest in adulthood as behaviors that harm themselves, people around them, and society writ large. By supporting women with equal rights, we are investing in the future of our state. I'm proud to be testifying in favor of LD 344 and grateful for Representative Reckitt's work on this, and I'd be happy to take any questions.
Thank you very much, Representative Lookner. Committee members, are there any questions? I'm not seeing any. We appreciate your appearing before the committee today. And next, we will hear from Representative Dodge. And before you begin, Representative, let me just say, I know there are a couple of folks in the attendee room with their hands up, and I just wanted to explain that we're going to take testimony from legislators first, and then we'll call on others. So please, thank you for your patience. And then I would ask any legislators who are in the attendee portion of the meeting who wish to testify to please raise their electronic hands and keep them up if you wish to testify in opposition to LD 344. And with that, Representative Dodge, you may proceed.
Thank you, Madam Chair. Good afternoon, Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary. My name is Jan Dodge of House District 97. I proudly represent the communities of Belfast, Northport, and Waldo. I am here to testify in strong support of LD 344, a resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. I believe you should pass this resolution. Thank you, Representative Reckitt, for your work. Despite the many detours a similar proposal has had in Congress, polls continue to indicate bipartisan support for the premise at the very foundation of LD 344, equal protection under the law. Even under current law, discrimination persists in employment, education, access, and military advancement. I believe this resolution will strengthen discrimination protections. Laws at the state level can easily be erased by subsequent legislatures. Constitutional equality is enduring. I join others here today to urge you to support this resolution. Your action will bring Maine a giant step closer to providing strong legal protection of equal rights to citizens of our state. I do this while thinking of the women in my family who pushed the envelope of gender roles, and especially in honor of my father, who encouraged his daughter and son by assuring us we could pursue any education or career path and be anything we wanted to be. We owe this protection to future generations of all Maine citizens. Thank you for your attention and your support of LD 344.
Thank you, Representative Dodge. Committee members, any questions for Representative Dodge? Not seeing any. We appreciate your testimony today. And next we'll be hearing from legislators in opposition to LD 344. And we'll start with Representative Sue Bernard. And if there's any other legislator who wishes to testify in opposition, please raise your hand and keep it raised and I'll bring you over momentarily. And you can proceed, Representative.
Thank you very much, Senator Carney, and members of the Joint Standing Committee on the Judiciary. My name is Sue Bernard. I represent District 149, and I'm reading the testimony of Suzanne Lafreniere, who represents the Roman Catholic Diocese of Portland in its opposition to LD 344. The diocese has a population of over 279,000 Catholics, or 1/5 of the total population of the state of Maine. The Roman Catholic Diocese of Portland advocates for enacting and enforcing laws that create safe communities and promote the common good. This issue is important to Catholics because as people of faith, a primary concern is the moral and ethical considerations that should be at the root of our decision-making. The Equality Amendment was first introduced in 1923. When under the amendment process, it was approved in 1972 by 2/3 of the members of the U.S. House of Representatives and Senate, a deadline for ratification by the states was inserted, at first 7 years, then extended to 10 years. The ratification fell 3 states short of the 38 needed, and in 1982, the ERA was declared dead. There are now 2 paths that the ERA coalition is trying. One approach is to gain the final 3 ratifications and amend the original congressional time limit. The other is to start over with the vote in Congress and gather 38 new state ratifications. The Diocese of Maine strongly supports equal rights for women. Women should have equal rights in employment laws, insurance, finance laws, family law, disability laws, etc. However, a woman is not exactly the same as a man. The most obvious difference is that only women can bring new life into the world. The ERA website's frequently asked questions section admits that the ERA has been in other states used to force taxpayer funding for abortion. Quote, state equal rights amendments have been cited in a few state court decisions, for example, Connecticut and New Mexico, regarding a very specific issue, whether a state that provides funding for low-income Medicaid-eligible women for childbirth expenses should also be required to fund medically necessary abortions for women that in that government program. The courts ruled that the states must fund both those pregnancy-related procedures if it funds either one in order to prevent the government from using fiscal pressure to exert a chilling influence on women's exercise of her constitutional right to make medical decisions about her pregnancy, end quote. If this bill were amended to protect unborn children, perhaps the Diocese of Portland would consider supporting it. However, as written, there is nothing equal about a law that would require funding that strips away the right to life for unborn children permanently. Thank you for your time and consideration. And Senator Carney, if you would allow me a couple of minutes to express my reasoning for opposing this measure, that would be great.
I wish that you had waited on the other testimony because this is the legislators' time. And if you would like to have 1 minute to address us now regarding your own testimony, that's fine. But next time, if I would appreciate a heads up if you're going to be reading somebody else's testimony instead of giving your own. Thank you.
Okay, I actually did write that in the information. I don't know who gets that information, perhaps the clerk. And I spoke to the clerk this morning, so I apologize. I didn't realize how this was supposed to go, but I mentioned that this was initially what I was asked to do.
Okay,
So I'll go on and make this real quick.
Thank you.
Promise to make
Appreciate
it quick. Okay. First, let me say that the efforts on behalf of LD 344 are obviously honorable and historic, but we also need to look at the practical outcomes of passing the ERA. As has been mentioned, the Equal Rights Amendment, equal rights already exist. Both women and men already have equal rights under the 5th and the 14th Amendments. There are already many laws in virtually all areas of American life, including education, employment, credit eligibility, and housing that prohibit sex discrimination. No doubt most women over a certain age, including me, have a story or two about cultural unfairness that had to be endured in the workplace or education, for example. But I can see and witness that this is fading. When I ask my 28-year-old daughter if she has ever felt discriminated against, she says no. The Maine ERA would threaten church tax-exempt status. Hundreds of churches in Maine will very likely be faced with a dilemma: either change their doctrines, policies, and practices regarding male-only clergy, or risk losing their tax-exempt status. Also, there would be unintended consequences with the ERA, but a big problem nonetheless. Auto and life insurance costs for women would very likely increase, regardless of statistical evidence showing that women live longer than men or that women have better driving records. Women would likely have to pay the same higher rates as men because otherwise it would be discriminatory. The Maine ERA would supersede Title IX. It would permit males and females to compete for inclusion on the same sports teams. In other words, the Maine ERA would end boys only and girls only sports teams, including contact sports, so boys and girls would be on the same team. It would jeopardize privacy and safety. Traditional male and female bathrooms, locker rooms, hospital rooms, rooms in nursing homes, etc., would be abolished because under the ERA, women and men, boys and girls, must be treated as indistinguishable. This would seriously jeopardize the privacy of our children, our elderly, and hospital patients. And the Maine ERA would impact the prison system by integrating it. According to the Supreme Court Justice Ruth Bader Ginsburg, male and female prisons would become integrated and result in harsher discipline for females, since they would be required to be treated in the same way as men. For these reasons, I ask you to oppose LD 344, and I thank you very much for allowing me to testify and get this on, and I have learned my lesson. Thank you very much, Senator.
Yeah, thank you. And in the future, if you can just send me an email directly, that would be
absolutely
helpful as well. Thank you. Committee members, any questions for Representative Bernard? Not seeing any. Thank you for your testimony. And next we'll hear from Stacey Guerin, Senator Guerin.
Thank you, Senator Carney, and esteemed members of my former Judiciary Committee. I am Senator Stacey Guerin, representing District 10. I am here to testify in opposition to LD 344. Since the introduction of the ERA effort nationally over 50 years ago, numerous states and federal laws have been passed to prevent discrimination against women. In the meantime, courts have interpreted some state ERAs in ways that supporters of these measures never imagined. While I support equal rights, I am concerned about the unintended consequences of the Federal Equal Rights Amendment, as well as LD 344. Here is what can happen to Maine's women if ERA becomes part of the U.S. Constitution or the Maine state constitution, as LD 344 seeks. It can be used to require the military to force women to serve in combat and be drafted into the military. ERA can make taxpayer funding of abortions a constitutional right. The New Mexico Supreme Court ruled that the state's ERA requirement requires New Mexico taxpayers to pay for abortions under the Medicaid program. The Susan B. Anthony Group, true to Susan's convictions, continues to fight to protect unborn babies. LD 344 can be used to remove all legal differences between men and women, thus affecting everything from room assignments in hospitals to housing in prisons to colleges with all male or female dormitories to women's sports. At-risk women, shelters, psychiatric hospital, and prison settings would thus have the added burden of fearing the loss of privacy in their living space, in their bathroom, and in their bedrooms. The differences are important, as evidenced by the current controversy at the University of Pennsylvania. Leah Thomas, a biological male swimmer at the University of Pennsylvania, did not rise to the top of male competitions, but once allowed to swim in female events, has broken many college women's swimming records. The Washington Post reported in October that her fastest 200-yard freestyle time before this year was 1 minute 39.31 seconds. This season, Thomas posted a 1 minute 41.93 seconds, a 2.6% drop. That's the fastest of any other female college swimmer this year, 0.64 seconds faster than Olympian Tori Hawk. If you have watched swimming events and know of close finishes, imagine what Thomas won at December 21 event by 38 seconds over the second place finisher. Now let's imagine the ERA law that would seek to end all distinctions between male and females. It would force the end to women's basketball. The NBA would be illegal. Envision women and men playing for the limited spots on basketball teams. Do you foresee many women playing in the NBA, in college? The Equal Rights Amendment is a poorly worded amendment to the U.S. Constitution that would restrict all laws and practices that make any distinctions based on gender on account of sex. Under ERA, men and women could not be treated differently. Even if the different treatment is due to physical differences, men and women would thus compete for teams, jobs, resources, and benefits. The ERA can also be used to impact insurance rates that distinguish between men and women. Justice Ginsburg listed 800 laws that would change with the acceptance of the ERA, including spousal benefits, Social Security, child support. It can be used to attack single-sex organizations like fraternities, sororities, single-sex schools, and the Girl Scouts. Title IX victories and gains for women would be immediately deleted. I believe we can do so much more for the women of Maine.
Senator Guerin, I'm sorry to interrupt. You're about a minute and a half over. If you could just wrap up, please.
Oh, okay. I am coming right to my closing.
Thanks.
In closing, the women are already protected by the powerful and immutable language of the 14th Amendment of our Constitution, which reads in part, "No state shall make or enforce any law which shall deny any person within its jurisdiction the equal protection under the law." Women do not need ERA for equal rights. The 14th Amendment has successfully been used in cases of discrimination to protect the rights of women and will continue to do so. Instead of passing another law, people simply need to acknowledge the unique nature of women and our skills and accomplishments. And I'd also like to say hi to Soupy and Peggy, my favorites from my years on judiciary.
Thank you very much, Senator Guerin. And with that, I think that is all of the, well, actually, there's one other legislator who will, let me send you back to the attendee space, Senator Guerin. Appreciate your testimony. And then we have Lori Osher, who is a legislator. And if there's any other legislator who wishes to speak for, against, or neither for nor against, please raise your hand and we'll bring you over. We have two other legislators, and then I will move on to other members of the public. And Lori Osher, you can please activate your camera and begin your testimony.
Thank you, and my apologies for coming late. Good afternoon, Senator Carney, Representative Harnett, although I don't see him here today, esteemed members of the Judiciary Committee. I'm Lori Osher. I represent part of Orono in the Maine House, and I'm here today in strong support of LD 344. And I support Lois Reckitt's, Representative Reckitt's tirelessly. I'm glad that she tirelessly brought this to the attention of the Maine legislature. Maine is a leader in many ways. When it comes to women's leadership in Maine, we've had some firsts. In my own town of Orono, Edith Patch was the first woman to serve as the director of the State University's Agricultural Experiment Station. She was hired in 1904 after working for free for a year, but was then the first director of an ag experiment station that was a woman. Margaret Chase Smith was the first woman elected to the Senate without first being appointed to fill an open seat. When she went to DC in 1922 and served 4 terms, 24 years, the longest service of a female US Senator until Maryland elected Barbara Murkowski to a 5th term in 2012. But when it comes to voting for policies that will provide equal rights for women, we have so far come up short. This resolution, simple yet critical, protects Mainers from discrimination on the basis of sex. Some may believe that discrimination against women does not exist in Maine, but there are many instances that prove its existence today. The 2020 report on the status of women and girls in Maine, produced by Maine's Permanent Commission on the Status of Women, found that Maine women will have to wait till 2060 to see economic security on par with men if pay trends continue at the present pace. The report details that overall, Maine women still disproportionately struggle for economic security, experience domestic and sexual violence, and lack access to health care. I have my own experiences of discrimination on the basis of sex and the difference that policy changes make in the pace of change. As a small child, it was clear to all that both my brother and I were athletic. We skated at the local ice skating club, and we were both hoping to play ice hockey, but girls were not allowed to play ice hockey. This was before the passage of Title IX. I became a figure skater, and I played field hockey in junior high and in high school, and I later raced bicycles, all the time wanting to play ice hockey. My brother played ice hockey starting as a mite, that means under 8 years old, and went on to become a high school ice hockey star and captain of his high school team. I enjoyed being an athlete, but was denied the chance to build skills and become proficient in a sport of my choice because of discrimination based on the basis of sex. Then something changed. As a college student at Cornell University, I went skating one day and was invited to join the women's ice hockey team. The team, which had previously been a student club, now had the support of the university, a locker room, coach, scholarship for the top player because of Title IX. It was the late 70s and there weren't many women who played ice hockey. That's why the coach invited this figure skater to join the team. I was fast, but I wasn't very good at stick handling, an important skill for getting the puck to the net. So I played defense. My job was to use my blades to keep the pucks that were shot by the other team out of our net. Throughout my life, I've had similar experiences. I was the first woman to be accepted in the soil science graduate program at North Carolina State University to work with Stanley W. Buell, the project to complete an independent research project in the Amazon basin of Peru. At the time, Dr. Buell was the foremost scholar of soil genesis, morphology, and classification in the US. Upon finishing my degree, Dr. Buell told me that he had never read the applications of women who applied to work with him before the year I applied. What changed? A new administrator insisted that the practice of not reading applications of women candidates was a violation of Title IX, and it had to stop. He encouraged Dr. Buell and each faculty member in soil science to accept one woman into the research group that year. Like the bill before you, the text of Title IX is simple. It begins, no person in the United States shall, on the basis
Representative Osher?
Yes.
You probably are not aware that the 3 minutes is up.
Oh, I'm so sorry.
Just, complete your testimony. We'd
All
appreciate
right.
it.
My apologies. I'm sorry it's so long. I will just say that that I was accepted because he basically told me that because I played ice hockey, he thought I could do the job. And so Title IX then wrapped around again. And so what I want you to do is to support this resolution because it's a first step. It will take many years for it to become part of the culture, but it's a first step. Please vote and support and give Mainers the opportunity to vote for equal rights for women. Thank you for your service on this committee, for allowing me to speak to you today, and thanks in advance for your support of this legislation.
Thank you, Representative Osher. And Representative Libby, did you have a question? Go ahead.
Yes, thank you, Madam Chair. Thank you for being here today, Representative Osher. Just a quick question. Do you believe that it is important to keep Title IX intact as it currently stands?
I'm not prepared to talk about Title IX today. I'm just giving you my experience that when policy changes, it opens opportunities, and those opportunities, some people don't even realize that out of all of the top women, and there are top women throughout the country at the time I applied, the fact that I was allowed to play hockey was the thing that opened the door for me. And so what I'm saying is that when we make a simple policy when we make a simple policy change, it has a lot of implications. There's been discussions about piles of negative implications.
Osher.
It's a positive thing.
I specifically want to know, very simple, just yes or no, but if you're not prepared to speak to it, that's fine. Thank you so much for your time today.
Had you completed your answer, Representative Osher?
Yes, I'm not prepared to talk about Title IX, but I use this as an example that a very simple policy change can have large implications for the status of women and for opportunities for women. And obviously in the future it will be for parity in pay and other injustices that we're suffering now that we would hope would change.
Thank you. Any other questions for Representative Osher? Not seeing any. We appreciate your testimony. And Representative Grochowski, you are, I think, our final legislator presenter today. Go ahead.
Thank you so much. Thank you for the opportunity. I didn't plan to be the final legislator, but I hope that my testimony will ring as loud and clear as those who came before me. It is wonderful to be with you, Senator Carney, Representative Harnett, and honorable members of the Committee on Judiciary. I appreciate the opportunity to share my support for LD 344. While there is much that I could say about this proposed legislation, I am sure that there are many who have spoken before me, as well as those who will come after, who have been or will be more eloquent. One of those who came before was the Honorable Margaret Chase Smith of Maine, who served in the United States Senate from 1949 to 1971, after having served in the United States House from 1940 to 1949. Senator Smith was a co-sponsor of legislation for a federal equal rights amendment, and she spoke to her position on the floor of the Senate on January 23rd, 1950. Thank you to the excellent library staff of Skowhegan's Margaret Chase Smith Library. I have that speech, and I would like to take the opportunity to read it to you now. It reads as follows. Mr. President, I am for the proposed Equal Rights Amendment to the Constitution for the very reason that some women are against it. Throughout my service in Congress, I have clung steadfastly to the belief that when women demand equal rights with men, they must give up their special feminine privileges. I have urged that on all women's legislation, because women are just as subject as men to the old saying that you can't have your cake and eat it too. But in being for this equal rights measure, I can appreciate some of the difficulties. These difficulties must be overcome. It may take time, but the more we delay, the harder it will be ever to achieve this objective. This is not a petticoat measure. It is a measure designed to give fuller meaning and expression to the traditional American way of life. We have heard a great deal about civil rights and no discrimination against anyone because of race, color, or creed. I would add one thing to that: no discrimination code of civil rights, sex. I say that there should not be any discrimination against any person because of race, color, creed, or sex. But I say with equal conviction that neither race, nor color, nor creed, nor sex must be permitted to be the basis for agitation for special rights and special treatment under the guise of no discrimination and equality. There is a danger of losing balance on this subject, and in our zeal for equality, to unconsciously demand and grant special treatment and privileges over and above equality. I think that it is high time that we stop thinking of women as being second-class citizens, as people with less qualifications and secondary in priority. There should be no such thing as priority for or against women or men. I think that the most effective argument for equal rights is summed up in three simple words: women are people. Think that over just a little, and you will see the justice and overwhelming merit of the equal rights measure. In closing, I want to pay my respects and express my appreciation to those senators who are going to vote for this measure, even though they do not believe in equal rights. In the first place, I respect their opinion, even though they differ with me. But more than that, I admire the fair and unselfish attitude that they have taken by saying that they are voting for this measure so that it can be referred to the states for ratification or rejection to give the people of America a more direct vote and voice on this issue. Some of these senators will fight the equal rights back in their states on the question of ratification or rejection, but by male standards, they will have manfully faced an issue rather than bottling that issue up in Congress without the states having had an opportunity to voice themselves on this proposal. Thank you all for the opportunity to let me share with you Margaret Chase Smith's speech. That is the conclusion of the speech that she read back in 1950. 71 years later, I think it still resonates. Indeed, the more we have delayed, the harder it has become, though no less necessary, as I'm sure you've heard. In society, we find examples of women still being thought of as second-class citizens. And I just would finish by urging you, as Senator Smith did to her colleagues, to approve this legislation to allow Mainers to have a say on this matter. We should not bottle this up any longer, and instead let us act in 2022 to finally give voters an opportunity to voice themselves on this proposal. Thank you so much, and I'm happy to take any questions.
Thank you, Representative Grochowski. Committee members, any questions? I'm not seeing any. We appreciate your testimony today. With the conclusion of the legislators' testimony, we're going to ask, now we're going to take the testimony in support of LD 344, and we'll probably take a quick little break at 2 o'clock, and then we'll continue with any other supporting and then any opposing testimony, and then neither for nor against. And so if we could have anybody in the attendee part of the meeting who wants to testify in support, please raise your hand and keep it raised until after you've testified. And we are going to begin with Mary Bonato and then with Attorney General Aaron Fry. And so Mary Bonato, if you'd like to begin. Welcome.
Thank you so much, Senator Carney, the absent Representative Harnett, can't see him, distinguished members of this committee. Good afternoon. Happy New Year. I'm Mary Bonato, an attorney at GLBTQ Legal Advocates and Defenders. And I'm here testifying on behalf of LD 344, on behalf of myself, and also on behalf of Representative Rachel Talbot Ross. We are submitting this testimony together as one way to symbolize the necessary struggle to see all women as equal and to move forward from some past mistakes where racism was part of the women's suffrage movement, the failure of the women's movement to address voter restrictions, and also the resulting racial and generational disparities. So we support this resolution for 3 reasons, and with enormous thanks to Representative Breckett for carrying this flame forward. First, we believe that our basic charter, our basic rules must be updated to be consistent with our values. In 1963, a state commission, constitutional commission, recommended including, quote, sex, race, religion, and ancestry in what would ultimately become Article 1, Section 6A, which is an equal protection, due process, civil rights provision. Suffice it to say, the enumeration didn't make it, but the enumeration is exactly what would have provided the specificity to show that the state has to be attentive to historical marginalization. I also want to say that, as the governor and others referred to, our state ratified the ERA in 1974, which again is not currently in effect. And I'd like to think that so much has changed that calls for updating. Certainly in the 1960s, when a legislator objected to the specificity in Section 6A because women would be able to apply to Bowdoin College, certainly rings of the past. We also want to say that we hope that the sponsor would consider some additional updates to enumerate other characteristics where The manifestation of those characteristics calls out discrimination, including racial and religious discrimination, tribal and indigenous membership, LGBTQ people, and so on. But beyond this, I want to just mention two other reasons. One, this amendment is substantive. You've heard about that from others. It's also in our testimony. I will say that a constitutional amendment provides guidance to lawmakers, to public officials, and to the public about what is and is not permissible. Sex discrimination cases at the Human Rights Commission consistently range in the 20% or up range of filings there, as well as with sexual harassment. And you can see from the case law and from reasonable grounds findings that there are still plenty of assumptions out there about the proper roles of men and women that end up limiting opportunities for people and denying them basic freedoms. The third thing I would say quickly is that Maine can't change how the US Supreme Court interprets the 14th Amendment sex discrimination guarantee. And the Supreme Court under enforces constitutional norms, but what Maine can affect is how Maine interprets its own equal protection guarantee. And that's in part what this is about, is Maine's values and how seriously we take sex discrimination. And the last thing that I'll just say, just in the interest of full disclosure, is that this would obviously have implications for LGBT people. And I say that because in June of 2020, the Supreme Court, in an opinion by Justice Gorsuch, accepted an argument that had long been raised that when you discriminate against a person because of their sexual orientation or gender identity, it is an aspect of sex discrimination, that sex is inextricably involved. And I put more about that in the testimony rather than take time here, but I would just say that it would have that effect as well, for good or for ill, from our perspective, for good. And so in the end, we just strongly encourage this committee to pass this and allow the voters to make the decision should they want to update our Constitution in these ways. Thank you very much.
Thank you very much, Mary Bonato. Committee members, any questions? I'm not seeing any. We appreciate your testimony here today.
Thank you so much.
And next we'll hear from Attorney General Aaron Fry.
Thank you, Senator Carney. Good afternoon to you and to members of the Judiciary Committee. My name is Aaron Fry. I have the privilege of serving as Maine's Attorney General, and it is my pleasure to testify in support today of LD 344. As you all know, the Constitution of the state of Maine is the primary legal compact between the state government and its citizens. This document not only contains the structure of the government that the people have consented to be governed by, but importantly, it contains numerous rights that Maine people over time have deemed important enough to require preservation by the state government. These rights include religion, speech, the right of citizens who are accused of crimes, the right to bear arms, which of course was amended as recently as the 1980s, and most recently, the right to food. And so while it is true that there are state laws that would protect against sex discrimination, these laws are neither as extensive nor as permanent a protection that the constitutional amendment that's proposed in LD 344 would provide. And Maine can do better to advance equality of the sexes by putting this question out to the people of Maine. You know, for almost a century now, there's been an effort underway nationwide to pass an ERA. That's been referenced today. And in fact, it was January 18th of 1994, almost 48 years ago to the day, that the state of Maine voted to ratify a federal equal rights amendment. The hope in ensuring that the sexes were treated indiscriminately that motivated that vote almost 48 years ago is still unrealized today on the federal level. And Maine has the opportunity, regardless of what happens on the federal level, to pass its own right, codify its own right within its constitution. And that's exactly what at least 26 other states have already done in their own constitutions. In my written testimony, I provide a footnote with those states. I would just highlight that these states include states like Hawaii, Indiana, Louisiana, Texas, New Hampshire, Colorado, Pennsylvania, Wyoming, states that range in terms of their political sensibilities they have included enactments in their constitution guaranteeing equal treatment of the sexes. So finally, this decision on whether or not this right belongs in the Constitution really belongs to the people of Maine. But the legislature has to vote to give that ability for Maine citizens to vote on whether or not this legal compact with its government should have this right. I ask you to please pass LD 344 and provide the opportunity for Maine citizens to register whether or not this is a right, along with speech, along with food, along with the right to bear arms, to include in the Constitution. And just finally, because I've heard it referenced, all those rights that I mentioned, you all probably also recognize there are restrictions that the state is able to put on the exercise of those different rights. So please keep in mind that really by adding this to the Constitution, not only does it elevate the right to make sure people are thinking about how important this not discriminating on sex is, but please also consider that it really just means that the state will be subject to more scrutiny by a court if it seeks to discriminate based on sex alone. My thanks to the Representative Record for proposing this. I have certainly learned from her 50 years of work on this. I hope you will as well. Thank you, and I'm happy to take any questions.
Thank you, Attorney General Fry. Are there any questions? Representative Thorne, go ahead with your question.
Thank you, Madam Chair. Attorney General Fry, is there currently a vehicle in place to ensure equality, equity, and non-discrimination against women?
Well, in the state of Maine, there are statutes that have been passed that do allow for remedy when a woman may be treated differently than a man based on gender. Those statutes are subject to change. I think other speakers have talked about that vulnerability that statutes have that constitutions do not have. And some detail about that might be available. I did see that the executive director of the Maine Human Rights Commission's on. She could probably talk a little bit about those as well. But again, they don't go as far as enshrining this in Maine's social compact. Its constitution does not go as far as the constitutional right would.
Thank you. And maybe that's a workshop question better suited. So thank you. Thank you, Madam Chair.
You're welcome. Any other questions, committee members? Thank you for your testimony today, Attorney General, and for your answer to the question as well. And next, we'll hear from our Secretary of State, Shanna Bellows.
Good afternoon, Senator Carney, distinguished members of the Judiciary Committee. If I were in person, I'd be bringing you candy as a former member. So this is my IOU. I am Secretary of State Shanna Bellows, providing testimony in support of LD 344. As the keeper of Maine's Constitution and the 50th Secretary of State, but the first female Secretary of State in over 200 years of our state's history, I'm particularly familiar with some of the ways that women in our equal status were left out of early drafts. On my wall behind me is a copy of the original Maine Constitution, including the duties of Secretary of State. And the section of the Constitution on the Secretary's role, the office I now hold, was written entirely with he and his pronouns. Our founders could not even conceive of someone like me holding this office. Behind me, also on my wall, is a portrait of the first female elected to the US Congress, Jeanette Rankin of Montana in 1916. 4 years before the 19th Amendment guaranteed women the right to vote, but shortly after Montana had passed the right to vote for women. Constitutional amendments matter. Since we passed the right to vote in 1920, we have made incremental progress toward gender equality under the law. But discrimination is not a thing of the past. It is not something only for the history books. As a young woman, I discovered inadvertently, not once, but twice, that I was being paid less than men in the same job, with the same title, with the same level of experience. Pay discrimination, we know, is alive and well because of the data that women but especially women of color and Indigenous women earn less per hour than their male counterparts. We are also witnessing today, even during the pandemic, disproportionate impact on women and women of color. We need every tool in our toolbox to fight for and to achieve full equality and to stop those who would work against it. Our Attorney General listed the states who have equal rights amendments in their own constitutions. And I just want to go off my testimony to address for a minute the potential unintended consequences that were raised that are simply untrue. When you look at those states, when you look at California, for example, home to Stanford, who won the 2021 NCAA Women's Basketball Division I championship, you see it clearly that an equal rights amendment to the Constitution, just as in California or Louisiana or Montana has not harmed women, it would not harm women here. It would only help us. Thank you.
Thank you for your testimony, Secretary Bellows. Committee members, are there any questions? Not seeing any. We appreciate you coming to the committee today. We'll look forward to those treats another time.
Thank you.
I just want to give everybody a little update. We are going to hear from Dean Lee Softly and Executive Director Amy Sneerson, and then we're going to take a short break just because we've been meeting for 2 hours straight. So we'll continue with Dean Softly. Welcome to the committee.
I am remembering to unmute myself. Thank you so much. Good afternoon, Senator Carney, all the members of the Joint Standing members on the Judiciary. I want to thank you for your patience and your attention to this really important issue this afternoon. My name is Lee Ingalls Softly. I'm a resident of Portland, and I want to be clear that I'm speaking today in my personal capacity. I do not appear for or represent the University of Maine Law, or any other institution. I speak today in support of LD 344, the resolution sending to the people of this great state the opportunity to make the Equal Rights Amendment a part of the Maine Constitution. And I commend Representative Reckitt for her unflagging commitment to this cause. Having had the honor to work with so many of you through the years, I know that you're aware of my background, but I want to emphasize that I am a lifelong resident of Maine. I grew up in South Portland, started my legal career in Ellsworth, spent many years working in Augusta, and then had the great good fortune to work in the courts throughout this amazing state, from Madawaska to York, from Farmington to Belfast. In all of that time, I've watched as this state that I love has consistently moved toward equality in all aspects of its connections to Maine people. I use the phrase moved toward equality advisedly because despite so many efforts from so many people over so much time, we're not there yet. In my particular profession, progress has been real but not complete. When I graduated from high school, there had never been a woman on any of the state courts. Women now comprise almost a third of the state court judges. When I began in legal practice in 1980, women were relatively new to the profession. Law school graduating classes are now routinely more than 50% women. Notwithstanding that progress in one particular field, however, women as a group still struggle with employment and salary parity. Women of our BIPOC community in particular find challenges in achieving equality. Violence against women remains an almost intractable challenge, and childhood hunger statistics are a reflection of the challenges that parents, often mothers, struggle with consistently. Discrimination on the basis of sex has also been addressed with regard to the LGBTQ+ community, but again, we are nowhere near done. In its entirety, the language proposed to be added to Maine's Constitution provides a truly unremarkable concept. Equality of rights under the law may not be denied or abridged by the state or any political subdivision of the state based on the sex of an individual. In my experience, This state has been and should continue to be a leader in the fight for equality for all people. Every day, all of you and the members of the legislature work to assure that Maine's laws are designed to be fair, just, and applied equally. I'm incredibly proud of the way Maine has moved forward, but until women are treated equally in employment, pay, education, healthcare, we will not be done. I urge you to help us enshrine this commitment to equality in the Maine Constitution. It is long past time to stand up for the right for all people to be treated with equality. Thank you. I'm happy to answer any questions.
Thank you very much. Committee members, are there any questions for Lee Softly? I'm not seeing any. Thank you so much for testifying before the committee today.
Thank you.
And then we'll have Executive Director Amy Sneerson, and then we'll take a 5 or probably a 10-minute break, and then we'll return and take the remainder of today's testimony. And with that, you may begin.
Thank you. Good afternoon. No pressure standing between you all and a break. My name is Amy Sneerson. I'm the Executive Director of the Maine Human Rights Commission. We're the state agency that enforces Maine's anti-discrimination law, which says it's unlawful for a person to be discriminated against based on sex, which for a lot of folks who oppose a proposal like LD 344, they say, well, it's already taken care of. Why do we need this proposal? I'm here to tell you that 50 years after the Maine Human Rights Act was created, and almost 50 years, well, so 1971, the act was created, 1973, sex was added as a protected class. The fact of sex discrimination is very present. The Maine Human Rights Act, as so many folks who spoke here today, and it's truly an honor to be here with so many people who are talking about this topic. The Maine Human Rights Act and parallel federal laws do not cover all areas of our lives. They cover discrete areas that, as a matter of social policy, Maine voters and legislators have decided should be subjected to law. It's unlawful to discriminate in some employment, in some housing, in some places that are open to the public, in some education, in extension of credit. Outside of those delineated parameters, the default is that sex discrimination remains legal. That's just the default. The Constitution was created by men for men, and that's been talked about. And the default is that discrimination that is not prohibited is legal, and that should change. State laws can and do change, as the governor noted earlier, and I thought it was a good choice of words, that the Maine Human Rights Act's protections are ephemeral. They can change with the stroke of a pen. Policy decisions change as social beliefs change. And we've made a lot of progress. I view it as progress in protecting the rights of people to be free of discrimination because of something that they don't choose about themselves, their sex. But that's only been 50 years worth of our history. For the 100 years before that, our Constitution didn't say anything about it, and that should change. There are a lot of carve-outs within the Maine Human Rights Act that don't apply the ban on sex discrimination. The parade of horribles that some folks mentioned before that would come to pass, that boys and girls would be indistinguishable, there'd be no boys and girls sports, and there'd be no privacy. Those I think are based on fear, which I can understand, but I don't think that they should be a barrier to Maine citizens deciding for themselves what their policy should be. So with that having been said, I'm happy to answer any questions, and thank you for your time today.
Thank you very much. Committee members, are there any questions for Amy Sneerson? I'm not seeing any. Thank you for providing testimony today. And let's see, to committee members and those waiting to testify, Representative Thorne, did you have a question?
No, Madam Chair, I just wanted to mention that I have an emergency dental appointment for a tooth that I broke last night, so I won't be here after the break.
Okay, thank you for letting us know. So committee members and members of the public, we will take a break until 2:10, and then we'll resume and we'll continue with those in support and then in opposition, and then neither for nor against this legislation. Thank you. Hi, committee members. Representative Libby, it looks like you are signed in twice. I don't know if, are you having, is that part of your resolving your technical difficulties?
I have no idea how I could possibly be signed in twice. I'm only on one device.
Okay.
I'm sure that it is. Oh, it's.
Oh, it's Representative Hagan. Never mind.
I couldn't find the address and Laurel was kind enough to give it to me. So it's nice to see your faces.
Yeah, it's nice to see you as well.
I just got rid of those snot-nosed brats, so we're all ready to go.
Would you like to introduce yourself, Representative Hagan? We did introductions this morning.
Yeah, right now?
Yes, go ahead.
I'm Dave Hagan, represent House District 101, Hampden and Newburgh. Thank you.
Thank you. And now it looks like a couple of committee members still need to rejoin us, but at this point I will bring some additional people onto the panel in order to provide testimony in support of LD 344. And let's see, we're going to bring in Mariah, Nathan, and Barbara. And I think, okay, and Mariah, you may proceed with your testimony.
Thank you. I am honored to have the opportunity to speak on the matter of LD 344, and I'm even more honored that Representative Lois Reckitt has invited me to speak. Thank you, Representative. I am Mariah LaRock. I've been a resident for Maine for 5 years, and I am proud to call Maine my home. I'm a recent graduate of the University of Southern Maine, where I earned my bachelor's degree in theater, and I now work as an actress and a screenwriter. I'm also an advocate for child sexual exploitation awareness and work directly with a nonprofit that combats human trafficking and exploitation right here in Maine. This cause is close to my heart because I'm a survivor of child sexual exploitation. But I am also your Miss Maine 2021. As the current state representative of the Miss Maine Scholarship Program and an ambassador of the Miss America organization, I am part of one of the biggest women empowerment organizations whose mission is to prepare great women for the world and prepare the world for great women. Not to mention that Miss America is the largest scholarship provider for women in the world. Since 2014, I've earned $36,000 in scholarships to afford my degree and further my education. I've also had the opportunity to hone a variety of skills like public speaking, volunteer thousands of hours towards community service initiatives, gain interview skills, and so much more. This organization is truly committed to its mission. But it is because of the dedication, passion, and steadfast fight of women that paved the way before me that I am able to stand here and say that I am all these things, that I can do all these things, and that I want other women to be able to have the same opportunities as me. I know that the many female leaders and lawmakers of Maine who are with us today resonate with the mission of my organization because they have become great women of this world, and they continue to prepare the world for great women and great women leaders. What we are asking for is to continue to do this with full confidence, knowing that the women who are prepared, let's just say, to work in the state of Maine won't earn 80% of the salary of a male colleague. We are asking to increase the opportunity of our female legislation representation, which currently stands at 38%, to be one that is more representative of the 51% female population of the state. How can we do this? Through legislative promised equity. LD 344 ensures women statewide that their opportunities will not be impacted based on their sex or gender. Some people believe that this is already the case because it feels so fundamentally obvious that when equality rights laws were passed, that it guaranteed permanence. But today we have the chance to follow through with the promise of permanence of equity for all. I am the same age that Lois Reckitt was when she first started to advocate and work on equal rights. I don't believe that there could be a greater testament to the importance of a cause than to know someone who has spent their life and continues to spend their time relentlessly pursuing its success and fruition. I implore you to support LD 344, amending Maine's constitution so we can finalize a simple and impactful promise that equity is truly ensured for all. Let's continue to prepare great women for the world and prepare the world for great women by fulfilling a promise that she will be viewed as equal in her pursuit of happiness, success, and safety throughout her life. Thank you.
Thank you for your testimony. Committee members, are there any questions for Mariah LaRoque? Not seeing any. We appreciate you being here today.
Thank you.
And next we'll hear from Barbara Cray.
Yes, hi. My name is Barbara Cray. Thank you for this opportunity to speak in favor. I'm an attorney and a filmmaker and a resident of Westport Island in Lincoln County. Last year, I produced a documentary on the women's suffrage movement that was aired on public television. And to do so, I did a deep dive into the history of the battles for women's rights and learned of the enormous sacrifices of women to obtain rights for women. And so it was almost 175 years ago at the first Women's Rights Convention in Seneca Falls that Elizabeth Cady Stanton put in her Declaration of Rights and Sentiments, borrowing from the Declaration of Independence, this language: "We hold these truths to be self-evident that all men and women are created equal." This language was considered scandalous for its time since women had no rights at all, but it was responsible for starting a movement for equality, which sadly still continues today. It took almost 75 years for the 19th Amendment to the Constitution to be ratified, stating that the right to vote shall not be denied or abridged on account of sex. Women's suffrage leaders knew the fight for rights was not done, and in 1923, Alice Paul proposed the first Equal Rights Amendment as a constitutional amendment. Despite being introduced in Congress almost every year, it was 50 years later that the ERA was passed by Congress. Now the future of the ERA is languishing in the US Senate. But states have acted by enacting equal rights amendments into their constitutions, and I urge this body to allow the people of Maine to do the same. Maine has a great history of women leaders. Margaret Chase Smith was the first woman elected to both the US House of Representatives and Senate. Governor Mills being the first woman elected as a district attorney in New England, and then the first woman attorney general and now governor of Maine, joining just a handful of other women leading their states. Maine has strong women leaders in business, like trades, lobstering, foundations, and the like. But I wager that each of these achieving women will tell you that they work twice as hard as their male counterparts, get half the credit and half to 3/4 of the salary at some point, if not many points in their lives of achievement. Women achievers have to work so much harder to overcome obstacles caused because of their sex. This cannot be the future for the young women of Maine. There's one other factor that has arisen since this bill was last considered by this body, and that is that from under the rocks have emerged far-right neo-fascist militant male organizations who are self-proclaimed Western chauvinists who want to prevent rights for women. Constitutional protection of equality in our state is all the more necessary as our democracy is being so publicly challenged. Thus, this committee should not allow politics to interfere with the right of the Maine people to vote on this issue. Please give the citizens of Maine the vote on a state constitutional amendment stating that the equality of rights cannot be denied on the basis of sex in the state of Maine. And I look forward to voting for this in the fall. Thank you for your time and attention.
Thank you very much for your testimony. Committee members, are there any questions for Barbara Cray? Do you have one question for you? You referenced a movie that you had produced, I believe. Yes. Could you give us the title of the movie and where we could watch it?
Sure. It was shown on Maine Public in August in connection with the 101st anniversary of the 19th Amendment ratification. It's called Votes for Women, The History of Women's Suffrage Through Song. And it hopefully will return to public television in March for Women's History Month.
Thank you very much.
Thank you.
Any other questions, committee members? Not seeing any. Thank you for being here today.
Thank you.
And Nathan Walsh, you may begin your testimony.
Thank you, Madam Chair. Senator Carney, thank you for having me and members of the committee. My name is Nathan Walsh. I'm a resident of Freeport. I'm also an assistant district attorney in prosecutorial district 3, where I'm primarily charged with prosecuting human trafficking offenses and domestic violence cases. So the majority of my caseload involves violence against women. And I come before you today to urge you to vote that this bill ought to pass. In my role as a prosecutor, I get the distinct privilege of getting up in front of a jury and say, my name is Nate Walsh and I represent the state of Maine. In order to get that job, I had to take a solemn oath that I take extremely seriously, that I would support the Constitution of the United States and of the state of Maine, which is an oath that all prosecutors take before they can fulfill their duties. And I think I think you're all familiar with that oath as well. So taking an oath about the Constitution means something. The Constitution being the supreme law of the state. So I think that amending the Constitution to allow a provision to prohibit discrimination is an important step that needs to be considered, and that decision should lie with the voters of the state of Maine. I would also encourage the committee to consider adopting Title V's Human Rights Act and the language of that act and those protections to move beyond not just sex, but also onto race, color, sexual orientation, gender identity, disability, religion, all those protected classes that we have in Title V. New York has adopted a similar stance in amending their Equal Rights Amendment bills to expand it beyond just the basis of sex. But for today's purposes, I come before you to say that it's important for us to consider non-discrimination, and that we should allow the people of Maine to decide on the issue of our constitutional protections. And I ask you to vote that it ought to pass.
Thank you very much, Nathan Walsh. Committee members, any questions? I'm not seeing any. We appreciate your testimony here today. And next we'll hear from Susan Snyder. You may proceed.
Yes, thank you very much, Senator Carney and members of the Joint Judiciary Committee. I'm here to give testimony in favor of LD 344. My name is Susan Snyder and I live in Brooklyn, Maine. On July 11th, 2018, Renee Henneberry Clark of Hamden, Maine was murdered by her brother-in-law. Renee was denied a protective order because her murderer wasn't her husband or a household member. So much for equal protection. This is why we need LD 344. A constitutionally guaranteed amendment specifically prohibiting discrimination based on sex would have ensured Renee the protective order that might have saved her life. An equal rights amendment would provide constitutional standards against sex discrimination for Maine's judicial and law enforcement systems. It would deter those who previously may have failed to apply or enforce existing laws. Almost half the homicides in Maine continue to be caused by domestic violence. 82% of domestic violence is committed against women. 65% of all murder-suicides involve an intimate partner. 96% of the victims of these crimes are female. mothers, daughters, grandmothers, infant baby girls. These are the victims. Many will argue that the Equal Protection Clause in the Maine Constitution, along with the 14th Amendment in the US Constitution, provide adequate legal protection against discrimination based on sex. While Maine's equal protection verbiage closely mirrors the 14th Amendment Equal Protection Clause, both Maine's Constitution and the United States Constitution fail to include language that specifically references discrimination based on sex. Both documents have failed time and again in the courts to provide equal protection for women, especially in cases of domestic violence and sexual violence. So what is the Violence Against Women Act, which is VAWA? Acts and other legislation not codified by the US Constitution are vulnerable to defunding, expiration, or even replacement by Congress, in addition to legal challenges. In 2000, the US Supreme Court in United States v. Morrison declared the civil rights remedy under VAWA to be unconstitutional. VAWA failed to protect the rape victim in this case. The majority rejected the civil rights remedy on the grounds that because domestic violence crimes were not themselves, quote unquote, economic in nature, Congress could not claim power over the Commerce Clause, under which VAWA is regulated. VAWA is also subject to reauthorization every 5 years by Congress, which leaves it vulnerable to the biases and politics of a partisan administration or one hostile to the protection of women's rights. Currently, VAWA is up for reauthorization and necessary funding for 2022 through 2026. The House passed a reauthorization bill in 2021 with a bipartisan vote. The Senate, however, has delayed its final vote on a resolution. In the current absence of an equal rights amendment to the US Constitution, Maine needs to ratify its own equal rights amendment. A constitutional amendment would provide the strongest protection and full weight of the law against discrimination based on sex. Maine voted in favor of an equal rights amendment to the US Constitution in 1974. We need to vindicate this vote by passing LD 344. I respectfully ask members of this committee to allow the people of Maine to decide if they want equality under the law. We, the people of Maine, deserve the right to vote on equal rights for all in our state. Thank you very much.
Thank you, Susan Snyder. Committee members, any questions for Susan Snyder? Not seeing any. We appreciate your testimony today.
Thank you.
Next, we'll hear from Quinn Gormley. Quinn, you may begin.
Thank you. Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. My name is Quinn Gormley, and I serve as the Executive Director of the Maine Transgender Network, Maine's sole organization specifically representing the needs and interests of transgender Mainers and those who love us. I am here today to support the passage of LD 344, but recommend to be amended to explicitly include the terms sexual orientation and gender identity. In the century of advocacy since the ERA was first conceived, our country has made significant progress towards gender equity and eliminating sexism. The ERA is a necessary next step in that work. That same century saw great strides towards the full inclusion of LGBTQ people in all aspects of our society. Indeed, efforts to improve the lives of women and girls often go hand in hand with efforts to promote the inclusion of people of marginalized genders and sexualities. Both rigorous academic research and lived expertise have found that homophobia and transphobia are ultimately just extensions of sexism, seeking to enforce stereotypical and limiting expectations of assigned sex on people, often through violence and discrimination. Though sex is biological, sexism isn't. It's cultural and extends beyond biology to our expectations and perceptions of gender. If we are to fully uproot sexism in our society, we must challenge homophobia and transphobia, specifically through explicit protections in our laws, wherever and whenever we address sexism. Mainers have consistently supported LGBTQ inclusion at the ballot box and their vocal support of affirming legislation. It is our opinion that the addition of sexual orientation and gender identity to this language will ensure that the inclusive intent of this effort is best and most explicitly achieved, while also honoring the clearly identified values of Maine voters. Thank you for your time and thoughtful consideration.
I was muted. My apologies. Thank you for your testimony, Quinn Gormley. Committee members, any questions? I am not seeing any. Appreciate you being here today. And next we will hear from Natalie Emerson. But Natalie, before you begin, just want to ask anybody who is part of the attendee portion of the meeting who would like to testify in support of LD 344 to please raise your hand and keep it up. And if you get a message saying somebody's trying to bring you onto the panel, please say yes, because I'm having a little trouble bringing people over. Thank you very much. And with that, Natalie, you may begin.
Thank you. Good afternoon, Senator Carney and members of the Judiciary Committee. My name is Natalie Emerson. My pronouns are she, her, and I'm a 16-year-old from Morse High School. I'm here today representing WE, a women's empowerment group at Morse made up of young women from our school. I'm here to speak in support of LD 344, the inclusion of an equal rights amendment prohibiting sex-based discrimination to the state constitution. As a young woman in today's world, it seems incredible to me that we are even discussing this amendment, that we are even debating whether or not someone's sex determines their value. However, because we are, there are a few things I'd like to say. As young women in our community, not one of us has ever felt less able or less important than our male counterparts. Think of the women in your lives, and for those of you who identify as women, have you ever considered your or their ideas and accomplishments to be less valuable than those of male peers? We believe that your daughters are just as valuable as your sons, that your granddaughter's contributions will hold just as much weight as your grandsons. We believe that no one is better than anyone else simply because of their sex, whether they be male or female. I think we can all see the unfairness in the fact that women make only 80% of what a man makes, or that I and the young women of my generation can legally be considered less important than our male peers simply because we are women. This bill is solely a moral question of equal rights. You either believe in them or you do not, and your vote will represent that belief. You have sworn to uphold the values of this state and serve its constitution, a constitution founded on the values of equality and equal opportunity, which states, all people are born equally free and independent. Maine ratified the federal version of this amendment in the 1970s, at the same time as Title IX, a time when women's rights were just coming to fruition, when it was still socially acceptable for women to be treated as inferior to men. Yet now, 52 years later, we are still struggling to pass it at a state level. We are still unable to agree that women deserve equal rights. After hearing testimony, I would also like to add that those who fight for equal rights must truly believe in equal rights. It was mentioned that the bill would require women to participate in the draft. And while as a young woman, this scares me, I understand that equal rights does not mean women get to pick and choose which laws they like and don't. Men have also faced sex-based discrimination, and we must recognize that. You have been given the opportunity to prohibit sex-based discrimination in this state, the opportunity to move us one step further towards the ideals of our nation and our Constitution. I ask that you consider that when you cast your vote. Thank you.
Thank you very much for your testimony, Natalie Emerson. Committee members, any questions? I'm not seeing any. We appreciate you being here today.
Thank you.
Next, we'll hear from Leo Delicata.
Thank you, Senator Carney. Senator Carney and members of the Joint Standing Committee on Judiciary. My name is Leo Delicata, and I'm a lawyer with Legal Services for the Elderly, and I'm here to speak in favor of LD 344. I don't want to repeat what people have said before me, and my testimony is in your hands. But I would like to make one fairly brief statement. The Constitution, our Maine Constitution, is really the highest expression of our rule of law. And our rule of law is the structural underpinning of our entire democratic system of government. So perhaps in the long run, this discussion is really about how recognizing women as equal under the rule of law is essential to defining our culture and who we are as Maine and as Maine citizens and as Americans. Some may think that making this addition would be just a symbolic gesture, but I say symbols have always been powerful expressions of actual and also aspirational realities, especially now when it feels like we're so divided. A symbol of our fundamental equality as human beings would be an important reminder of how not so different we really are. Passage of this resolution and acceptance by a vote of the people of Maine would affirm our belief that discrimination based on sex should not be tolerated. Maybe more importantly, it would be an enormous statement that we stand on the side of justice for all. And that in itself would be evidence that despite our differences, we in Maine have at least one core belief to build upon with our neighbors. So please give Maine people a chance to take this step forward. Thank you for your attention, and I hope that you vote to pass. Thank you.
Thank you very much, Leo Delicata. Committee members, any questions? Not seeing any. We appreciate your testimony today.
Thank you.
And next we'll hear from Posey Cowan. Good afternoon, and you can begin when you're ready.
Good afternoon. Can you hear me?
We can hear you fine.
Good. Senator Carney and members of the Judiciary Committee. My name is Posey Cowan and I live in Brooksville. I am the fourth generation of women in my family who have fought for equal rights. My great-grandmother started working with Alice Paul in 1923. That is almost 100 years ago. I don't want my daughters or my granddaughters to be fighting the same battle 50 or 80 years from now. I'm also a founder of Equal Rights Maine. I'm just trying to start my watch so I know where I am in time. Our mission is to advocate for the Equal Rights Amendment in Maine and also to educate Mainers why it's so necessary. Most people think that there already is an Equal Rights Amendment in the US Constitution. That's not true. That means that women are not protected from discrimination based on sex. And it's all the more reason that Maine joined the 26 other states. Please read the op-ed in today's press, Maine Voices, without state ERA, women face unfair barriers to equality. It was written by one of the founders of Equal Rights Maine. One of the stumbling blocks, everybody has sort of done a lot of history and reasons and very strong arguments. I'm trying to understand why there isn't support, why people are opposing it. And I think one of the stumbling blocks is the issue of abortion. And I think it's important to separate that and be very clear why. Abortion is a personal, private healthcare issue. Women's equality is a human rights issue. So let's work together on the issue of abortion. Let's look at the root causes of abortion. Let's have a state that is successful in reducing the need for abortion. So what the Maine ERA would provide is the legal backing, as everybody said, on gender pay, sexual harassment, and domestic violence. So a no vote suggests to me that you don't think that women should have the same legal constitutional rights. A no vote suggests to me that it's okay that women are paid less than men for equal work. A no vote suggests to me that it's okay that men who sexually harass and sexually assault women receive little or no consequences often. A no vote suggests to me that it's okay with you that not more is being done to address the prevalence of domestic violence in Maine, and that the sentences are often much less than it is for a murder by a stranger. A no vote suggests to me that the chances your daughter and granddaughters will be discriminated because of sex discrimination, or that they will be sexually assaulted, are high if nothing is done about it. A no vote means you don't believe Mainers should be able to vote on this very important issue. A yes vote means you want legal equality for women specifically written into the Maine Constitution. And a yes vote means you want your wife, your daughters, and your granddaughters to have full legal protection in the Maine Constitution. Thank you.
Thank you for your testimony. Committee members, any questions for Posey Cowan? Not seeing any. Thank you so much for testifying before the committee today. And next we'll hear from Ann Schenk. Ann, you may proceed.
Thank you, Chairman Carney and the members of the Standing Committee on the Judiciary. My name is Ann Schenk and I'm a resident of South Portland. I'm here today as a volunteer on behalf of the League of Women Voters of Maine. I'm testifying in support of LD 344. The League of Women Voters is a nonpartisan political organization that's been working for over 100 years to encourage informed and active participation in government, to increase understanding of major public policy issues, and to influence public policy through education and advocacy. We never support or oppose any political party or candidate. I'm proud to share that I've just celebrated my 80th birthday and look back on my life with a certain amount of sadness to realize that the very first time I testified on the Equal Rights Amendment was 50 years ago. That's a long time to wait for an Equal Rights Amendment to become part of our state and federal constitutions. I remember the very first speech I gave in support of the Equal Rights Amendment. I mentioned the old trick math problem of which is heavier, a pound of lead or a pound of feathers. Clearly, they're not the same, and that is the point. It's not whether they should be treated the same, but rather they should be given equal weight. It means accepting our differences, but treating them equally. When the federal ERA was first sent to the states for ratification in 1972, I was living in Pennsylvania, which ratified the federal ERA and included a state ERA in their constitution. After passage, a task force examined every statute in the state for reference to gender or disparate treatment between men and women. In the end, a package of more than 200 bills was sent to the legislature and passed. That process demonstrated to me the strength of having equality embedded in the Constitution. I'd like to share an example. Originally, under Pennsylvania bankruptcy law, the tools of a carpenter, almost always a man, were not allowed to be confiscated because he needed those tools to exercise his trade and provide him a way out of bankruptcy. A woman, however, could lose her sewing machine because she was just doing it to clothe her family. And under the ERA, the sewing machine was treated the same as the carpenter's tools. You may be saying to yourself, well, we've already done that. And in many cases, you have. Over the course of the last 50 years, many state and federal laws have been enacted that are based on the principle of equality, despite the lack of a constitutional mandate. But those laws can be overturned by the stroke of a pen or nibbled away at by any legislature that is inclined to turn back the clock on equality. Equality is a bedrock principle in today's world, and our Constitution should reflect that. It should be the standard against all legislation and court cases are weighed. Fully protected equality from erosion in all three branches is guaranteed only by a constitutional amendment. The League of Women Voters strongly supports this resolution, and we urge the committee to vote ought to pass to demonstrate our commitment to equality for all people who live, work, and love the state of Maine. Thank you very much.
Thank you for your testimony, Ann Schenk. Let me just, I think that we need to look into whether there's a concern about recording here. Oops.
I will say that was accidentally me. I accidentally clicked the wrong button for something. I'm so sorry about that.
Okay, thank you. Let me just check in with our committee clerk. Soupy, are we still recording and live streaming okay?
Yes, we are, Madam Chair.
Okay, great. Thank you.
You're
All
welcome.
right, back to where we were. Ann Shink, thank you so much for providing testimony today before the committee. And we appreciate you being here. And next we'll hear from Samuel Selby. And Samuel, if you could activate your camera and proceed, we'd appreciate it. Samuel Selby, are you able to provide testimony right now? Okay, there may be some confusion. Oh, here we go.
Hey, sorry, my fault. Hello to the committee. Thanks for letting me speak today. I'm Sam Selby, a resident of Wiscasset, a retired teacher, naval officer, husband, father, granddad, who of wonderful women, and who'd like to add support, male support to LD 344. Because of our founding fathers failing to include the rights of women along with in the indigenous and the poor when they wrote the US Constitution, we remain the only modern developed nation without constitutional guarantees for women. In 1820, when the Maine Constitution was crafted, women's rights were again neglected. This amendment will correct the glaringly outdated oversights. And because the US Constitution mostly ignores the right of women, and it's all the more important to ensure that those rights are guaranteed at the state level. Many Republicans in the Maine House oppose LD 344. This minority in Augusta should be encouraged to rethink this opposition to an amendment favored by a majority of Mainers. Allowing people to vote on this amendment is vitally important to all the men and women of Maine. Thank you.
Thank you very much. Committee members, any questions for Samuel Selby? Not seeing any. We appreciate your testimony today.
Thank you.
And Ann Gass, you're next. Would you like to proceed with your testimony?
Yes, thank you. Senator Carney and distinguished members of the Judiciary Committee, I'm here to speak on behalf of Maine's Permanent Commission on the Status of Women in strong support of LD 344. For those who don't know, Maine's Permanent Commission on the Status of Women is an unfunded, nonpartisan, independent advisory board charged by statute with advising Maine policymakers, including the legislature and the governor. As we stated in our 2020 report, we can point with pride to many significant gains for women achieved over Maine's history. We know that when women are empowered, enabled, and have the freedoms and rights to achieve our full potential, then all Maine people benefit. Unfortunately, our research demonstrates that Maine women still disproportionately struggle for economic security, experience domestic and sexual violence, and lack access to health care. And women of color trail white women in many categories, from pay equity to achieving high-level jobs, appointments, or elected office. Permanent Commission on the Status of Women members are united in believing that in 2022, it is finally time for women to be recognized as equal under Maine's foundational document, our Constitution. The Maine ERA will prohibit discrimination on the basis of sex. It will protect women from discrimination in the workplace, especially around equal pay, as well as in critical areas such as domestic violence and access to health care. This bill is an important step forward to protect all self-identified women. The Commission further recommends that in the working session, the committee revise the bill to use more inclusive language focusing on gender identity and expression rather than just sex. The COVID-19 pandemic has disrupted everyone's lives, but it has imposed a particular burden on women. Women have disproportionately left the workplace to care for school-aged children, resulting in financial hardship and jeopardizing their career advancement and future earning power. Those women remaining in the workforce are disproportionately represented in frontline occupations such as nursing, teaching, child and elder care, and in the retail and hospitality sectors. Without women, we could not have coped with the pandemic as well as we have, and our economy, our society would be at a standstill. Now more than ever, women deserve equal protection under Maine's Constitution. A majority of women support equality for women. I mean, a majority of Maine people support equality for women. It's time to let the people decide. On a personal note, I am the great-granddaughter of Florence Brooks Whitehouse and the author of 2 books on suffrage history. As Representative Babbage noted, Florence testified in front of this committee multiple times in support of voting rights for women. She later went on to work with Alice Paul in the federal ERA. I'm just dumbfounded that we're still talking about equal rights for women nearly 100 years later. There's no doubt in my mind that if she were here today, she would urge this committee to support LD 344. Please join the Permanent Commission and Standing with Maine Women in voting to support LD 344. Thank you, and I'm happy to answer any questions.
Thank you very much. Committee members, any questions for Ann Gass? I'm not seeing any. We appreciate you providing testimony here today.
Thank you.
And next we'll hear from Iceland Bratz. Go ahead, please.
Hi, thank you all so much for hearing my testimony. My name is Iceland Bratz. I'm a 17-year-old senior at Camden Hills Regional High School, and I'm speaking in support of LD 344. I'm going to take my time to tell you all a story. The story is of a young girl who is the product of her generation, a girl who grew up in social discourse, whose childhood was marked by terrorist attacks, school shootings, climate change, violence against women, police brutality, and bipartisan conflict. A girl who at the age of 10 was pushed to attend her first Women's March to fight for her rights, for her voice, and for her future. She watches the news and sees another woman discriminated against, whether it be inequality, violence, sexual harassment, workplace discrimination, healthcare discrimination, or a lack of bodily autonomy. She watches as those who look like her face challenges simply because of their identity. She grew up listening to the story of her great-grandmother who was unable to follow her dreams as a woman in the workforce, of her grandmother who drank herself to death, all because she lived in a world where she was not given the space to be equal in her home, a world where equality was not hers to demand. She watches as her aunt struggled to make the same amount of money as her male counterparts despite her having a higher job. She watches her mother struggle too, her single mother who feels the weight of the expectation to raise 2 children on her own, who has been taught to prioritize motherhood over herself, who has experienced discrimination for so long that the girl has to remind her of what it is. The girl is afraid to walk at night in the dark, afraid to be around men at work, afraid to get pregnant, afraid she'll never get paid enough or seen as equal enough to follow her dreams, afraid to develop a health condition that might be made less by doctors who have biases because she has a uterus, afraid because she feels she can't do anything about it in a system that does not guarantee her equality, where protective laws can easily be repealed. She's been told that she has equal rights, that the vote was given in 1920, and yet at work, school, and home, she feels lesser. She feels the fears of her mother, grandmother, and great-grandmother. That is her reality. That girl is me and so many other women of my generation who question why a country that claims to be one of the best does not have equal rights in the Constitution, why the state they live in does not stand against sex discrimination in their laws. My generation has learned far quicker in the power of our voice, that the power that we must stand up for what we believe in, to fight for a country where we can be proud to call ourselves American. Now we use that voice to tell you to pass this legislation so we can take steps to create a better future for Mainers of any gender identity. Ask yourselves, if Maine can ratify the federal ERA, why shouldn't it provide those same protections for the girls in the stories? Thank you.
Thank you very much for your testimony. Let's see if committee members have any questions for you. Are there any questions, committee members? Not seeing any. We appreciate you being here today.
Thank you.
And next we'll hear from Charlie Hartman. You may proceed with your testimony. Hang on one second. Do you need help?
I am sorry, I am not Charlie Hartman.
Okay.
My friend Charlie Hartman had also sent me the link to make good and sure that I made it here. And I didn't realize it logged me in under her.
Okay. Can you, first of all, are you here to testify in support of
Yes.
LD 344? Could you please introduce yourself and then we will take your testimony.
Sorry about that. My name is Larissa Batchelder. And I have wrote in my testimony as well. I really didn't think that women's rights had to be a topic. I mean, we all know we're supposed to be equal. And then there's the conversation about equal but different. Because clearly, yes, we're different, but we can still be equal. I believe that equality amongst the sexes was an unalienable right claimed by those before me. But it's 2022. And for sure, gender, even though it should not be a topic that we have to discuss, it is. I believe those making decisions based on genitalia were from times before, but I'm in the workforce and I have healthcare. And I know that there's a difference from my male counterparts. I've learned not only is sexism alive and well, but it goes both ways. Stereotypes that a man or a woman, what they can and cannot do. We're a community of people and we have flaws. We learned early in our development that baby girls have baby dolls and baby boys have trucks. And whether we want to admit it or not, no matter how much we say we're not sexist, it's ingrained in us. Somewhere in our professional lives and our personal lives, we're making a subconscious choice everywhere, stating that I cannot read and speak at the same time. So I'm just going to stop reading my paperwork so that I can actually speak and you can hear me. Nobody wants to say that they're sexist or that they're the cause of something sexist happening. So everybody who's saying, you know, why should we have to have this in our Constitution if it's a done deal? Anybody who had the thoughts that I had before might stop and think, how many times have we seen a job that requires muscle and we immediately think we need a man? Or we see clothing that's effeminate and we immediately think, well, that's definitely for women. We're cutting it down that line. So as humans and lawmakers, could we also make those mistakes when we're voting? Could we also make those mistakes in making laws? Yeah, we could. And I think that I think that having this in our Constitution is going to help us going forward, making laws so that we don't fall back on our humanness to cut us into categories anymore. Thank you.
Thank you very much for your testimony. And committee members, any questions? And it's Larissa Batchelder, right?
Yes.
Okay, I hope I spelled your name correctly when I renamed you.
Oh, you did. You spelled it correctly. Thank you. And I apologize for being a little frazzled. I'm a working woman trying to work and speak and read at the same time.
That's okay. Committee members, any questions for Larissa Batchelder? I'm not seeing any. Thank you so much for being here today. And next we will hear from Megan Sway.
Good afternoon, Senator Carney, members of the Judiciary Committee. It's great to see all of you. Happy New Year. My name is Megan Sway, and I'm Policy Director at the ACLU of Maine. We're a statewide organization committed to advancing and preserving civil rights and civil liberties guaranteed by the Maine and US constitutions. On behalf of our members, I'm here today to support LD 344. If approved by the legislature, this resolution would give Maine voters a chance to add the Equal Rights Amendment to the state constitution. This amendment would provide, for the first time, explicit constitutional recognition of the fundamental notion of gender equality, a principle that has been a cornerstone of our nation's laws and policies for half a century. This legislature and Maine's courts have long held that existing constitutional and statutory provisions protect against gender discrimination, and in particular have rejected policies or practices that perpetuate gender stereotypes. Yet the constitutional amendment proposed by this resolution would provide women and LGBTQ individuals with a new tool to challenge discrimination they face. It would ensure courts analyze discriminatory laws, policies, and practices under a more exacting level of judicial scrutiny. Despite significant gains in courts and legislatures, women and LGBTQ people still face myriad barriers to equal participation in civic and economic life. Women working full-time and year-round on average are paid only 80 cents for every dollar paid to their male counterparts, and the disparity for women of color is even more severe. Gender-based violence and harassment remain rampant in schools, workplaces, housing, and custodial settings. Crucially, an Equal Rights Amendment could provide an additional layer of protection against restrictions on abortion, contraception, and other forms of reproductive health care. For over half a century, the Supreme Court has recognized that fundamental decisions about whether or when to have a child are protected under the 14th Amendment principles of liberty, privacy, and equality. The Supreme Court has emphasized that the Constitution prohibits the state from insisting upon its own version of the woman's role as a mother, and recognized that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The Equal Rights Amendment could be an additional tool against the erosion of reproductive freedom and the stereotypes restrictions on reproductive freedom reflect in gender. An Equal Rights Amendment could also lay the groundwork to establish critical avenues of redress to individuals facing sexual harassment and gender-based violence. As the outpouring of stories in the Me Too era has made clear, sexual harassment and assault remain pervasive throughout all corners of American life. Limitations in the existing legal landscape leave many individuals, but particularly women, LGBTQ people, people of color, immigrants, people with disabilities, and low-income people, vulnerable to sexual violence. Some of the most marginalized workers in Maine have lost their jobs after complaining about sexual harassment. An Equal Rights Amendment has the potential to recognize gender-based violence as a form of gender discrimination and remove barriers, and we ask you to vote ought to pass. Thank you.
Thank you very much, Megan Sway. Committee members, any questions? I'm not seeing any. Thank you for your testimony today.
Thank you.
And next we have Dusty Holman Sprague, and you may proceed with your testimony.
Hello, good afternoon. I am Dusty Holman Sprague from the Maine Women's Lobby. It's so nice to be back again with you all in 2022. For over 40 years, the lobby has advocated for policy that increases the health, wellness, safety, and economic security of Maine women and girls. And we are in happy and delighted support of Representative Reckitt's resolution today, and thank her for her tireless work on behalf of this issue. First, I want to note, as others have mentioned, that we fully support expanding the protections in this bill to cover the full range of Mainers who experience discrimination and harm based on gender. The Supreme Court has definitively concluded that sex-based protections extend to sexual orientation and gender identity, and the Maine Human Rights Act offers these protections. Our own Constitution should do no less. As others have said, the Constitution is one of our most sacred founding documents, and Maine has deeply held beliefs regarding equality and protection from discrimination. Our Human Rights Act is a national model, but 200 years into our state history, we are still silent in the Constitution on guaranteeing equality. We know women are more likely to live in poverty. We know women still make less than men. That is particularly true for women of color. We know women are more likely to experience sexual harassment and violence, to experience discrimination in the workplace, are less represented in government. And we know that enshrining this value in the Constitution is the best way to ensure that we protect people based on gender. In Maine, it will not solve all of these problems, but it will address places where the Human Rights Act is silent. It will help move forward pay equity. It will offer clarifying language based on gender-based discrimination that is not specifically about sex. And it will create additional avenues for redress. I worked for over a decade in sexual assault response, and one of the key things I learned was that one size does not fit all when it comes to experiences for survivors and their potential pathways for justice. Real justice and equity is achieved through many means, and it's time that we make this one of those means. I hope that you will agree that we should send this out to the Maine voters, and I hope to vote on it myself in the fall. So thank you for your time today and attention to this. I appreciate you.
Thank you very much for your testimony. Committee members, any questions for Dusty Holman Sprague? I am not seeing any. We appreciate you being before the committee today. And I think that takes care of, we've heard from everyone who raised their hand to speak in support of LD 344. So now I will turn to the attendee space and ask anyone who is here to speak in opposition to LD 344 to please raise your hand. And again, keep it raised until after you've been brought onto the panel. And it looks like we have a few people who wish to speak in opposition. So we'll start with Michael McClellan. And to those who have their hands raised, I'm going to just move you all onto the panel at this point. And then I'll call on you to testify.
Unmute.
Okay, and so Michael McClellan, if you could begin first, thank you.
Thank you all for being here. Senator Carney and members of the Committee on Judiciary. I am Mike McClellan, the Policy Director of the Christian Civic League of Maine. The Christian Civic League of Maine envisions a state and nation where God is honored, religious freedom flourishes, families thrive, and life is cherished. So we believe in a biblical approach to life and into governance as well. And I'm here to testify against LD 344. I've got some testimony I gave you folks, and I'm not going to get into most of it, but I want to read a story. I was actually a state rep back in 2010, and I was placed on the Education and Cultural Affairs Committee. And I had the experience of another bill that was seeking to change culture. Rep. Terry Morrison of South Portland and the ACL of Maine sought to pass a law that was going to stop bullying. From my perspective, I was seen as the key vote on that committee to make it happen on the level of the committee. And I had misgivings on the draft legislation. But ultimately, I worked with the CCL of Maine, ACLU Executive Director Shenna Bellows, and many others, and we crafted a bill that passed the committee unanimously. This is probably the only time I ever saw this in my 6 years, but the room erupted with young kids cheering as we passed the bill. And the chair of the committee, Senator Langley, allowed that cheering to occur. When it was done, I asked if I could speak, and he allowed me to. And I pointed out, you know, congratulations, but they needed to know that cultural change only occurs with people, with people's hearts. You can't pass laws that change the culture. And so now 10 years later, as I'm a lobbyist and I drive to Augusta quite often, I can't describe to you the sadness in my bones. How often listening to the news, I hear about bullying cases. And I think, but we passed the law. So even if I accepted the sponsor's premise of LD 344, I probably would not see it as a resolution. In my remaining time, I'm going to pass on the rest of my testimony and just kind of give some observations from the testimony I've listened to for 3 hours today. Myself and people behind me, there's been a lot of labels about who we are today. Pretty interesting. I wrote them all down and I decided not to read them to you. I want to say I simply respect the sponsor and I just disagree with her on this premise. My research is, and the Christian Civic League's research has nationally shown that bills like this added to state constitutions, add the abortion rights laws, It adds abortion funding laws. And I know I don't have time to speak to it. Others have a little bit. They add things that are anti-women. I want to point out, if you think about it today, how amazing has this meeting been? We've seen a governor, a secretary of state. We've seen the lead of the Maine Supreme Court, 8 of 14 of you, and let's see who else, and many other accomplished women are all participating in this discussion. I think that's an amazing thing and good for Maine. I also think the law is clear. And I think that it's important to say that Christian Civic League and I believe that we are all equal, but we're also all different and unique. And that's something to celebrate. So just to close, I'll suggest to you, check out Justice Bader. She wrote a report with somebody else called Sex Bias in the US Code many years ago. And it makes the case for ERA. And I think just as much, it makes my case against ERA. So I think while we need to continue to strive to change people's hearts, I don't think we can do it with laws. So I think the sponsor is very well intentioned and I respect her highly and I think she's accomplished. But I think ERA would not be the remedy so many have testified for today. And just know that we're out here praying for you guys, for the work you're doing, and we just thank you for your service.
Thank you very much, Michael McClellan. Committee members, are there any questions? And I see we have a question. Go ahead, Representative Libby.
Oh.
Thank you. Thank you for being here today, Mr. McClellan. My question would be, we have heard a lot today about all of the possible positive impacts of passing this bill. And you mentioned that the changes and what would be codified regarding abortion. Can you please expand on that? Because I need to clarify that connection.
Okay, and I'm not going to verbalize this very well, but there, and I think it's actually in my report if you read it, and probably some more that'll come, that we have seen in states where legislation like this has passed, and I think right away New Mexico and Connecticut come to mind. After this was put into the Constitution, the state courts saw that for a lot of reasons that the rights of women to have an abortion were assured, that there was no debate in it. And I do think it's in my testimony if you read deep into it.
Thank you.
Sure.
Any other questions, committee members? Not seeing any. Thank you very much for your testimony today. And you had mentioned that somebody else was looking for a link and was trying to provide testimony. I don't see any indication that that person has signed in under your name or any other name. So if you could.
Can I say his name out loud so you can find him, or you can't find him that way?
I thought you said his last name was Janelle.
Janelle, yeah, John.
Okay,
and he might be on my link. He said he applied at 11 o'clock this morning, and he's never done this before, which is awesome that he's doing this. And he said he never got an email, and he tried to reach you folks, and obviously you're busy. So
okay, well you can share your link with him, and
I did actually. I don't know how that works, but I did send it to him, and he said he was in. He said he could see.
Okay. Thank you. I'll see if I can find him. Thank you very much.
Okay, thanks. I'll tell him to look for you.
All righty.
Thank you.
And
God bless you guys.
And Abigail Beal, you may proceed with your testimony.
Senator Carney, Representative Harnett, and members of the Maine Committee on Judiciary. My name is Abigail Beal of Cherryfield, Maine. I appreciate the opportunity to testify here today. As a citizen and as a Christian, I stand in opposition of LD 344, resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual, which was submitted by Representative Reckitt. I believe we must consider the fact that our U.S. Constitution already grants sufficient protection and promise of equality to all people through Section 1 of the 14th Amendment, and the U.S. Supreme Court has already previously applied the 14th Amendment to women's issues. The Declaration of Independence also plainly recognizes that all are created equal and have been given certain unalienable rights by our Creator. Furthermore, there are countless other laws already in place covering practically all the bases, from employment and equal pay to education and many other areas of life. The truth is that the ERA will not give women any more rights than they already have, and if passed, it will harm and endanger women and their children in incredibly significant ways. While appearing to promote justice and equality, in truth, this proposition seeks to erase differences between men and women. The Bible plainly states in Genesis 1:27, "So God created man in his own image, and the image of God created he him. Male and female created he them." I urge you to stand against the tide of immorality that seeks to destroy God's order in family and gender distinctions. If passed, the ERA will be used to overturn all restrictions on abortion. This absolutely breaks the 7th commandment, which tells us, "Thou shalt not kill." It also violates the before stated founding documents, recognizing that all people have the God-given right to life and liberty. Today, we have more than sufficient evidence to prove that life begins at conception, and that unborn children are indeed living, growing human beings. Therefore, by allowing abortion, we are causing children to die en masse across our nation, to the tune of millions of children missing from our society today. I believe we have a responsibility to stand up against this evil. I would like to take this opportunity to remind you that as lawmakers, you are responsible before God for the decisions you make. Not only will these decisions impact us as citizens here and now, but they will also affect the futures of our families for generations to come. Where is the future of America, if not in the family structure we are destroying? Where is the future of our nation, if not in the holy scriptures we are shunning? And where is the future of our country, if not in the Constitution we are trampling? I urge you, in the name of righteousness, justice, and truth, to boldly stand up in opposition to LD 344. Thank you for your time and attention.
Thank you for your testimony. Committee members, any questions for Abigail Beal? Not seeing any. Appreciate you being here today. And lastly, we have Thomas Keith speaking in opposition to LD 344. You may proceed.
Thank you, Senator Carney and the esteemed members of the Judiciary Committee. My name is Thomas Keith, the policy analyst at the Christian Civic League of Maine. Today, I testify in opposition to LD 344 as it currently stands. We've heard much in this hearing about equality for women in general terms. This amendment, however, isn't just a vague affirmation of that truth. It has concrete implications that must be discussed. Yes, more needs to be done to address the concrete inequalities in this state, such as promotion discrimination or gender-based violence. But the worry is that this is going to do so much more than fix the problems caused by gender inequality. For example, it's going to override the statutory protections given to churches that, for religious reasons, only endorse male clergy. It will take everything sex segregated from school locker rooms to state prisons and make them, at least on its face, unconstitutional. It very well may enshrine abortion in the state constitution. Governor Mills told us earlier today to look at other states who have passed this. New Mexico and Pennsylvania, for example, passed unqualified equal rights amendments. Those unqualified amendments were used to force the people of those states to fund abortions. Now, does this mean that Maine shouldn't pass an equal rights amendment at all? No, it doesn't. But it means that it shouldn't pass equality without qualification. These invidious extensions do not occur in states that clearly qualify their equal rights amendments language, such as Rhode Island or New Jersey or Louisiana, states praised earlier by equal rights amendment supporters. If this committee is willing to clearly qualify the language of this amendment so that we know exactly what it does and what areas of the life of Maine citizens this extends into, then maybe we can all come together to support equal rights for women in this amendment as it is stated. Supporters of this amendment today have repeatedly called for a clear statement of the rights of women. I agree. Let freedom ring, but let it ring clearly. Reject this amendment as it currently stands so that when Maine voters are given the chance to vote for equality for women, they know exactly what that will mean. Thank you so much.
Thank you for your testimony. Committee members, any questions for Thomas Keith? I am not seeing any. We appreciate you being here today. And with that, I'll turn to the attendee portion of the meeting and ask if there's anybody who wishes to testify in opposition to LD 344 and you haven't already testified. Please raise your hand and leave it raised so I can bring you over to testify. And I'm seeing one person. And we'll be joined by Penny Morrill. And Penny Morrill, if you are able to, could you please activate your audio and video?
Can you hear me?
We can hear you, but we're not able to see you actually.
Oh, how do I do that? Let's see.
I might be able to ask you from
Video.
Oh, you got it? Okay, great. Thank you. Okay.
All right. Well, I've submitted my testimony for you to read and consider, but I'd like to address some things that concern me. Can you still hear me if I go off screen? I'm Senator Carney, Representative Harnett, and members of the Judiciary Committee. Thank you for the opportunity to appear before you today. I'm Penny Morrill, State Director of Concerned Women for America of Maine, speaking for Concerned Women for America Legislative Action Committee. Concerned Women for America is the largest public policy women's organization in the nation with hundreds of thousands of members across the country. CWA of Maine opposes LD 344 resolution proposing an amendment to the Constitution of Maine to explicitly prohibit discrimination based on the sex of an individual. I've submitted my written testimony for you to consider, but in addition, wish to make the following remarks based on what I've heard so far today, if I may. Why did the sponsor of this bill remark that she will keep bringing this issue up every session until it gets passed? That speaks to the need for the law introduced in this legislature in a previous session that would not allow a bill to be reintroduced until 5 years since its rejection. I also question the remark made to a committee member's request that she speak to the reasons why others oppose this bill. She said she doesn't know why. She stated in her opening statement that she wants to us to listen to hers and others' concerns regarding this bill. I request the same from her, that she listen to what we're saying. Obviously, that has not been the case, and she doesn't know why we oppose it. We've certainly laid it out from many citizens and organizations. We have seen nationally that this bill is about abortion rights, funding, and is actually anti-women in what they will lose with the RA. Legislative positions obligate members to listen, hear, and consider what we say to this and any other legislation. It is government of, for, and by we the people, and our representatives represent us. This bill has not passed every time we are saying no. Please keep that in mind as you deliberate this bill again, taking up time and valuable resources already decided many times over. And I'd like to say that Barbara Cray said that it says all men are created equal. And she said men and women, but the original said all men are created equal. And it was speaking of mankind. It wasn't to the exclusion of women. So thank you for taking my testimony today, and I'm happy to answer any questions. And if you want me to, I'll read my testimony that I submitted.
Thank you very much, Penny Morrill. Committee members, any questions for her? Not seeing any questions. We appreciate you being here today.
Thank you so much. Appreciate you all. And we are praying for you. We're the group that does the Encourage a Legislator, and we pray for each one of you and appreciate your service. Thank you.
Thank you for being here. And now I'll turn to the attendee part of the meeting and ask if there's anybody who wishes to speak neither for nor against LD 344. Please raise your electronic hand and keep it raised. And I'm not seeing any, so have all, okay, we do have one, neither for nor against. So just one moment. CL Hartman, you're visible now on the panel. Could you please activate your audio and video?
Can you hear me?
We can. Can you introduce yourself and tell us where you reside? And I also don't know whether you're speaking for, against, or neither for nor against. So if you could give that information as well.
I can. I am the real Charlie Hartman, and I sent the notice about this this hearing today to my friend Larissa Batchelder, and she used it to register. And even though I had already registered, she got taken as Charlie Hartman, and I got nothing. So I tried to register again under CL Hartman about, well, while she was talking, I did that. But I'm finally on, and I really am trying to testify in favor. And it's just taken me a lot to actually get connected.
Well, we're glad you're here, and you can go ahead with your testimony.
Thank you, Senator Carney. My name is Charlie Hartman. I live in Vassalboro, and I would like to testify in support of LD 344, proposing an amendment to the Constitution of Maine explicitly to prohibit discrimination based on the sex of an individual, the Maine Equal Rights Amendment. I'm amazed in 2022 that Maine still does not provide women equal rights. When I was a young woman getting paid getting paid half of what the man next to me got, I looked forward to the inevitable day when parity was accepted as common sense. The Maine human rights law, for example, is important and valuable, but inequity in Maine remains. I worked as a federal funds trader in a small company, successfully making my company millions of dollars. When I left the company, I was replaced by an inexperienced man who was given a starting salary more than 50% higher than my ending salary. He quickly became known as the man who cost the company millions of dollars. I asked my old boss why he was paying my inept replacement so much more than he had paid me. And he replied, "It's supply and demand. I don't have to pay you as much as a man because you can't earn any more anyplace else." That's what happens when women are generally allowed to be paid less. But pay equity does not cost companies money. It keeps competent employees on the staff. Dear legislators, what will you do when your granddaughter comes to you and says, "I love my job. It uses all of the experience and training I've gotten, and I've been able to do positive things for the company. But last week, a new man was hired to do the same job I do. He has none of my experience or training, but I found out he is getting paid much more than I am. Grandpa, this isn't right. You're in the legislature. Can't you help me?" Will you be able to say that you voted to eliminate pay inequity? LD 344 is long overdue, and I urge you to pass this bill. Thank you.
Thank you very much for your testimony, Charlie Hartman. Committee members, any questions? I'm not seeing any. We appreciate you being here today.
Finally.
We're glad you made it. And next we'll hear from Eve Jameson.
Yes, hi. I would like to testify in favor of the bill if I could, please. I'm sorry, I was waiting for my chance and I had to drive my son uptown, but I'm back, and again, my name is Eve Jameson of Boothbay. I am the mother of 6 children, 4 sons and 2 daughters. I urge you to join the 26 other states who have already added an equal rights amendment to their state's constitution so that women, who make up 51% of both our states and our nation's populations, have a permanent guarantee of equal rights. We now have a female governor and a female vice president. How is it that women are still seen as second-class citizens in the eyes of our state and federal constitutions? I want my daughters and my future granddaughters to live in a state and a country where crimes against women are treated as seriously as crimes against men. Currently in Maine, if someone steals a TV or something worth over $1,000, it's a felony offense, but beating one's wife or girlfriend to within an inch of her life is but a misdemeanor. It is outrageous to me that a man can strangle his wife, the mother of his 3 children, to death with his bare hands and still expect to be released from prison after a measly 7.5 years for good behavior, as was just the case in Madawaska. The time is now for women's lives and rights to be valued. Sorry. As equally as the men's in the eyes of both our state and federal constitutions. Please do the right thing and pass this ERA to the Maine state constitution. Thank you for your time and consideration.
Thank you for your testimony today. Committee members, any questions for Eve Jamieson? I'm not seeing any, and thanks for rejoining the meeting so that we could hear from you. And then I think we have one other person who is signed in as Michael McClellan, although I think we just lost him again. Mike McClellan, I think for a moment we had 2 of you signed in, and now we just have 1, and I'm just curious as to which one of you is signed in. Oh, I see. With the hand raised. Okay, we're going to solve this problem. Everybody give me 1 minute. All right, I am not sure what is happening with John Janelle and Mike McClellan. To members of the public who are listening or watching, there is a way to sign up on the Judiciary Committee webpage. And once you sign up to testify, you will get a unique link that is connected to your name and to your testimony. And if you can use that, it saves us a lot of time and confusion. But I do think that we have, sir, are you John Janelle?
Yes, I am. Thank you so much.
Okay, can you spell your name for me? Because I want to put your proper name into the.
My name is John, John, Janelle.
Thank you very much. Okay, and you can proceed with your testimony.
Thank you very much. Good afternoon, Senator Carney, Representative Harnett, and members of the Maine Committee on Judiciary. I am John Janelle, and I'm here to testify against LD 344 resolution. The ERA would give extensive new powers to the federal government that currently belong to the state. Section 2 of the ERA states that Congress shall have the power to enforce by appropriate legislation. Both men and women already have full claim to equal rights under the 5th and 14th Amendments. Laws already exist that prohibit sex discrimination. There are numerous laws in virtually in all areas of American life: employment, education, housing, public accommodations, and many more. The ERA could be interpreted as enshrining in our Constitution a right to taxpayer-funded abortions because under the ERA, there would be no difference between abortions and medically necessary procedures sought by men, so the state must pay for abortions under Medicaid. The courts would be empowered to define sex and equality of rights, which would grant special rights and legal rights to people on the basis of sexual orientation and gender identity, which would threaten religious liberty and conscience protections.
Will?
Jeopardizes private and privacy and safety. Traditional male and female bathrooms, locker rooms, hospital rooms, nursing homes, etc., would be nullified because under the ERA, men and women must be treated as indistinguishable. This would place on our young children at risk and seriously jeopardize privacy. This bill is not a solution. Implementation would cause chaos in our lives, in our culture, with a lot of law changes. And I thank you for your time and consideration on this matter.
Thank you very much. Committee members, any questions for John Janelle? I'm not seeing any. We appreciate you being here today.
Thank you very much.
And with that, have all who wish to speak on LD 344 been heard by the committee? If you wanted to speak and you have not had a chance, please raise your hand, your electronic hand. And I am not seeing any. I think we covered it, everyone. Thank you very much, committee members. And with that, we'll close the public hearing on LD 344. And committee members, I think that our committee clerk had one question she wanted to check in with everybody on. And then we will be done with our work for the day. Before we move on to that, Representative Reckett, I wanted to express thanks to you for bringing forward LD 344 and for all your work in support of equal rights for women throughout your long and successful career. We really appreciate the work you're doing. And Soupy, did you have a question for the committee?
Yes, please. I just wanted to see if it was possible to get the final votes on Thursday's vote. And I see Representative Hagan. I do not see Senator Keim. I do see Senator Keim. Yes, thank you. I need to see you and hear you. So if it's appropriate at this time, would you like to record your vote on, yes, your vote on that draft legislation question? And maybe it's more appropriate for Peggy, are you there, Peg, to come on and just give a better explanation than me.
Right. So the question, the committee had a presentation of the probate court study on Thursday, and the committee is authorized to report out legislation based on those recommendations. And so there was a vote as to whether the committee would support the drafting and the printing of a bill that would then come back to the Judiciary Committee for public hearing and work. So it's not really a vote on the merits of the bill, but the process of bringing the bill, making the bill get printed and then bringing it back to committee to then debate the merits of it.
Senator Keim, go ahead.
So if we're being asked to vote, then I would vote in opposition.
Representative Hagan?
Thank you very much. I would also do the same.
Thank you very much. Thank you. And for both Representative Hagan and Senator Keim, normally I would have sent you the vote sheet and then you would have contacted your presiding officers. But we've been told this year, as long as we have you on camera, I can see you, I can hear you, then it's appropriate to do that. And so from now on, once we have work sessions, what I'll do is continue the process that we did last year, which is I'll send you that evening, I'll send you an email. It will contain copies of the vote sheets. And then I'll ask you, if you would please, to contact your presiding officers, your respective presiding officer, and indicate how you want to vote. And that email will then be sent to me, and your vote will be recorded. Okay?
Very good.
Thank you. We're all set.
All right, committee members, any questions for Soupy about that process before we adjourn? Looks like everybody's got it. Okay, is there a motion? Janet, did you wish to speak to the committee?
Just really quickly, can you hear me? I'm on
Yes, we
Peggy's
can.
computer. I just ran into her office. I forgot to mention when you all were meeting about that vote, that ordinarily, if you're voting to implement the recommendations of a study and there are any questions as I draft legislation to implement those recommendations, that you would ordinarily be okay with me conferring with the chairs of the study to just make sure I'm drafting it the way they thought the study meant. And then of course, I would point everything out to you when the bill comes back for the hearing in the work session to let you know all of the decisions that were made. I just want to make sure that's what everybody else understood. That's what I understood, but I just want to be sure.
Everybody okay with that?
Great.
Thank you.
Looks like it is. Thank you, Janet, for crossing that T and dotting the I, I think. Peggy, is there anything else you'd like to speak with the committee about before we adjourn?
Actually, I would just real quick. We have a presentation tomorrow morning on the Criminal Records Review Committee and a bill to extend it. I'm hoping that you'll have an opportunity to ask questions about that report and what they went through. And then in the afternoon, we're going to do work sessions on two carryover bills. One is LD 233, which is Representative Harnet's bill on electronic access to confidential juror information. I'm hoping the judicial branch will have a little more information for you, but I'm not exactly sure. But the second one is LD 903, and that is Representative Moriarty's bill on an act to enact the Uniform Foreign Country Money Judgments Recognition Act. And we're incorporating the Canadian Money Judgment Act. And we've got some uniform law commissioner experts signed up who will be there in the afternoon. And there is a nice long amendment for you to look at in the portal. If you remember how to get to the electronic LD file. So you can either go from the Judiciary Committee page and find the LDs, and it's LD 903. If you're a masochist, you can go and find the date of the hearing, which was April 7th of 2021, and you can find the information that way. I will also email you. The judicial branch has a proposed amendment to what I had originally posted, and that is posted. It says it's the corrected version. And I will email that to you now as well, so you'll have access to it both ways. But that is what I'm hoping you'll be able to actually talk about tomorrow afternoon for LD 903.
And one other thing that we are hoping to address tomorrow afternoon is we've received a request from Criminal Justice and Public Safety to re-refer 1682 to them. That is a bill that is correcting something related to legislation that passed out of criminal justice in the first session of this legislature. And they would very much like to have that bill referred to them instead of to us so that they can complete that work.
Right.
And it seems very appropriate. And I believe that Senator Hagan and Representative Hagan, Senator Keim, Representative Hagan, and Representative Harnett are all in agreement. So we'll just present that to the committee for a re-referencing vote.
Just a quick tweaking of the numbers. It's LD 1862.
Oh, I wrote it down incorrectly. Thank you. Got my.
If you're looking it up, you're saying, what?
1862. Thank you.
1862, yeah.
Good year.
All right, everybody.
Thank you.
Anything else? I don't think so. Is there a motion to, oh, Peggy,
I-
anything else?
Actually, does anybody need a refresher on how to find the electronic LD files? No, you remember? Awesome, great, thank you.
All right, is there a motion to adjourn? No? Representative Poirier? And seconded by Senator Kime. All right, everybody, great work today. Thank you. See you
Nice
tomorrow.
job, Ian. Thank you.
All right.
Oh, sugar.
Representative Moriarty,
Yes.
did you want to take up Peggy's suggestion to, because that's different from what we did the other day.
Well, yeah, I've got messages, I guess, from both of you.
Well, she's off and she would have shared her computer, so unfortunately, I can get her back though if you want.
Well, you know, Supi, what you and I spoke midday.
Right.
And we worked our way through it. And I was working on bills that are coming up tomorrow and the day after and so forth. And it was perfect.
Okay, good.
I found all kinds of testimony there. However,
Okay.
then I went to today's calendar to check what might have come in by way of written testimony. And there was nothing posted whatsoever for either one of today's matters.
I've been told the new
And-
process is that it won't be done until the close of the public hearing. So things may start to populate now. We had two public you were asking about today's public hearings? You didn't see
Well,
any testimony?
again, not quite. Again,
Okay.
you and I went through it yesterday.
Right.
I could look and find posted testimony for tomorrow and the day after, where you told me it would be.
Okay.
Then yesterday, I went to see what was posted for today. It was empty for both matters.
Well, since we spoke, Peggy and I talked and she showed me another, actually better way to find what you were looking for. And I think that's
Well, it worked great, except
Oh.
that nothing was posted for today. Which didn't make any sense because, again, there was material posted for later on in the week.
I thought there was too. I was told that testimony on a public hearing, if they submit it online, will not be posted until after the end of the public hearing.
What
I
sense
know,
does-
but we saw it yesterday. That was what was
Yeah.
weird.
I don't know why that makes any sense.
Now, it may be because remember we entered the LD number in two different places. And it may be that the one that's in the middle, that newer process, I think it said something about help us with this new process. I think that is the one that didn't show any testimony. And remember, we went in on another way and it didn't have anything from 2022.
Well, yes, but I used
Oh, hi,
that
Chris.
new.
Well, I just wanted to, I didn't want to take all your time. I just wanted to know if, I mean, you can call me anytime and I can show you what Peggy showed me, which was a great way of getting, it was different from what we talked about.
Well, sure.
I probably wouldn't want to do it now. It's, you go to the, what's the easiest way to do it? And it may be what you all did last year, which you go to committee and then you go to committee documents. Does that sound familiar?
Yeah, I think so. I think so.
Okay. Well, I'm happy to talk to you at another time. I was hoping Peggy would be on because she could screen share with you, and anybody out there listening to us could. I mean, it's just a great way of getting information.
Okay.
Because I found out that when Peggy showed me how to do it, it showed that there were 91 at that, and that was yesterday. 91 submissions for this particular bill.
Well, I expected to see about that many, but again, it was blank.
And I think since then it's up to like over 150.
Oh, sure.
So it's climbing as we speak. So I'll let you go, and thank you for those that are listening. We have, sorry to,
Okay.
because we're all on this, we're having this discussion on YouTube, but that's okay.
I may give you a call in the morning then.
All righty, sounds good, Steve. Thank you. Have a
Okay,
good night.
good.
I'm ending
Thanks
the
then.
meeting.